Where it stops, no one knows. We're going
Well, good morning, everybody. Happy Friday, TGIF. Happy Friday the 13th, I should say. Welcome back to Criminality, or if this is your first time here, welcome to Criminality. Too bad Sleuthie's busy today. Well, she's not busy this morning. She's busy in a little while, so the court needs
I'm here for now. You can't get rid of me that quickly, that fast, that easily. We should have played that clip, that sound or whatever, where she's like, "You can't get rid of me, bitch." That's what we should have played.
So, to keep everybody up to date on where we are, so yesterday they did the oh my god, I can't even think. They did the conference and they got all the jury instructions together, did the conference, so on and so forth. There was a couple things that they were still pending, like needing to be redacted and the Commonwealth to go over. And
oh, wait a second. Ted Daniel just said, I just noticed there are 958 entries on the docket. That's 2 forests at least. There's almost 1,000 filings on this docket.
As of this morning with the new stuff, that's crazy. Yep. So, Bev told everybody all the attorneys to be there early today, get there at like 8:30 because the jury was going to be told to be there at 8:45. So then that way at 9 o'clock or even a little bit before, they'd be able to start their their closing arguments, and the jury would have a short lunch, and then they would be able to come back and deliberate. I don't know if she was doing jury instructions before or after lunch. She didn't really make that clear to me. Now we get to the court.
I saw the plan. I did not screenshot it. It's jury instructions. Oh, damn it. What's that lady's name? The lady reporter up there.
Sue?
No, the other one.
Jessica?
No, the other one.
Like
the one for an actual news something.
Oh, I don't watch actual news somethings.
And then Indiana Girl says after. My whole Christina Rex, yes, thank you.
Christina Rex. There you go. Thanks, Kat.
That's where I saw it. Closing. Here's the order for tomorrow. This was yesterday, obviously.
Okay.
1 hour, 15-minute closings by each side, defense, then Commonwealth. Quick and early lunch. I think yesterday she said 30 minutes, right?
Yep.
And then jury instructions. Then foreman selected by the judge. 6 alternate jurors randomly selected by the clerk. And then deliberations begin with 12 jurors. Now, I'm going to bring up that email. No, I'm not going to bring it up, but I'm going to mention it.
Okay.
So the clerk is the same person who emailed me.
Oh, okay.
So the fishiness just keeps getting higher and higher. So for everybody that doesn't know, the last sentence in my email from the clerk
because Sleuthie's been getting like all the exhibits like basically once a week, that she'll get like the batch of exhibits, and then so she's been in communication with the clerk so that he can continue to get them for her.
Yeah, so I emailed him and I was like, been a while. Like, I don't have 3/4 of the exhibits. And he said, blah, blah, blah. I sent you a bunch, blah, blah, blah. And then at the end, he said, also, we're putting the exhibits together for the jury, so they won't be available to at least after the verdict, comma, if there is one.
It was really weird. If there is one.
It stuck out to me as weird. I sent it to Teresa. I was like, oh my God, why would he say that? Like, full on tin hat.
I mean, that's I go as soon as I saw it, I was like, wait, what? So if there is one.
So my thing is that the clerk is the same person who's picking the alternates, and it's the same person who, remember I said I saw, so that that motion got denied where it said, your shorts are on backwards, I think. I'm 99% sure. Come here. Your shorts are backwards.
So the defense puts in the motion to have transparency for the jury alternates to be picked, essentially saying like, hey, we want, to know all the juror numbers are actually in there, number one, and that you guys haven't hand selected who's in there so that it automatically draws who you want it to. And then we want, to be able to see who you're actually reading the number to. We want to see the whole process as it unfolds. And she denied it and said no.
Because I think it was that doctor's trial or whatever with his wife or girlfriend, whatever it was, where we saw the clerk like spinning the old bingo spinny thing where the ball spits out, and that's how they picked the alternates. And I thought that's perfectly fair, and they do it in front of everyone and call the number out in front of everyone. I think that's perfectly fair. So we know they do it. I don't know why she's denying it. And my kid has grown out of his clothes just in the time he's been at my mother's.
Mav said, glad you said something, Sleuthie. My shorts are on backward. Mav never would have known had you not told him.
I was like, go turn them right side out. And he's like, no. I'm like, dude, you're not going to, like, what? Do boys not get wedgies? Like if I had my pants on backwards, I'd have a wedgie.
I don't think kids get wedgies. Let me just say, like, it's just like they don't care. Okay, so then they go to court this morning, and as soon as Bev comes in, Brennan says, we need to be heard, unfortunately. That's what he said. Unfortunately, we need to be heard, unfortunately. She says, okay, well, come to Sidebar because the jury is on their way. So they go to Sidebar. They're there for about 2.5 minutes. And whatever happens makes Bev stand up, pack up her shit, and leave the courtroom. So now there's no court right now. So I don't know. And then what reporter was it? Was it Sue or was it Ted?
Sue.
Who was it? It was Sue that said on Twitter that Bukkake is standing outside. Oh, looks like we're going in.
Good, because my whole basis on even being able to listen to this shit today was that they start at 9 a.m. So I'm glad she decided to start 15 minutes late so she could fuck up my entire day.
I need my mouse too.
Trying to throw out a juror. Oh, that's true, Teresa. That might be it.
That's what I was wondering.
All right, so why don't I see counsel over here at Sidebar? I've got my computer up.
Oh, here we go again.
It doesn't. It seems like it has something to do with whatever the redactions were that were supposed to be made.
Probably Brennan's clips. His clips probably aren't working.
I was saying, so apparently Bukkake is standing outside and the defense wanted to know if he was going to be standing there while the jury was brought in, and they said they preferred that he not be standing there. So I don't know whatever happened with that, but so it seems to me so yesterday they went over they were talking about final versions of Proctor's text, which McLaughlin checked while they were in the courtroom and said that was fine. The other one, I think, was Wolf's presentation. And it had to be, the redactions had to be finalized, or were finalized and had to be reviewed by the Commonwealth. So it seems that maybe...
Oh, Brennan probably has a problem with something. The redactions.
Probably, because she just said, let me get my computer and where's the thumb drive? So that makes me think...
And you know what I was thinking? I was listening to Peter trying to figure out this whole, which I guess he switched platforms to be able to use, and he has no clue what he's doing. So, like, I've seen him, like, messing with his camera. I've seen him argue.
Why did he switch platforms?
I don't know. They're trying something else, I guess. He doesn't even know what it is. And he's like arguing that he's not on YouTube while we're watching him on YouTube. He's like, I'm looking right now on my phone. We're not on YouTube. But anyway, he was talking about Rentschler's PowerPoint not getting admitted. And he said what it sounded like was that they had like some type of agreement, a stipulation, and that they decided that, because he's like, there's things in everybody's PowerPoints that I felt like was hearsay, but the defense didn't object because they had some type of agreement. He's like, and then it seems that somebody went back on that agreement and objected to Rentschler's, and the judge basically was like, well, you didn't object to the other ones.
Exactly. Yeah, you never objected, so it doesn't matter.
And that it's like they probably didn't object because they had an agreement, and then last minute Hank turned around and did that. And so I was like, that's probably right. And then I got to thinking about like Koberger and stuff, and I like how that judge was like, I don't care what kind of agreements you guys make, but I want it all reduced to writing, the exact agreements, because if at some point somebody does something and you guys say, oh, we had an agreement, he's like, I have no way to enforce the agreement because I don't have it in writing. And the defense should have did that exact thing here, knowing how suspicious and snaky Hank Brennan is.
Okay, hold on. So this is on Law and Crime. This is when everything went down. So give me... Can you hear it or no?
I can't hear anything.
Okay, hold on. Did you hear that?
No, I can't hear it.
Okay,
no, I don't hear anything. I kind of like him too, Chelsea.
Okay, hold on. Did you hear check, check, check?
No.
Check, check, check.
Did you hear it?
Wait, maybe.
Check, check.
Yes.
You heard check, check, listen.
Yes, I heard that.
Okay, listen.
Yep, I hear that.
Unmuted.
Do you agree with that? No, that's complete garbage.
Did you hear that?
Did he say, do you agree with that? And someone said, no, that's complete garbage.
That's Brennan and Lolly. Yes.
So Hank said, do you agree with that? And Lally said, that's complete garbage.
Correct. And then?
Now we'll be made seated.
Jurors on their way.
No, we need to be heard, unfortunately.
There you go. Okay.
Do you agree with that? No.
Right there.
Huh.
Listen.
So,
Do you agree with that? No, that's complete garbage.
no, it's complete garbage.
Now we'll be made
You agree with that? No, that's complete garbage. She comes in. Your Honor, we need to be heard, unfortunately.
I wonder if it's something Lally doesn't agree with Hank about, or if it's something that...
Oh. Lolly can't tell Brennan.
You are unmuted.
Here. Play it one more time.
Do you agree with that? No, that's complete garbage.
Now we'll be made seated.
Jurors on their way.
No, we need to be heard, unfortunately.
Okay, come over to Sidebar, please. The jurors are on their way.
There you go.
Interesting.
Yep.
Oh, maybe they confronted them about Buchanan not being allowed to be there outside.
Why would she leave the courtroom for that? Let me see. Let's see when she comes back. When did she come back?
You are unmuted.
You set this up.
Thank you.
I didn't feel I need to see that flash drive.
So she wants to see the flash drives.
Now open the
Here, I
meeting
need my mouse too.
Oh, maybe they don't agree on the redactions.
That's what I was thinking. That's what when I heard that, I was
So
like,
why don't I see counsel over here at Sidebar? I've got my computer up.
okay. So now let me see. Okay, so they're just showing people in the courtroom. So she is there. She's looking at whatever. We still don't get to hear anything that's happening. So John's dad is in the courtroom today. John's mom is in the courtroom. John's brother is in the courtroom. John's sister-in-law is in the courtroom, leaning more towards Carl than her own husband. So that's interesting. Is that Carl or is that Carl?
Oh, wait a minute. Zoom in. Oh, you can't. Oh, I can't. Damn it. Someone that has the ability to zoom. It looks like Carl in back left next to Paul.
Okay, that's what I was like. Wait a minute. Then okay, yeah, that's not Carl. That's Carl.
Wait, was that the lady, the date lady? I don't think it was. Is she gone? Was she not allowed to be here for this? That's so funny. If not,
She was here yesterday for the charging conference.
see, none of his heads were minus.
Yeah.
They were like, "Listen, bitch, you were allowed to be here this entire time. You don't need to be here for closing."
Thomas finally came and got his wife.
I could see her being like the one where once the verdict comes down, she yells something one way or the other.
Oh, probably.
Or cries
So, like,
hysterically. Or
oh, she would cry. She'd cry.
she'd like sob loudly.
So I'm just checking Twitter to see if anybody has anything else. But I think that's it. Had the only other thing that was pending was I think it's Dr. Wolf's presentation, which they already got fucking rid of Renchlers. I just don't know. I just don't understand. Like, he doesn't want anything in there. And Lolly's like, I think it's complete garbage. Caught on a hot mic. Lolly, go back to your fucking paper clips. Nobody cares what you have to say.
Oh, 42 minutes ago, I got a breaking. Buchanan is in the courthouse. So he wants to be in there. That is outrageous. There's literally no reason for that to happen. There's no reason at all for him to be in that courtroom. None.
Right.
In fact, in my opinion, anyone that's not like John or Karen's family that has testified has no business being in there. while the jury's
Yeah.
getting ready to go deliberate, let alone a police officer that investigated the case. Absolutely not. Like, if you're not thinking that that's intimidation, you're insane. And I would be shocked if this entire time we've had no issues with the jurors. Now, all of a sudden, some weird shit's going to happen. Dude, she's 30 minutes late. I may get to listen to the defenses.
Yeah, he may. Yeah, I don't know
And
who that
Jackson is doing the closing.
is. Yep.
I'm glad about that. Are you? Although
yeah.
I did kind of like, I mean, I am happy about that, but I did kind of like Alessi's, what could be more egregious?
I know, that's the best. Dude, if Alessi did it with his black gloves on and with that tone, I would fucking die. It would be the best thing ever. What could be more egregious? I love all the clips that everybody did with that. Like,
Jay has put out some really good ones.
Jay has put out some really good ones. Hey, Katie K. Her bangs are not cooperating. No, she's there. They're all in the courtroom. They're all at the sidebar right now. It seems that they're going over some thumb drive. I don't know. I don't know if either side is using something for closings. And that's what they're having a problem with. But the only thing pending from yesterday was the one presentation that was redacted by the defense, and the Commonwealth had to confirm. Now, I don't know why, if they had an issue with that, they would have, I mean, they had ample time yesterday to let her know that there was an issue with it. Like, he didn't need to be talking to him this morning asking what Lolly thought about it. Like, they would have already conferred, no? You know what I mean? Okay, so now they're walking back over.
I'm looking at the Facebook group from 11 hours ago, and they said caption this, and it's him doing the what could be over and over again. And she said, my favorite has been when you order a Diet Coke but they only have Pepsi.
Yeah, that was awesome.
When the milkshake machine is broken, quote, broken at McDonald's.
All right, so the court, please.
My husband telling me I can't get another dog when he promised me before getting married I could have all the dogs. When you're Higgins at an Albert party and want whiskey and they hand you a beer.
What could be more?
When you order a ham sandwich and they only have bologna.
Oh shit, that's fucking hilarious. Oh shit. Not the ham Sammy.
Someone
So
said when you find out she's wearing a Victoria's Secret Wonder Bra.
Did she leave again?
Oh God.
I was laughing too hard. I didn't see if she left again. Hold on. I don't think so. Did she? I'm wondering if this, like I said, Alan's getting all set up over here. If it has something to do with that one of them using, I would assume Jackson using a video for closing.
Oh God,
because
what is she doing?
She did. She fucking left again.
I might not even get to hear the defense.
You might not get to hear anything. You might just get to hang out with me for a little bit before anything happens. I like that the sponsor down here is delete me. Just fucking delete me. Just done.
Someone said when a can of blue paint costs $440,000.
Ooh,
That's a good one.
That is a good one.
When my husband says we can't buy any more
accurate to be
reptiles.
funny though.
Someone
Say
said
what?
when you bite into a cookie your grandmother baked, thinking it's chocolate chip, and it ends up being oatmeal raisin.
Aw, I love oatmeal raisin.
I do too. When I find out my boyfriend ate my leftovers.
Katie K said I dated this dude once that was always complimenting my boots or my cardigans. And my friend and I swore he was going to snag my Wonder Bra to put it on, and we all BTK.
Wait, let me tell you, Jace. He said, babies, when you do got your nose.
Fucking Jay's funny, dude.
He really is, and he's quick. I miss him so much.
Me too.
When my wife has been extra annoyed with me and I ask her to check her period app.
That's so bad.
And then he said, 32 days of trial, evidence up to AAAA. Now go explain and tie everything together in 60 minutes, and then it's him. What would be more egregious?
Need to put bukkake outside the courtroom and then have it.
My dog when I break a treat in half. Oh my God. And then he said, he put up a poll and says, is it time to retire this meme? My answer is absolutely not.
Okay, so Sue said 5-minute recess.
Oh God.
And then she said the Reed team is jubilant.
That means excited. I
Yeah.
think. Jubilant.
Come on, Sue.
Feeling or expressing great happiness and triumph.
And the birds are happy where you are.
Yeah, I'm gonna go put on my makeup, I guess. Get ready to go. My kid wants me to sit in the back seat with him. My mom wants me to drive. So I guess I'm gonna do both. I'm gonna have to do both.
I don't know how you're gonna do that, but good luck. I'm surprised you can sit outside with the bird noises.
I don't mind the bird noises as long as they don't get close to me.
I was like, you're not petrified, knowing they're so close.
I know
what
they listen.
More egregious.
This listen. His reaction. That was me when that bird had the audacity to come inside my house.
I can totally see that too. And then as your mom and I laugh at you.
Like if I had more breath in me, that's what would have came out. But I could hardly breathe. But my thing is. My thing.
Put your son in the front and make your mom ride in the back. That way you can do both.
Yeah.
That's funny.
The way I see it is that birds,
did you just
other
get knocked
critters,
out?
insects, all of them, they live outside. That's where they live. That's their home. So if I'm going to go out there in their home, I have to expect to see them, right?
Right. Like you go in the ocean, you should expect to see a shark.
Correct. But don't come inside where I live because you don't belong here.
Yeah, no sharks inside the house.
Or birds. This is ridiculous.
Oh, Katie K. Oh my God. I can't even breathe.
He got you.
It's true. It's true. It's a true story too. I could imagine somebody saying that. Somebody that I actually know very well saying that. I was trying to find where we were talking about my mom and her hot rollers. Uh-huh. I couldn't figure out which live it was, and then she got frustrated. But in her defense, she did let me look for like a whole 20, 30 minutes. It was like on a short day, and we did it at the end. I thought so, but then I fast forwarded. I couldn't find it.
I feel like it was after my kid went with her. Like, it was not that long ago.
I'll find it.
Bro, I came here, and as soon as I got here, I was like, well, we'll only be staying here one day.
Why? Is there no food?
No. She
Oh.
don't have the air on. So, like, I walked in.
The audacity.
Literally, I was like, I'm not going to be able to sleep. I'm going to be fucking miserable. This is outrageous. What could be more egregious?
That's what you need to tell her.
And I was like, and I like didn't say anything for a while, but I was like already planning on heading back. And I was like, and then I finally was like, bruh, it's like 100 degrees. Literally, like, look at the thermostat, man. I was like, it is 90 degrees outside. Are you like, what is wrong with you? This is like how people get dementia. You cannot.
I found which live it is.
Which one?
It's the part 2 of the mendacity of the grab ass duo.
Let me write it down.
And I lied, it wasn't on a short day. It was a 7-hour live.
I swore I looked at that one, but I mean,
it's part 2 of the mendacity of the grab ass duo. I'm looking at her hair curlers right now.
All right, so I wrote it down. Okay, so but anyway, the air's not on. Well, her husband. Well, you know he's still not well, but he is finally home from rehab and stuff. But he's always been like, he gets cold. So when she puts the fan on, or when she puts the air conditioner on and stuff, he gets too cold. Well, so now I'm in a little conundrum because
why can't
I don't really care, but he's also not well. What?
Put him outside.
Well, my whole argument would be like, you can put more clothes on. We're naked. We can't get any more naked. So, like, you know what I mean? And so,
I'm walking around in my Wonder Bra here.
Yeah, but like I felt so gross. I still feel gross. I did not sleep. And I really would prefer to leave after our surprise. Don't say it out loud because my kid might be within earshot.
Yep, not saying nothing.
Oh, thank you. Wow, that is beautiful. Oh my God.
Even put a little cookie on it.
I know. It's adorable.
Did he bring you a bird?
No. All right, now go away so I can do my makeup. Thank you. I love it. And I'm going to take a picture before the flowers die. No, he used like pipe cleaners to make like a little caterpillar with hair. And then he picked a bunch of flowers from the yard and he like wrapped the caterpillar. Hold on. I'll send you a picture on why is the color so ugly?
On the stream?
No, on my in this room. This ugly hot room.
Hello, Spring. It says, if Bev screws this day up so much that we can't get to deliberations, I'm gonna be pissed. She said she was gonna ask him to stay late, like until 5.
Oh my God.
I thought that was hilarious. I was like, that's not fucking late, Bev. That's normal time.
Right? She did. She really did. She acted like that was like midnight. Like
she did. She's like, I think
it's only an hour. It's an hour more.
My gin and tonics a little bit later today. Maybe I'll let them stay till 5. Hi, Debs.
But anyway, it's so damn hot. I sent the picture in Messenger. It's so hot. My hair is curling up at the roots because it's so hot. I laid here all night naked with no blanket, no sheet. It's so cute. It's super cute.
Cute it is. So you can't. I don't know if you can see it well, but like that's the flowers, and it's got like the little caterpillar.
He like wrapped them. He wrapped it around the flowers to hold them together in like a bushel.
That's so cute. Little cutie pie. Hey, cat.
So yeah, so like I'm basically dying.
So you guys you're considering going home tonight?
Yeah, I mean, it really wouldn't be that bad. The whole thing is only from 12 to 3. And we'd be back here by like 4-ish or so. So we wouldn't be getting home until dark, but it's like if I can't sleep.
No, then you're miserable.
Like when I can't sleep and I'm at my house and I'm like laying in bed and I'm comfortable, like at least I'm resting. You know what I mean? I couldn't even rest.
Mm-hmm.
So, and I don't want to keep bitching because like I get it and he's not feeling well and I don't want him to be uncomfortable just so I can be comfortable. So, but it's like, what's the next best solution? Well, we just gotta go, you know?
Mav, we read most of them. I didn't read the ones where they're talking about Karen smiling at her father and stuff. I mean, I can now if you want me to. So it says that when they were at the sidebar, they were all watching something on her screen. From the sidebar, Karen smiles at her father. Now she's nodding affirmatively toward her father. Yannetti pats Karen's shoulder at the sidebar. Karen smiles again toward her dad. Judge is smiling while talking with Alessi and Jackson at sidebar. Yannetti is smiling. Karen smiles toward her dad again. She said, I think they are all still looking at the judge's laptop. Karen leaves the sidebar to chat with her tech person. I can see an image of an x-ray on his screen. Karen is alone at the defense table working on a laptop. Jackson now talking to the judge. Karen conferring with the tech person. Yannetti and Little are talking separately at the sidebar. They are smiling and laughing. She said, I have never seen so many smiles at a sidebar. The Commonwealth is not smiling. Judge is looking at the clocks. She directs the court officers to move the podium to face the jurors. Defense and prosecution return to desks. Judge leaves the bench, 5-minute recess. And then this is where I read, and the Reed team is jubilant. And now the O'Keefe family has re-entered the courtroom, and the jury's being called over. So that is where we at. That's where we are currently. So I think the best part of that is that Reed's team is smiling and they are jubilant while the Commonwealth is not smiling. There you go.
Have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court and for the country. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Can we get to the courtroom here?
Good morning, jurors. Good morning. So I have started far too many mornings by saying to you folks, I apologize for the inconvenience having you.
So maybe you should stop doing that at some point.
I didn't want to do that today, but I had to do that today. Everybody has worked so hard on this trial, the jurors, the lawyers, the witnesses, that everything has to be right before you hear it. So I needed to do that this morning. All
right, move on.
I do have to ask you those 3 questions. Were you all able to follow my instructions?
How's the audio? Is it okay or no?
I mean, it doesn't sound great, but she's not mic, so.
Were you also able to follow
go to Court TV. Go to Court TV. Yeah, Bev is the inconvenience every day, literally.
Too many mornings by saying to you folks, I apologize for the inconvenience having you wait around so long. I appreciate your patience. I didn't want to do that today, but I had to.
Doesn't seem much better.
Everybody.
No, but she's not at the mic. Well, it'll be fine when they're at the mic.
The lawyers, the witnesses, that everything has to be right before you hear it. So I needed to do that this morning. I apologize. I do have to ask you those 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we were here yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here yesterday? So as you know, it's time for closing arguments, and When I was a trial lawyer, I never liked it when just before closing arguments, just before I stood up.
Shut up.
Jurors, remember, closing arguments are not evidence, but it's true. Closing arguments are not evidence. The lawyers aren't witnesses. And because they're not evidence, I need you to put away your notebooks because you can't take notes on them. But the reason it used to bother me is because I sensed that it made it sound like they're less important than anything else in the trial, and they're not. They're certainly a very important part of the case. And we've all noticed that you've paid very close attention to this case, and we know that you'll do the same to the closing arguments.
Hank's going to
Couple of things I
misstate
wanna say,
everything.
And you'll hear more about this in greater detail when I give you the chart.
Okay, so Sue said, everything I know, you know. We will soon see what this is about. She did not see Buchanan in the hall outside the courtroom, but Yannetti just left the courtroom, and she overheard an officer saying to him, "Come see for yourself." Alessi is watching the door from his seat at the defense table.
So weird.
Right.
First is you folks are the fact finders. So it's what you find from the testimony, your memory of the testimony. This has been a long trial, but your memory of the testimony, not the lawyers and not mine. So if the lawyers or I say anything that doesn't square with your memory, it's your memory that serves. Secondly, there are very important constitutional rights that I hope that you understand, or constitutional concepts that you need to understand. First, again, the burden of proof in this case is proof beyond a reasonable doubt and to a moral certainty. And the Commonwealth bears the burden of
Someone's phone's ringing.
right. The
Whose
burden
phone
of
is
proof on
ringing?
the Commonwealth to prove beyond a reasonable doubt and to a moral certainty. And because of that, in Massachusetts, because the Commonwealth has the burden of proof, the Commonwealth goes last in closing arguments. I've given each lawyer an hour and 15 minutes, and I'm not going to stop them. So we'll start with the
Yeah,
defendant's
okay.
closing arguments. Mr. Jackson?
All right, move on.
Here we go.
I'm excited. Oh my God, this is it.
There was no collision. There was no collision. There was no collision.
This is good.
I want to take a minute to start off with thanking you. I want to thank you for your attention. I want to thank you for your patience. I want to thank you for your diligence. This is not an easy undertaking. Most of all, I want to thank you for your courage, because courage is what this moment demands. Not just to listen, but to stare directly at injustice.
True.
And say, not here, not now, not on our watch. That's what you're being asked to do. Stare down injustice. I want to start with a simple truth. You folks, not us, nobody else in the courtroom, you folks are the last line of defense. The last line of defense between an innocent woman and a system that has tried to break her.
Yes.
That falsely accused her, that tried mightily to bury the truth. This case was corrupted from the start. It was corrupted by biases and conflicts and personal loyalties that you heard about. And most fatally, it was corrupted by a lead investigator whose misconduct infected every single part of this case from the top to the bottom. In our opening comments to you a few weeks ago, we told you what to watch for. We warned you what to watch for. We begged you what to watch for. Watch for the physical evidence. Pay attention to the medical facts. Pay attention to the science and the physics. But also pay attention to the integrity, the very essence, the integrity of the investigation. But you also saw something during the course of the trial that none of us might have expected, something that should sadden us, something that maybe would anger us. On full display, you saw the lengths to which some police officers will go to protect their own at the expense of the rest of us, at the expense of Karen Reed, an innocent woman. Before we examine the evidence in the case, which we will do, we need to understand the very foundation of the entire system of justice in which we operate. It's the bedrock on which this entire system is built. Reasonable doubt. This isn't just a technicality, and it's not a slogan. It's a constitutional shield that protects the innocent and prevents the government from punishing without proof. The Commonwealth has the high burden to prove every single element of every single charge beyond a reasonable doubt and to a moral certainty. As I said, those powerful words are not just some legal jargon. They're your mandate, they're your obligation, they're your community's protection against injustice. In our system of justice, Karen Reed sits here today, presumed innocent, cloaked in the presumption of innocence. That presumption is not fragile. It doesn't just disappear because there's a charge or a badge or a theory. That presumption stands firm unless and until the Commonwealth clears that high bar, the highest bar the law provides, proof beyond a reasonable doubt and to a moral certainty. That means at the end of this case, at the end of the trial, you think about one or more of the charges, you think, you know what, maybe that's true. It might be true. Then you vote not guilty. If you think it's possibly true or probably true, your vote must be not guilty. If someone among you thinks it's likely true or even very likely to be true, your vote is not guilty. It's because none of those standards, maybe, might be, possibly, probably, likely, very likely, none of those meets the extraordinary burden of beyond a reasonable doubt and to a moral certainty. A moral certainty means a level of confidence so strong, so incredibly unshakable that you could go home, you would go home, look your loved ones in the eye and say, I am certain. Not probably, not likely. I'm morally certain, and my certainty remains unshakable. The law defines moral certainty as the highest level of certainty known in all human affairs. Think about that. You must be that certain about the entirety, not part of, the entirety of the Commonwealth's case. As we discuss this case, you'll see that the Commonwealth comes nowhere near, nowhere close to reaching that extreme burden of proof. Ladies and gentlemen, on January 28th, 2022, it was a Friday night. John O'Keefe and Karen Reed made plans to meet up with friends, go out for drinks. You saw through video evidence and eyewitnesses that they were affectionate, they were loving, they were in good spirits throughout that evening. They started off at C.F. McCarthy's, which you've heard about, and eventually made their way over to the Waterfall Bar and Grill. When they got there, the Albert family, they were already there, and they were already drinking. The Albert family, it's been established as a very well-known family in Canton. They've got quite the reputation. Brian Albert was at the Waterfall, a longtime Boston police officer. His wife, Nicole Albert, was there. She was with him. His brother, Chris Albert, who was a Canton board selectman, he was there. His wife, Julie Albert, their daughter, Caitlin, and his sister-in-law, Jennifer McCabe, whom you met, and her husband, Matthew McCabe, whom you did not meet. They were all there drinking before John and before Karen ever arrived. But also present at the Waterfall that night was Brian Albert's friend, Brian Higgins. We know that he had a romantic design on Karen. That becomes an incredibly important fact as we discuss the facts of this case. As the bar was closing around midnight, the Alberts invited everybody back to their house. They wanted to keep the night going. But the evidence revealed something interesting, that the invitation to John O'Keefe appears to have been for a different reason, an alternate reason. Think about the video of Brian Higgins and what Michael Proctor in his investigation completely and utterly ignored. Higgins was agitated after a day of drinking, agitated that it was John and not Karen, John with Karen, not him. Recall that ominous text that he sent to Karen with her and John standing just feet away. Well, he got no response. And then we see this.
Glad they're playing this.
That's what Brian Higgins was confronted with following his well text. What of all things starts going through Brian Higgins' mind? Where does his mind go? What is he thinking about after seeing this, after witnessing this? He shows you. And if Michael Proctor had been the least bit interested, this video would have shown him too. Take a look.
I hope they show the one at the end too. But I wish he would have specified that he kissed her on the head.
Sparring, practicing, fighting techniques. Where was Brian Higgins' mind? What was he thinking about? And then what happens? Before you look at the next video, think about what you're going to see. This next video is after he sees John kiss Karen on the forehead, after he sends that aggressive text to Karen with her standing just feet away. Watch closely, and this is what you're going to see. This is what Michael Proctor and his investigation completely ignored. Higgins is very clearly upset. He's agitated. Chris Albert tries to control him. He tries to talk to him, calm him down perhaps. Chris forcefully grabs Higgins' arm. You'll see that in the video that you're about to watch. It appears that Chris is trying to calm him down from something. Brian Albert's standing right there with the other two men, but Brian Higgins is having none of it. He appears to be hyper-focused on one person and one person only, John O'Keefe. In an instant, Higgins angrily jerks his arm away from Chris. Higgins rubs his brow, and he directly gestures at John, a gesture that looks a lot like, let's step outside. Let's go outside. But John looks at him, takes a swig of beer, completely ignores him. Take a look. Michael Proctor, the lead investigator in this case, had all this footage, but he did nothing. He had access to the exact same thing that you saw. Why did he do nothing? A few minutes later, Higgins then texts John directly. You coming here? 3 question marks. It's now 12:20 a.m. These guys are not good friends. They barely spoke or even acknowledged each other when they walked into the bar together, other than a quick greeting. So why was Higgins coaxing John over to 34 Fairview? You coming here after this? And why not text Karen? Because at that moment, he wasn't interested in Karen. He was interested in John O'Keefe. This is about 5 minutes before John gets out of the SUV and walks toward the house, about 5 minutes before Karen sees him alive for the last time. So what happened inside that house, or that basement, or that garage? What evidence was there for the investigators to look into? What did they ignore? Laceration over John's right eyelid, black eyes, a large dog at the home, an obvious dog bite on John O'Keefe's right arm, a head injury from falling backward onto a hard surface, alleged surface, a text from Higgins, one of the last people to ever communicate with John O'Keefe. You come in here? Those words now echo in the wake of John's death. But Michael Proctor, he didn't listen. When John didn't come back outside, Karen, very oblivious to what had happened, thinking she was just left alone in the car out in the cold in the middle of the night, she got frustrated and she drove home. She arrived back at home and her Wi-Fi connected to her car or phone connected to John's Wi-Fi at 12:36 a.m. It's an important time, 12:36 a.m. She left John voicemail after voicemail after voicemail. He was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got. Her voicemails reflect that frustration after the fact. That's the frustration that you hear in her angry voicemails. She uses harsh words and foul language. She's obviously upset. She's obviously irritated because he didn't come back out of the house and he wasn't responding. But Karen did not know what you know. She didn't know what the investigators should have known. She didn't know what was happening with Higgins and Albert and with her boyfriend, John O'Keefe. When he didn't come home at about 5 a.m., Karen went looking for him in a panic. As you know, her worst fears were realized when she found John beaten, battered, bloody, and left in the snow in Brian Albert's front lawn. At 6 a.m., when Karen found John, you heard about the scene. It was described in detail. It was chaos. To use Mr. Brennan's word in his opening statement, it was bedlam. The screams for help by Karen, the yelling and the hollering, ambulances, emergency lights, fire engines, ladder trucks, paramedics, patrol vehicles, patrol officers, all of them swarming all over the lawn just under Brian Albert's bedroom window. And of course, as you learned during the course of this trial, Brian Albert, a sworn peace officer, a first responder trained in being a first responder, never came out of the house. Never went outside to help a fallen fellow officer who was laying on his own property. Never came out. And you learned through the undisputed evidence that the lead investigator, Michael Proctor, for his part, never went into the house. The Commonwealth has struggled to try to prove that John O'Keefe ended up in Brian Albert's front lawn because he was struck by a vehicle. They have failed. They cannot and they will not ever be able to prove that John was struck by a vehicle beyond a reasonable doubt and to a moral certainty, because the science does not lie, the medical evidence does not lie, the physics do not lie. Their investigation was flawed from the start because their investigator was corrupted from the start by bias, personal loyalties. Folks, they cannot prove a collision. John O'Keefe was not hit by a car. There was no collision. So let's start there. I want to take a minute to discuss the actual science, the actual physics, and the actual medical evidence that was presented in this case. The science, it's an old saying, is known as the silent witness. It doesn't lie, it doesn't forget, and notably, it doesn't take sides. If there was no collision, what are we doing here? In order for there to be a collision, there has to have been an impact site. The vehicle had to have struck John, period. I want to remind you of some of the most important testimony in the entire case, and it comes from the Commonwealth's own medical expert, Dr. Irini Scortibello, the Commonwealth's medical examiner, someone governed by law to make these decisions. We know that a person struck by a vehicle suffers massive trauma, broken bones, fractures, soft tissue damage, torn ligaments, contusions, soft tissue injury, severe tissue injury, crushing blows. None of that was present with John. None of it. Not anywhere on his body, including his right arm. Not one bruise. Nothing. The fact is, the injuries are not from a vehicle impact. Not his head injury, not those scratch and bite wounds. Not a single medical expert. Think about this. Not a single medical expert called by the defense or called by the Commonwealth has testified that John was hit by a car. Not one. Think about the irony. Not one. That's not just significant. It's literally the most important point in the entire trial. Listen again to Dr. Scortibello's words. Question: you did not include in your autopsy in any fashion any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident, did you? Answer: no, I did not. She told you, quote, I did not see any evidence of an impact site. end quote. She was talking about John's body. The Commonwealth's own medical examiner, Dr. Scortibello, performed the autopsy. She did it personally. She's the only one to have personally examined John's body, and she found no evidence of an impact site on his entire body. That in and of itself is reasonable doubt. You don't need anything more. The Commonwealth's case is done. It's cooked. Their own experts said there is no evidence of a collision, no evidence of an impact. If you want to know what an impact looks like, take a look at this. This is what a body looks like after being struck by a car at 25 miles an hour.
The one from Mulcher's
And this is what a car looks like after hitting a person at 25 miles an hour. These are exhibits from Dr. Welcher, the Commonwealth's expert. John didn't even have a bruise. Make no mistake, Dr. Scortibello was presented with the Commonwealth's theory of the case, the same case that you've been presented with, and she refused to conclude that John's death was a homicide. She flatly refused to conclude that there was a collision. And you know who agrees with that? That silent witness, the science, the physics, the data. Dr. Wolf and Dr. Rentschler, you just met them recently. They explained they were not initially hired by the defense. They were asked by another agency to conduct their analysis. They looked at the evidence from both sides, not taking a side for the defense or the Commonwealth, completely independent. They looked at the damage to the SUV on the one side of the coin. They looked at the injuries to John O'Keefe on the other side of the coin. Both PhDs, both engineers determined there was no collision. I'm not saying it. The science says it. That SUV's taillight was not damaged by striking an arm, and John was not struck by a 6,000-pound SUV. Period. Full stop. Dr. Dan Wolf did the testing on the taillight. Actual testing, not some ridiculous blue paint kindergarten project. He did lab testing. He did field testing. He did data testing. Actual impact force analyses. In every single test at every single speed, the taillight damage was inconsistent with striking an arm. In every test, the taillight damage was inconsistent with damaging the shirt, the sweatshirt. Remember that severe internal damage to Karen Reed's taillight. Not just the outer lens. The internal diffusers were completely smashed, completely shattered. ARCA testing established that all the internal components of every single test taillight, especially the diffusers, remained completely intact. Conversely, on Karen's taillight, the diffusers were almost completely gone. Folks, understand something. If any part of that diffuser portion of the taillight is broken, there is no light. It doesn't illuminate at all. It's just black.
I'm so glad he's bringing
Let's take a look
this
at a couple of photos.
up. Oh, excellent.
At 5:07 a.m. at One Meadows, that's the photograph on the left. What do you notice about the right taillight? It's completely illuminated. Later, at 4:12 in the afternoon, photograph on the right, it's lit up. How can that be? How can that be if the Commonwealth claims that those diffusers, the portion that lights up the light, were already scattered all over 34 Fairview? That's their theory. But don't believe your lying eyes. The taillight's completely lit up. That would be impossible. Dr. Andrew Rentschler, a PhD, a biomechanist, explained that at those speeds, the other side of that coin, John's arm would be basically destroyed. Contusions, swelling, torn ligaments, hyperextensions, dislocation of joints and bones, fractured, broken, and shattered. But as you know, John's arm was pristine, save those dog and claw bites. He didn't even have a bruise. Think about this.
Oops, he said dog.
Think about that photo of those x-rays as you deliberate. You can manipulate a taillight fragment. That's not that hard. You can't manipulate a bruise. If they claim the car was going fast enough to shatter the taillight and shatter the diffusers, then it was also going fast enough to destroy and shatter John's arm, and it simply did not. How do they square that? They don't, and they can't. So they spent nearly $400,000 of taxpayer money to hire someone to dress up and look like John and paint his arm blue, which told you exactly nothing. The ARCA testing, conversely, also established that it is impossible for John's sweatshirt sleeve to be damaged by an impact with the taillight. The Commonwealth's theory is that the sleeve of John's hoodie sweatshirt was damaged by flying shards of taillight slicing through the shirt and through John's arm. I have 3 questions. Number 1, John's arm had about 36 abrasions. How did 36 shards of acrylic go through 9 tiny little puncture holes? How'd that happen? Somebody needs to answer that. Number 2, why are there no slices or cuts in the hoodie? All the defects are punctures. Punctures that you might get from, say, I don't know, canine teeth. And number 3, if the shards cut bloody gouges into John's arm, that's their theory. Why is there no blood, no skin, no tissue on a single shard
That is my
of
tweet
taillight
from yesterday,
that
literally.
they claim
That's what I've been asking.
with John's arm?
Exactly.
The Commonwealth cannot answer a single one of those questions because John's arm was not impacted by the taillight. It doesn't make sense simply because it didn't happen. Compare and contrast the ARCA experts and their actual testing to Judd Welcher. He came to you in the Commonwealth's case in chief, and he told you that for the better part of $500,000, he'd come in and testify that John was tall enough to touch the taillight with his elbow. That's it. And even in that basic demonstration, he had to lean in to manipulate it, to get the results that he wanted. Dr. Welcher then claimed that the reason he didn't do the reconstruction, the actual testing, think about what he said. There isn't enough evidence to determine what happened. I beg your pardon? What happens when there isn't enough evidence, in his words? You vote not guilty. That's what happens. That's out of his mouth, not mine. The Commonwealth also used the same company, Aperture, to try to establish a time of a collision that never occurred. The Commonwealth called Shannon Burgess, the supposed expert from Aperture. There is a cardinal sin for experts, folks, a cardinal sin. It's called confirmation bias. It's when you decide to change your opinion to fit a theory. The most important takeaway from Shannon Burgess' testimony was how brazen, how shameless he was in trying to change the data to try to suit the Commonwealth. Remember Mr. Brennan's opening statement. He made some promises to you. He said, this case is about the data. He stressed it over and over again. They've had 3.5 years to get this right. The Commonwealth has had this case for 3.5 years to get it right. So his top expert, Dr. Welcher, prepares a report. And that report says that John O'Keefe was struck by Karen Reed's SUV at 12:31:38. Note that time, 12:31:38. He was struck, he was immediately incapacitated, he was immediately unconscious. So says Judd Welcher and the Commonwealth's theory. But there was a huge, huge problem with that. And somewhere in the middle of trial, somebody must have realized it. They must have realized that the very data they produced unequivocally establishes that they are wrong about a collision. It could not have happened. Why? Because John was interacting with his phone after 12:31:38. Remember, the collision immediately incapacitating. How could he be interacting with his phone afterward? He was on his phone, opening his phone, checking his phone, reading texts on his phone, and locking his phone, all of it after 12:31:38, which is the time Welcher clocked for the moment of the impact. And he was taking steps and walking with that phone after 12:31:38 also. That's what their own data showed, and it devastated their case, and it devastated that false theory. There must have been panic, I'm guessing, in the room. What do we do now? The data shows John wasn't struck by the car. What do we do? Enter Shannon Burgess. Question. Can you believe him? Can you believe
Hell
Mr.
no.
Burgess? He came up with a brand new story right in the middle of trial. You might ask yourself, would an expert actually say something he knows not to be true? Would an expert actually say something he knows is not supported by fact? Would an expert shade the truth? You don't have to look any further than Shannon Burgess's CV to answer that question.
Yes.
That was a shame. Even with the pull and push and stretch and manipulation of the time data that Mr. Burgess came in here and told you about, it still shows that John O'Keefe was very much alive and walking around after they claim he was hit and incapacitated. Think about that. Matt DeSogra looked at Burgess's report and told you that in 30 out of 30 scenarios of the possible time skews that Shannon Burgess identified, he came in the middle of trial and identified all these other time skews that he called it. In every single scenario, John was alive and walking after they said he was hit. And that's a problem for them because there was no collision. Just look at Mr. Whiffen's data, Ian Whiffen. John O'Keefe took 31 steps at a steady rate, about 83 feet. And then think about this, in a westerly direction. That would be right toward the house. Remember, it's 78 feet to that garage door. That's not a coincidence. The Commonwealth's witnesses, or the Commonwealth's witness, Mr. Ian Whiffen himself conceded that he has reasonable doubts about the accuracy of John's location data. Remember that question and answer on cross-examination by Mr. Alessi. Do you have doubts? I do. Are those doubts reasonable? They are. And remember, it's still the Commonwealth's burden. If their own cell phone expert has a reasonable doubt about John's location, so should you. John O'Keefe was inside, and the phone battery temperature further proves it. This is not speculation. This is science, and it's irrefutable. It tells us that he was not laying outside in the cold. He was inside somewhere a little bit warmer. Ian Whiffen told you that when the iPhone is exposed to freezing temperatures, think about these numbers. When the iPhone is exposed to freezing temperatures, it will drop from 81 to 21 degrees in 15 minutes. 15 minutes. That's a 60-degree drop in 15 minutes. Now look at John's phone. It was laying, according to the Commonwealth, it was laying directly on frozen ground. He arrived at 34 Fairview and his phone dropped only 20 degrees over the course of an hour. Then inexplicably, it stayed steady, never dropping below 50 degrees for the next 4.5 hours, never dropping below 50 degrees for the next 4.5 hours, basically through the entire night. He was not outside. He was someplace warmer, like a basement or a garage. Dr. LaPosada confirmed that John O'Keefe did not have hypothermia. No telltale signs, no telltale Wisniewski spots, no frostbite on any extremity. He did not die of hypothermia because he wasn't outside. Dr. Isaac Wolf, Dan Wolf, Elizabeth LaPosada, Judson Welsher, Andrew Rinchler, all agreed. Every expert agreed. This is how John O'Keefe died. A rearward fall from a standing position. What could make you fall straight back like that? Let's just think about that for a second. What could make you fall from a standing position as Judd Welcher just showed us? Standing up, falling straight back. Add a laceration to the right eye consistent with a fist or a punch, and you've got your answer. He certainly didn't sustain that wound on the back of his head by falling backwards onto a lawn. Dr. LaPosada told you that the patterned injury on the back of John's head could only be produced by hitting a hard, ridged, or ledged surface, like a concrete stair or step. What's just through that garage door? Michael Proctor never stepped down in that garage to find out. What a shame. And look at the arm. Just look at John's arm. You don't need the top experts in the country, but you had them. You don't need the top medical minds on the planet on this issue, but you had them. These are dog bites and scratches. These are animal wounds. Not one witness has been called in their trial. Not one. 8 weeks and counting. Not one witness who actually disputes that John O'Keefe's arm injuries are from a dog. The Commonwealth could not find a single medical expert, a single medical witness who would come in here and tell you those are inconsistent with a dog bite or a scratch. And it's equally clear that there was no collision. Dr. La Posada told you in probably the clearest voice in the entire trial. You remember her testimony. He didn't get hit by a car, in her words. He just didn't get hit by a car. You remember the question that was posed by Mr. Brennan, did you consider the speed of the vehicle? And she said, speed didn't matter because he didn't get hit by a car. She repeated it 3 times because it's true, not just because she says so, but because the medical evidence proves it. The medical science proves it. There was no collision. Dr. Rentschler told you unequivocally and just as firmly he didn't get hit by a car. The Commonwealth has not met their burden. They cannot meet their burden. The Commonwealth hasn't called a single medical professional, not one, to testify that John's wounds came from being hit by a car. Not Dr. Scortibello, not Dr. Isaac Wolf. Contrast that with the caliber and the quality of the experts who came in here to tell you what is obvious to anyone with common sense. Those wounds on his right arm are from a dog. This was not an oversight by the Commonwealth. It's just that there is no one out there. No matter how big a check you write, there's not a medical expert who's going to disagree with that. The fact is, this is the central fact in the case. The only fact that matters is literally uncontested by every medical expert. Uncontested, undisputed. There is no evidence that John was hit by a car. None. How much more reasonable doubt could there be? This case should be over right now. Done. Because there was no collision. So given all that, how did Karen Reed end up sitting here? Why is she even here? Why is she in that chair? Why is she in this courtroom? There is a reason for that. And it's a reason they don't want to tell you, and it's a reality they don't want to admit to. The reason we're here is because the system, the very system that was meant to protect her, that was meant to protect all of us, that system has failed badly. So now let's discuss the facts that were and were not presented by the Commonwealth in this case. Over the next few minutes, I want to talk about the utter failure of the police to investigate this properly and to investigate this fully. And what you're going to see is that Michael Proctor, the lead investigator for the Commonwealth, did nothing to actually and properly investigate this case. Let's start with the house. That's the most logical place to start. I think you'd agree. Brian Albert's house, where John's body was discovered lifeless in the lawn. A man, a police officer, is found dead on the front lawn, and no one secures the scene. No tape, no preservation of evidence, no crime scene log, no search warrants, no consent searches, no photographs of the house interior. They didn't treat the house as a crime scene, and shamefully, they didn't even treat the yard as a crime scene. The lame excuse offered by retired Lieutenant Gallagher, it was really cold and windy, and I didn't know if there was a crime that had been committed. What? You didn't know that a crime had potentially been committed? You have a man laying dead in the yard, and here are the undisputed facts that those officers were confronted with. Black eyes. Obviously, black eyes are consistent with a fight. Bloody nose, also consistent with a fight. Bleeding from the face, consistent with a physical altercation. A cut over the right eye, consistent with a punch. No coat in the freezing cold, not dressed for outside, dressed for inside. and one shoe on. I wonder where the other shoe could be. I don't know, maybe in the house 30 feet away. And then you find a broken and shattered drinking glass next to him, the type of glass that you might find, I don't know, let me think about this, in a kitchen in a house 30 feet away. And John's phone was tucked neatly under his back shoulder. Lieutenant Gallagher actually claimed he did not know it was a potential crime that needed investigating. The neighbor across the street, Detective Lieutenant Kelleher, had a ring camera that was pointed at the exact direction where John O'Keefe would have been hit, and nobody bothered to secure it. Nobody bothered to secure it. Nobody even bothered to look at it. Of course, this was a potential crime scene. Of course it was. Let's not forget, this was Brian Albert's house, and that comes with privileges. Quote, is the homeowner going to catch any shit? Nope. He's a Boston cop too, end quote. That quote starts to make a little more sense now, doesn't it? Michael Proctor wrote those words just hours after John's body was found. He sent this in a private chat, in a private text he never, ever believed would ever be revealed. He sent that text in a series of messages that now belong to you. You weren't given the opportunity to hear from Michael Proctor, but you can read his thoughts for yourself. And I urge you, go read them. They're in Exhibit 209, in case you're wondering. But here are the highlights. Proctor starts the conversation, quote, all the powers that be, one answers ASAP. He's getting pressure, obviously. Get this done. His friend then asks what Proctor's probably thinking at the time. Quote, I assume you guys are out to make it cut and dry since it involves cops. Something stinks. And Proctor responds, yeah, to the something stinks. And then he goes on, but there will be some serious charges brought on the girl. Think about that. Hours into this investigation, there will be some serious charges brought on the girl. She's a whack job cunt. Yeah, she's a babe. Weird Fall River accent, though. No ass bitch. She's got a leaky balloon knot, leaks poo, zero chance she skates. She's fucked. And up to this point, Michael Proctor had done zero investigation, nothing, save talk to a grand total of 3 people, all of whom were named Albert or McCabe. That's it. And this was his mindset. This is the same lead investigator who sent the group chats that you heard about with Sergeant Buchnick. Late night, sitting at his office, rifling through Karen's phone, bragging about looking for naked pictures of her. That text wasn't sent to his buddies or his friends. That text was sent to his supervisors at the Massachusetts State Police, for God's sake. And what was their response? Sergeant Buchanan liked this conduct with a big old thumbs up. He encouraged it. Ladies and gentlemen, a lead investigator is every investigator is supposed to be objective, an objective fact finder, no bias, no agenda. Michael Proctor went far beyond just insulting Karen Reed. He dehumanized this woman. He betrayed her as a human being. He was fired for this blatant bias. If the Massachusetts State Police can't trust him, how can you trust him with this investigation and with your verdict? And with Karen Reed's life. The lead investigator in a murder trial was never called to testify. Think about that. That should stop you in your tracks. Wouldn't you want to hear from Michael Proctor? Wouldn't you want to hear from the lead investigator in the case? Don't you have questions? The Commonwealth did not present their own lead investigator to the jury, the very jury who is charged with judging the investigation. Michael Proctor clearly is radioactive. and the Commonwealth stayed away from it. Michael Proctor is no longer a Massachusetts State Police officer. He wasn't transferred. He didn't go on sabbatical. He didn't retire. He didn't resign. He was fired. He was terminated
He's
for
not
cause.
dead.
The Massachusetts State Police investigated him, found him guilty of dishonorable conduct, not just for those text messages, folks, for sharing confidential information with witnesses and for bias. Not just any bias, bias in this case. Fired. This is the man who touched every single piece of important evidence in this case. All the evidence that was brought before you in this trial went through his hands one way or another. The shirts, the shards. Remember that when Mr. Brennan gets up and gives his closing argument. The shirts, the shards, all in Michael Proctor's possession. Mr. Brennan and the Commonwealth, I think, have pinned their hopes on some microscopic pieces of, or close to microscopic pieces of plastic that were claimed to have been scraped from the hoodie several months after the fact. What he failed to ask every single every single witness is who had access to that shirt and who had access to those taillight fragments. And the answer is it was Michael Proctor. Not for days, not for weeks, for months on end, for months unaccounted for, before they were submitted to the crime lab, before they were ever scraped. Just go look at the chain of custody documents. You've got them. Why didn't Michael Proctor give those clothes to Maureen Hartnett with the crime lab when she was at Canton PD just days after the fact to receive those solo cups? Remember that? Just a few days later, she was there. She drove up. She did the driving to take the solo cups in the grocery bag, which has a ridiculous aspect to it in and of itself as well. Why not just give her the shirts as well? Give her the taillight fragments if any were found at that point. Why hold on to them? What could possibly be a reason? Why wait until March to book those into evidence? Now let's talk about some of the other problems with the Commonwealth's evidence. As I indicated, there was no blood, no skin, no tissue, no DNA found on a single piece or shard of the taillight that the Commonwealth claims cut and sliced into John O'Keefe's arm. Where is that trace evidence? Where is that biological evidence? The DNA. Where is it? They've got nothing. Not a single piece that the Commonwealth wants you to believe cut up John's arm. How is that possible? It's not possible. The only way it's possible is if those shards never touched his arm, because it was a dog. Oh, and the one sample of DNA that they did find, by the way, was found on the outer smooth part of the housing. Not any shard. It was the outer smooth part of the housing. Nothing that they claim actually came in contact with John O'Keefe. Number two, that sample had DNA of two other men, two other unidentified males. That tells you that that DNA had nothing to do with a car strike. That DNA would be expected to be, John's DNA would be expected to be all over that car. Inside, outside, he had access to that car for months and months and months. He was in and out of it all the time. Show me some blood, then we'll talk. They can't, and they won't because it doesn't exist. That SUV never hit John. The hair found on the bumper. The Commonwealth really stretched its own credibility on this one. That magic little hair on the SUV supposedly survived a 37-mile drive in 47-mile-an-hour winds. But that little magic hair just clung there, just hung on. That same hair that moved in between photos in the Sallyport. Remember that? There were two photos taken, and it was either the breath of the photographer or just the movement of walking by the hair. It literally moved between the two photographs. But that hair is supposed to have hung on in a 37-mile drive in a blizzard. The only thing that hair proves that the Commonwealth is embarrassingly grasping at straws. That hair has nothing to do with anything. But it doesn't stop there. There was another revelation at trial, a big one, a huge one, and it came from a very unlikely source. Christina Hanley, the quiet, reserved criminalist who told you something the Commonwealth likely did not want revealed because it's devastating to their case. Absolutely devastating. And it's this. The glass on the bumper didn't match the cocktail glass. None of it. Remember, February 11th, Michael Proctor, without any other person with him, no witness, no supervisor, no other person with him, claims to have found a single piece of glass at the scene. February 11th, single piece of glass, Michael Proctor. Keep that in mind. Interestingly, the glass on the bumper that didn't match the cocktail glass, one piece did match one other thing, the Proctor glass. Those two go together. The only two things that go together from that bumper are the Proctor glass. We know that there's no glass in the taillight. We know that nothing else was shattered on the vehicle. Therefore, that glass had to be placed there. Didn't come from a crash, didn't come from a cocktail glass. So how did it get sprinkled on the back of the bumper? Whose proverbial fingerprints are on that glass on the bumper? The only thing it matched was Michael Proctor. What about the Ford Edge and that snowplow driver, Brian Loughran? He observed that Ford Edge parked outside Brian Albert's house at 3:30 a.m. That vehicle was moved directly in front of where John's body was found sometime between 2:30 and 3:30 in the morning. The only person connected to a car of that make and model, Brian Albert. Michael Proctor did nothing to investigate that point. Did nothing to investigate whose Ford Edge was parked in a spot specifically to block the line of sight in the exact position where John's body would be later found by Karen Reed. No one, not Michael Proctor or anybody else, checked it for evidence. No one even asked any questions about it. That Ford Edge, Brian Albert's Ford Edge, completely ignored. Michael Proctor failed to interview obvious witnesses in this case. Why? Why didn't he want to speak to the snowplow driver, Brian Loughran? Why did he falsely claim that no one plowed the roadway that morning? When police dash cam video, you saw the dash cam, it shows plows going back and forth all morning. Why did he wait so long, years even, to interview Heather Maxson and Ryan Nagel, individuals who were literally outside 34 Fairview at the exact same time John and Karen arrived at Brian Albert's house that night? Brian Loughran, had he been investigated or interviewed, would have told Michael Proctor that he drove past the lawn multiple times on January 29th, and there was no body on the lawn. He would have had a perfect view. Remember, the weatherman told you there was only enough snow at that time. I think he said, in a very charming phrase, only enough snow to track a cat. I think that was it. There was no body there. Heather Maxson and Ryan Nagel would have told him that they arrived at 34 Fairview shortly after Karen and John pulled up behind them, and they would have told Michael Proctor, at least Heather would have told Michael Proctor, that when she left 10 minutes later, she drove past the SUV and observed Karen Reed in the driver's side, dome light on, passenger seat empty. So where was John? Wasn't outside, wasn't sitting down, wasn't laying down. There's only one place he could be. We could all say it together if you could talk with me. He was in the house. But Michael Proctor did not want to have those answers. He did not want to have to disclose those answers. He didn't want the truth. The Commonwealth hasn't presented a shred of evidence of when Karen Reed consumed her last drink that night. Think about that. It's critical information that the Commonwealth has to prove beyond a reasonable doubt and to a moral certainty. They have to prove when her last drink was that night. They have to prove it. We don't have to prove or disprove anything. Every single witness who was asked and who had an opportunity to observe Karen that night said the same thing. She wasn't drunk. She wasn't stumbling. She wasn't slurring her words. She was, in the words of Ms. Kolakithis, completely normal. Even Jennifer McCabe grudgingly had to admit that fact. It's on video. Instead, they used Yuri Buchanan to try to come into court and count sips of alcohol, which he admittedly got wrong. According to Ian Whiffen, the Commonwealth's own expert, the location data, using location data on John's phone, showed Karen driving lawfully. She was driving safely. She was under the speed limit. She was slowing and stopping at stop signs, slowing around corners. And Ryan Nagel corroborated that when he saw her make that left-hand turn onto Fairview. The Commonwealth has an incredibly high burden to prove that Karen was driving under the influence. They have failed to prove that beyond a reasonable doubt and to a moral certainty because it depends on when she had her last drink. What happened after she got home and she was upset with John for not coming back out of the house? That would answer that question. As you well know, no one searched the house for signs of a struggle. Not that night, not the next day. I'm talking about 34 Fairview. Not ever, not once. Not with a warrant, not with consent. They never went into the basement, the stairwells. They didn't look at the walls. They didn't look in the garage. Nothing was ever examined. Nothing was checked for blood. Nothing was checked for DNA. They didn't look for alleged or ridged surface. Zero. You'll remember how surprised Jennifer McCabe was to recall that there was a garage door even on the house. Except this was her sister's house. She's been going to that house since she was 5. She's seen that house. She's been in and out of that house hundreds of times, maybe thousands of times. She's been going to that house her entire life, and yet she acted surprised when I asked her about it. Remember Jennifer McCabe's answer when I asked her whether there was a door at the garage? I was asking her about the front door, the side door, and the garage door. And her answer was, oh, actually, there is a garage door right there. Investigators never opened that door. Let's change the scenario. What if it wasn't the house of a Boston cop? What if it wasn't the house of Brian Albert? We can be certain that investigators would have torn that house apart to get answers about why a fellow police officer was laying dead on the homeowner's lawn. You can betcha. But because this was Brian Albert's house, a Boston cop, nope. And because he was a fellow cop, an insider, they didn't even open the door. That is not justice, folks. That's just pure favoritism. Each of these facts is more than a question mark. They're failures of duty. They're blank spots on a map where justice is supposed to live. And every single one is a reason why you cannot convict Karen Reed. Reasonable doubt abounds. If the Commonwealth failed to investigate every reasonable alternative, how dare they come in here and ask you for a verdict? They didn't investigate the case fully, and yet they're asking you to take the easy road and do their job for them. These facts do not represent reasonable doubt. Nothing does. Every one of these facts that you're seeing that we're talking about represents reasonable doubt. Every one. The police and the prosecution are in a position to take people's liberty. It's the most dire and consequential act a civilized government can take against one of its citizens. Their obligation is not just to try to get it right. They have to convince you to the highest degree of certainty known in human affairs. They have to do it all, every bit of it, beyond any and all reasonable doubt. And they have not done that here. And how about the homeowner himself? The host, the first responder, the Boston cop, Brian Albert, who was sparring and practice fighting with Brian Higgins just minutes before John O'Keefe appeared at his house, 34 Fairview. Brian Albert, who was watching Chloe that night, the German Shepherd. Brian Albert, whose phone and his wife's phone were never secured. Brian Albert, who never came out of the house. But that doesn't mean he wasn't awake. It doesn't mean that he wasn't on his phone. Think about this. Jennifer McCabe claimed that her sister and Brian Albert both slept through this complete chaos right outside their bedroom window. But Jennifer McCabe's phone records tell a different story, and they tell the truth. She spoke with them for the better part of a minute, 38 seconds to be detailed about it, at 5:07 a.m. And then she lied about that call. Remember that? What was the reason for that call at 5:07? Was it panic? Was it a warning? We know that conversation took place at the precise time Karen left her house to go search for John, 5:07. We could answer those questions if we just had access to their phones. Brian Albert, Brian Higgins. Michael Proctor wasn't interested in their phones. Not only did he not secure their phones, he never even asked. And what about Brian Albert's dog, Chloe? A dog with a history. A dog that is, quote, not good with strangers. Dr. Russell confirmed that John's patterned injuries were from a dog, just like the dog Brian Albert owned. And then Chloe just disappeared. Not there the next morning. None of the officers that you heard from said that there was a dog in the house. They didn't see her. She was just gone. And then ultimately gotten rid of altogether. Who gets rid of their family pet? Unless they had something to hide. Michael Proctor wasn't interested in that either. And recall the group chat with the Alberts and the McCabe's. They were getting their story straight. Matt McCabe, whom the Commonwealth did not call in this trial, instructed the group in that group chat, you'll recall, tell him to say the guy never came in the house. Think about that exact quote. Tell him to say the guy never came in the house. And Brian Albert, the patriarch of the family, exactly, exclamation point. He blessed it. With the truth, as we all know, you don't need to get your story straight. You don't need to tell someone what to say. It's just the truth. And what about the Google search? A Google search that Jennifer McCabe admitted having made. A Google search that was time-stamped by Celebrite at 2:27 a.m. A Google search that read, Haas Long to die in cold. It is uncontested and undisputed that that search was deleted. If the 2:27 a.m. timestamp is not true, why does Jennifer McCabe have to lie about it? Why delete it? If the 2:27 a.m. timestamp is not true, why create a false story about Karen screaming Google hypothermia? That's just a fabrication. That's just a made-up fact. And by the way, if someone does tell you Google hypothermia, why would you Google how long it takes to die in cold? Wouldn't you just Google hypothermia?
Great point.
Jennifer McCabe enlisted Carrie Roberts to help shift the blame to Karen. Why go to that much effort unless you're trying to cover for something? Keep in mind the entire foundation of her claim that Karen said Google hypothermia is this fantasy about Karen screaming it at the location, at the scene. That's her entire excuse. But that story went completely off the rails when Carrie Roberts admitted that she perjured herself to back up Jennifer McCabe's false story. That was a dramatic moment in court. It's an admission of perjury, and you don't see that very often in a courtroom. That tells you everything you need to know about the character and quality of the prosecution's case and their witnesses, lying and perjury and admitting to it. A fundamental tenet of any investigation is to ensure that witnesses are independent and not influenced by other witnesses. You start by separating the witnesses. Michael Proctor did none of that in this case, and we see the results. Think back to Jennifer McCabe's own text messages with Carrie Roberts. About Carrie Roberts, not with Carrie Roberts, notably. What Carrie Roberts didn't know was at the time she was being interviewed by the police, Jennifer McCabe was in real time. She was bragging about having influenced Carrie's testimony or her statements to the Alberts and the McCabes. Quote, she's telling them everything, all the stuff. Remember that timeline that we talked about with Jennifer McCabe? That's what she was referring to. She's telling him everything that Jennifer McCabe had put in Carrie Roberts' timeline. The Commonwealth wants you to believe that Karen Reed made a statement at the location, at the scene. I hit him. I'm sure you'll hear that from the prosecution in their final arguments. But their own witnesses contradict that. Jennifer McCabe admitted on cross-examination that her very first statement to law enforcement, confirmed that Karen didn't say anything. She asked, could I have hit him? Did I hit him? Is he dead? The physics and the science answer that question. Could you have hit him? No, you couldn't have. Sergeant Buchanan also testified that the only statements Karen Reed made at the scene, according to his conversations with the first responders, was, could I have hit him? Did I hit him? It wasn't a confession. It was confusion. And Dr. Russell explained that confusion. She told you why Karen Reed or anybody in that position might ask those questions. She was suffering from extreme grief reaction, which according to the evidence can last for years. Even her medical records confirm that diagnosis. It's common to ask those questions in grief. It's common to ask those types of questions in shock. You're trying to make sense out of the nonsensical in the moment. And the Commonwealth has tried to twist those words into a confession. There is no evidence that any officer at the scene ever heard Karen Reed say, "I hit him." Not a single police officer at the scene came in to support the Commonwealth's claim. It's not on video. It's not on audio. It's not in a single police report. It's not in a single EMT or EMS report. Nowhere. The fact is, Karen never said, "I hit him." You saw the video. Multiple officers were right there. She simply never said it. What did Jennifer McCabe do and not do when she got to 34 Fairview? She would have you believe, I want to set the scene for you, that she's confronted out of the blue with John O'Keefe's lifeless body. Her friend, John O'Keefe. He's bruised and battered. He's bleeding. His eyelid is cut. His nose is bleeding. Karen is screaming at the top of her lungs. Carrie is screaming back to Karen, "Shut up!" Both women begin crying. Both women are giving CPR. There's chaos everywhere. It's building in the yard, just feet from Brian Albert's house, Brian Albert's window. Jennifer calls her sister at 6:07 with all this chaos going on. No answer. Jennifer calls her sister at 6:08 with all this chaos and bedlam going on. Still no answer. No lights come on in the house. In the midst of all this screaming and this chaos, Brian Albert doesn't come outside. Nicole Albert doesn't come outside during this maelstrom. And yet, Jennifer McCabe never goes inside to check on her sister.
Yep.
There's literally no signs of life inside the house. And Jennifer McCabe doesn't take a step inside that house to check on her family. Why is that? Does that make any sense? Everyone would sprint inside the house to make sure that there's no one in there that was hurt or injured or, God forbid, dead.
I would.
Everyone would do that. But not Jennifer McCabe. The only way that makes sense is if Jennifer McCabe already knew that Brian and Nicole were just fine. That's the only reasonable explanation. And the only way she would know that they were fine is if she knew what happened. But Michael Proctor never explored this incredibly suspicious behavior. Don't you have questions? This would give anyone reasonable doubt. And don't you have questions also about Brian Higgins? Michael Proctor certainly didn't. Higgins had been sending flirtatious and romantic texts to John's girlfriend, Karen Reed. You'll remember I asked Sergeant Buchanan a simple question. Were those texts flirtatious in nature? He refused to answer that simple question. Do you remember that? Quote, "I'm not comfortable putting a label on that," end quote. We read the texts. It's not a secret. Of course they were flirtatious. Of course they were romantic in nature. The reason he refused to answer that simple question is telling. It's because these flirtatious texts establish a motive for Brian Higgins. Sergeant Buchanan could not bring himself to tell the truth. His bias was on full display. He was covering for another cop. Investigators also ignored Higgins' suspicious late-night visit to the Canton Police Department. That was after a night of drinking, by the way. Why didn't they investigate this? What was so important that Higgins needed to go to the police station at that time, 1:30 in the morning, while drunk, by the way? Why weren't they interested in those facts? Remember, he's an ATF agent. He's a cop, a member of the Blue Wall, and best friends with Brian Albert. He would know that the CPD would be the first to get the call when someone reported John missing or injured. He would know what to look for, what to listen for, to determine if a report had been made and when and what the response was going to be. You saw the skulking through the hallways with his hood up, moving bags between cars, and of course, that late night mysterious phone call on his cell phone, a phone that you don't have and that you'll never see. All of that, and Michael Proctor never gave him a second look. All of that, and the Commonwealth, who's supposed to be after the truth, didn't call him to the stand. If you have any unanswered questions about Brian Higgins, that's reasonable doubt. The police didn't interview Brian Higgins on January 29th, 2022, but he was at the police station, as we've just seen. You heard evidence that Higgins and Chief of Police Kenny Berkowitz, also good friends, were in the Sallyport together with the SUV for a, quote, wildly long time. Kelly Dever, another Boston cop, told you that. She also told law enforcement agents that she found it, quote, weird that Higgins could have access to that very sensitive evidence, the SUV. Folks, there is never a situation in which a witness, a potential suspect even, should be given access to the evidence in a case. But that's exactly what happened here. Higgins was given unfettered access to that SUV and its taillight nearly immediately, according to Kelly Dever's statement to law enforcement. And it was at that exact time, the exact moments that Higgins would be in that Sallyport, that the 42 minutes of the Sallyport video is just missing. It's just gone, vanished. Well, that's convenient. Now put in context the condition of that taillight when it was actually seized in Dighton. It was cracked, but not completely damaged. I ask you to compare and contrast Officer Kelly Dever, her attitude, her demeanor. That's all for you to judge. Her attitude, her demeanor, her truthfulness, her motives from the witness stand. Compare and contrast that to Sergeant Nick Barrows. Who's more believable? Officer Barrows is unattached to any of the players in this grand play directed by Michael Proctor. He's truly independent. And what did he tell you? Was the taillight, he was asked, was the taillight in this condition when Michael Proctor picked up that SUV at 412? His answer? Absolutely not. Absolutely not. It was cracked, but not completely damaged, not smashed out like that. So how did the taillight get cracked? How did it end up in the condition where it was cracked, as Officer Barrows saw it, but not completely damaged? Well, you don't have to guess. There's a video. Just watch.
Excellent.
That's how it got cracked. And Judson Welcher's own recreation confirms it. Look at the contact. That's from the Commonwealth's expert. And that further is confirmed by the fact that there were no taillight pieces found in any of the initial searches conducted at the scene. 2 searches, 50-foot area searched. Not a single fragment was found until after Michael Proctor had access to and control of that SUV and its taillight. What does that say about the character and quality of this case? It's revealing what happened here at trial. One of the most dramatic moments probably of the trial, Kelly Dever. How can you trust this investigation when you saw how far a police officer will go?
Yup.
You had a front row seat to the power of police manipulation and police corruption. A front row seat.
That's why they called her.
Kelly Dever was interviewed by a separate law enforcement agency, not a friendly department, not Boston Police Department, not Michael Proctor's MSP, a different independent agency. She told those law enforcement agents in a formal interview that she saw Brian Higgins and Chief Kenneth Berkowitz alone in the Sallyport with the SUV. She was detailed, she was clear, she was unequivocal, she remembered the specifics, she recalled how it made her feel, quote, weird. She recalled how long Higgins spent, a quote, wildly long time, as she described. These are all incredible details to tell law enforcement. She couldn't have been clearer. She couldn't have been more specific. But then she's put on a witness list. and she's subpoenaed by the defense. Oh boy. Then this rookie cop was called up to the police commissioner's office, the same commissioner that was the boss of Brian Albert. They have a meeting, a private meeting, and he says, wink, wink, nod, nod, "We support you, Officer Dever." What else was said in that meeting?
Love it.
What else is reasonable to believe was said in that meeting? She claimed she couldn't remember. She claimed not to remember if he instructed her to do the right thing. But the commissioner of the Boston Police Department certainly said something to this rookie cop. And all of a sudden, that detailed, unambiguous, unequivocal statement to law enforcement became, what did she say? A false memory. Not, "I didn't say it." She admitted she said it. She admitted she detailed the entire story. She just said, "It's a false memory." What? So she's called to the commissioner's office to make sure that she would do the right thing. That's why she was called. And now we know what that means. In her words, "My entire career depends on what I say here on the stand." I'll quote that again. Quote, "My entire career depends on what I say here on the stand." You bet it does. That's how it works. And that's how we got here. At the end of the day, you have to ask yourself, can you trust the Commonwealth's case? Can you trust their witnesses? Can you trust their evidence? And here are a few of the highlights. A video that was played in a courtroom and sold as accurate. Turns out it was completely inverted, flipped backward, completely false. The test that formed the basis of their entire theory of the case. Watch closely as Dr. Welcher stands as a surrogate.
Moves to make it work.
Is that a righteous test? Or is that a manipulation? Dr. Welcher tried to deceive and fool you by leaning into the car, manipulating the results of his own test. When the truth was revealed by Dr. Rentschler, the Commonwealth spent the next hour cross-examining it about how that test was meaningless. It actually didn't mean anything. Well, that's convenient now that we realize that it was a manipulated test, and it actually does mean nothing. It didn't represent the theory of the Commonwealth's case. That's what was suggested. That test does not represent the theory of the Commonwealth's case. Really? Then why was Dr. Welcher playing dress-up in John O'Keefe's clothes, or identical clothes to John O'Keefe, when he was holding a glass? Why was he holding the glass right behind the vehicle? And why was he standing with his right arm oriented to the right rear taillight if he wasn't trying to recreate the circumstance that is the Commonwealth's entire theory? The Commonwealth stood up here with a straight face and told you they weren't trying to suggest that that's how John was hit by the car. Of course they were trying to suggest that's their theory of the case. They only abandoned it 2 days ago when it was revealed by our experts that it's physically impossible. That silent witness, that science, that physics has become very pesky to the Commonwealth because there was no collision. Dr. Welcher also told you under oath that there were no x-rays taken of John's arm. He tried to deceive you into believing that John's arm might have been broken. I don't know. I didn't see any x-rays, so I can't tell you what the damage was inside the arm. Really? The Commonwealth has had those x-rays in their possession for 3 years. And again, it took the defense to bring out the truth. The x-rays do not fit the Commonwealth's theory, so you weren't shown. And Dr. Welcher wasn't going to admit it. And my goodness, then we get to the sweatshirt. That was a moment. Mr. Brennan stood here in front of you and dramatically held up John's sweatshirt. Not just to the witness, but to you. And asked Dr. Wolf about it multiple times.
Yes.
Specifically, while it was in that plexiglass, asked Dr. Wolf about the multiple holes in the back of the sweatshirt. He interrupted Dr. Wolf, and Dr. Wolf started to look at the sweatshirt and say, well, and he said, how about here? Here's a hole, here's a hole, here's a hole, here's a hole. dramatically tapping on that plexiglass. It was clear what the suggestion was, that the holes in the back of John's sweatshirt were from January 29th. That's the impression that was expected to be left with you. That's the impression that he wanted to leave with you. And that's false. The truth is, the Commonwealth created those holes. They aren't holes from road rash. They weren't made on January 29th. Those are cuttings from the Commonwealth's own crime lab, folks. That's what those holes are. And even with 3 prosecutors, all 3 of them, sitting right there in the room at the time, it had to be the defense to correct that record, to bring out the truth. If we hadn't done that, what impression would you folks have been left with? That's more than negligence. That's dangerous. It's dangerous. I'm going to guess that Mr. Brennan's not going to say much about this, about the fraud that was attempted on you. And if he doesn't, that speaks louder than any concocted excuse that the Commonwealth might come up with. It's shameful. It's shameful. We are after the truth in this courtroom. You're entitled to it. Demand it. Why would the Commonwealth stoop to a stunt like that? It's desperation.
Mm-hmm.
They know what you now know, what their experts know. There was no collision. So now we've reached the final moments of the trial, and you've seen the facts and you've seen the evidence, and we've just talked about dozens and dozens and dozens of facts that are reasonable doubt. Each one of them are reasonable doubts. These facts, these note cards that you're looking at, piled high, one on top of another, literally stacks and stacks of them covering the table. As you mentally sift through those cards, realize that every one of them is a massive hole in the Commonwealth's case. Every single one of the note cards represents a hole in the Commonwealth's case. If you're holding mentally even one of those cards, you're holding reasonable doubt, folks. You're holding a not guilty verdict. Reasonable doubt is not a sliding scale. It's a wall. If the Commonwealth cannot get over every one of these dozens of walls, you have to acquit Karen Reed. The truth is, Karen Reed is not guilty. Not because of technicalities, but because the facts, the law, the science, the physics, the data, they all say so. They demand it. The Commonwealth does not have a theory about how John was hit by the car. They haven't even shown you that it's possible that he was hit by a car. And the reason they haven't is because it's not possible that he was hit by a car. There was no collision. Your job is not to do their job, their burden entirely. It's theirs. They have to prove this case and their theory beyond all reasonable doubt and to a moral certainty. And not only do they not have a theory, they can't prove one that doesn't exist. All you need to know is that the Commonwealth failed. They failed to provide you with a truthful representation. They failed to prove the essence of their case, that John was even hit by a car to begin with. They failed to prove any intent on the part of Karen Reed because she has none. They failed to investigate the actual suspects in this case. They failed to present the lead investigator to you. They failed to justify the perjured testimony that you heard discussed in this case. They failed to hold accountable an officer who came in here and lied to you and claimed false memories so she could do the right thing to cover for a fellow cop or cops. They failed to maintain a fair and unbiased and honest investigation. They failed to present you with the truth. And this is what you get. An investigation that's riddled with errors and omissions and a rush to judgment and conflicted and corrupted from the start, every part of it. That is the literal definition of reasonable doubt. How can they ask you to be morally certain based on this evidence. It's a tragedy. When the government fails so completely, so catastrophically, when there are dozens and dozens of points of reasonable doubt on the table, your duty, your oath is clear. Your sworn obligation under the law is to acquit Karen Reed, not just because you can, because you must. Justice demands it. Do not let the Commonwealth get away with this. Don't let them get away with this. Do not endorse and sanction an investigation that is broken and corrupted top to bottom. But just as importantly, do not let Michael Proctor get away with it. And make no mistake about it, folks. If you convict Karen Reed of anything, if you convict her of anything, science, the physics, the data, they lose. But tragically, Michael Proctor wins. Remember his texts. Something stinks. Yeah, but serious charges will be brought on the girl. She's fucked. Could you ever say to yourself, this is justice? The fact is there was no collision. A car did not kill John O'Keefe. So I ask you, let your voice be heard, not in whispers, but in truth. Let the community feel through your verdict that justice cannot be bent and that it will not be buried. Find Karen Reed not guilty, not guilty, not guilty. Thank you.
Holy shit, dude! Like
That was amazing. And
that was
Ted
so
Daniel,
fucking good.
Ted Daniel just tweeted that he could hear a bunch of cheering. He's died and he said he could hear a bunch of cheering outside.
Oh, really?
Yeah.
Oh my god, that was just so good. I mean, there's so many good parts. Like, I don't even know how people could go around and clip that, because that whole thing was a fucking amazing. If he
Hurry
had
up
a
and I'm
mic,
not gonna be
he
able
would have fucking dropped it. All right, we'll go. But I just have to say that,
because
I'm gonna have to watch that
not-
a couple more times today. I'm just gonna say that out loud because that was so good.
Yeah,
One of
because
the
I'm
best
not going to
I've
be able to watch
ever heard.
Brennan's full thing. Yeah, it was better than last time.
Oh my gosh, yes. Their whole case was better than last time.
Now I'm going to get annoyed, so I'm glad.
John O'Keefe was 46 years old. 46 years old. He spent his life helping people. He's described as a good man, kind, generous, thoughtful. He was a Boston police officer. He worked to help the community. Everything you've heard about this man, he was a good man. He helped people. When his niece and nephew had nobody, he took them in. He took them in. John O'Keefe seemed to be the type of person who would help anybody at any time. And on January 29th, 2022, John O'Keefe needed some help. He needed help from somebody else. You see, John O'Keefe had just been hit by Karen Reed in front of 34 Fairview Road, and he lay on the ground dying, and he needed help. Someone to reach out a hand, someone to knock on a door, someone to make a phone call to 911, even anonymously. Not take responsibility, just to help. And there was only one person in this entire planet who could help him that morning, to give him a chance. Maybe it was a 33% chance if he met the Isaac Wolf of the world, but to give him a chance. And that one person who could help him that morning was this defendant right here, Karen Reed. And she made a decision. In her Lexus with the shattered taillight, debris field all over the front yard, and John O'Keefe lying helpless like a child on the front yard. She made a choice. She didn't call 911. She didn't run to his aid. She didn't knock on a door. She made a decision about herself. In her Lexus, she drove away. She was drunk. She hit him, and she left him to die. She was drunk. She hit him, and she left him to die. Before I go through and detail the evidence, let's talk a little bit about the evidence as a whole. She was drunk. She was drinking that night. She was drinking McCarthy's with John. She was drinking at the waterfall. Her blood was taken with samples of a retrograde analysis, almost 2 to 3 times the legal limit. She was drunk. She hit him. The timeline in this case is beyond dispute. You can accuse, assault, characterize, malign, twist. The timeline doesn't change. It is data. Data is data. The black box, the forensics from the SD card, we know exactly step by step where they were. We know in that window, she hits him because he never moves again. His healthcare data, the temperature on the battery of the cell phone, the physical evidence, the debris field, the DNA, the hair. And then she left him to die. He had a basal skull fracture, counter coup. You heard all about it when the back of your head hits the ground and the brain comes forward. Dr. Wolf told us the reason why they have level 1 trauma centers around the country is because people can survive this injury if they get help. That's why they have this care. That's why they have these hospitals. But you gotta get help. You gotta get help. And if you don't, you develop symptoms, ecchymosis, raccoon eyes, your brain swells, and you die. She was drunk. And that night was a recipe for disaster. But before we get to the drinking, in some ways, the fate of this night was sealed well before that night, because John O'Keefe and Karen Reed were in a toxic relationship. This relationship was crumbling. We hear lovey-dovey, and it was crumbling, and we know it. And we know it because a month before, his niece Kaylee talks about when they went to Aruba. It should have been a wonderful event. It was discord. It was fighting. It was aggravation. And when they got back, the discontent was palpable. Miss Reed reaches out to Brian Higgins, text messaging. John O'Keefe, the relationship is crumbling. And you heard a little bit about what that relationship was like. Kaylee, his niece, told you, when there was an argument, John would do what John does. He would walk away. She described for you one time, to get away from the scene, he walked into his bedroom, but the defendant wouldn't let it go, pounding on his door, having to get the last word, never letting go of the fight. Kind of mirrors what happens on January 29, 2022. And maybe outward appearance, they got along. Maybe sometimes quietly they got along. But behind closed doors, relationships have up and downs. We have a bird's eye view into the relationship on January 28, 2022, because we have the text messages, not so lovey-dovey. The relationship is almost over. The tensions are simmering beneath the surface. They are not getting along. She believes Mr. Keefe is already halfway out of the relationship and he's not into it anymore. You will read them, you saw them. This relationship was unstable and at its end. And so fast forward that night. That night, after this discord, after the arguing, they go out and what do? They drink. And they drink a lot. So Keith drinks a lot and Karen Reed drinks a lot. You've seen the McCarthy videos. You can call it 6, 7, 8, whatever you want to call it. You can see the shots into the next drinks, more shots into mixed drinks. Count them yourself. Over a half dozen mixed drinks in just a few hours. Sober. And then at the waterfall, a shot, a mixed drink. Now, it was brought up the waterfall that there was some type of discord between Brian Higgins and John O'Keefe. They knew each other. They were friends. Brian Higgins' conduct of speaking to Karen Reed is not honorable. It's not. But they were friendly. There was no adversarial relationship. There was no anger between them. What we heard is they barely greeted each other. Could we have slide 1, please? At the waterfall bar, when you see John O'Keefe come in, here's him barely greeting him. That's him and Mr. Higgins, barely greeting each other. Reality sometimes is different than argument. This is a celebratory mood. Take that down, please. Celebratory mood. A bunch of friends. They're playing around. They're hugging. They're grappling. This is a fighting technique for a murder 2 hours later. Is that the story? They're practicing their moves to murder John O'Keefe. In the celebratory mood, you don't see any aggravation or animus between Brian Higgins and John O'Keefe. Inevitably, the next morning, Karen Reed is brought to the hospital and they take her blood. Now, the government doesn't have to prove that she was drunk. It is either that she's over the legal limit, 0.08, or she had enough alcohol to affect her ability to operate a motor vehicle safely, but you will know that she was far beyond the legal limit. After the retrograde analysis, almost 2 to 3 times the legal limit. Almost 2 to 3 times the legal limit. Now, it's been intimated, not come out and said, that maybe she went home and started drinking after she got home. No evidence, mind you, no evidence. And that somehow that is why she had a high blood alcohol level. It's not appropriate for me to comment on the credibility of another attorney's argument, so I won't do that. But Karen Reed will do that for her. So if we listen to slide 2, she'll tell you exactly what she thinks about that claim.
My alcohol intake's probably about 5 or 6 or 4. The drinks that they were pouring me at McCarthy's, which is where I consumed most of the alcohol, was the weakest at the time. It tasted just like old soda water with lime.
Slide 3, please.
I wouldn't have gotten on the expressway. I wouldn't have gotten on the expressway at 12:15 on January 29th. I mean, it was quiet, the roads were very quiet, you can see on the videos. And I was going, when I've had a few drinks and I drive, I always drive extra slow. So I know my alerts aren't as sharp as they should be. But I shouldn't have been driving.
Thank you. Do you think she drank when she got home? When they leave the waterfall bar at 12:12, you see a video, you have it in evidence, there's a still photo of John O'Keefe holding a glass. Not from the Albert's home. He didn't sneak into the house in the cupboards and grab a glass. From the waterfall, you see him with a glass, and in it is a straw. Take a look at that picture. And now from 12:12 on, we virtually have a historian in the data that tells us exactly where he went, exactly step by step where he went. And how do we have that? Well, we know the defendant's car had like a black box, and Judd Welcher, Dr. Judd Welcher, took the data from the black box and downloaded it so you can see the movements and the triggering events. And then Shannon Burgess, well, you don't like what he says, don't attack the data, attack the man. He can be mocked for his LinkedIn profile or his unupdated CV. But what he did is he found a key critical piece of this case that did not exist before. He found it recently. And it was that SD card. The SD card that everybody missed, including the defense expert. Everybody missed it. So as much as you want to make fun of him, Shannon Welcher found the key so that we could have the time and date and location coordinated for an impenetrable timeline that can't be broken. That's what Shannon Burgess did. And so we know on the way from the waterfall to 34 Fairview, Ms. Reed is driving, drunk. Mr. O'Keefe is in the passenger side of the car, and they're heading their way to 34 Fairview, and they get lost. And now we have more data because John O'Keefe has a cell phone. And I said it at the beginning, it is a historian. It doesn't suffer from bias, it doesn't suffer from prejudice, it doesn't suffer from memory loss. It has data on it. And he puts on Waze, high location data, as Ian Whiff would say. And it tells you second by second the speed, the location, the movement. That's what it does. And he has healthcare data on that phone. The healthcare data separately shows his movement. And that is critical. It is critical because it not only shows his movement, it shows when he does not move. That healthcare data is critical. And it's not subject to bias. It's not in dispute. There's no other contrary evidence. It is data. On the way to 34 Fairview, alcohol fuels tension. We know that. And we know from those text messages the tension in that relationship. And then there's a trigger. There is a trigger on the way because they're lost. And when John O'Keefe calls Jen McCabe for directions, Jen McCabe says something that triggers what's going to happen next. Could I have slide 4, please?
Very close to the outbursts. In fact, when Jen was navigating John to the outbursts when I was driving, she said it's near Ashley's house. Ashley and John had hooked up prior to John and I dating.
And so as they travel to 34 Fairview, under the duress of this crumbling relationship, fueled by intoxication, we have triggers. Now, we know on their way there, we know from the data, where they went, how they moved. If we look at slide 5, Ian Whiffen showed you a guide. You could enlarge that just a little, please. And it shows you with the healthcare data, it registers as flights climbed, but it doesn't mean someone's climbing upstairs. What it means is there's an elevation, and he breaks down the data, the red, the green, if you can move down to his installment. And then the bottom left, that's 34 Fairview. You can see second by second the circles of their route, even the 3-point turn on Cedar Crest. That's what you see. At that point, they've left the bar. Remember, the battery temperature was 82 degrees. They're now in a car. It's now 77 degrees. Think about how accurate the battery temperature is, that it reflects the difference between being in a bar and being in a car. They take a 3-point turn at Cedar Crest. And because of Shannon Burgess and because of Judd Welcher, we have the data, and it's a triggering event. Remember, if there's an acceleration past 30%, it registers data on the car, and that's exactly what happens. Is a 3-point turn, and it all lines up with the cell phone after you synchronize the times. It's that simple. It's nothing complicated. There's nothing tricky. There's nothing devious about it. It's data. They do the 3-point turn, and you can match the cell phone clock with the Lexus clock, and when you do, you can reconcile the difference. There's been a lot of talk, a lot of argument, a lot of fights. Shannon Burgess says 21 to 29 seconds. Mr. DeSorga comes in, Unfortunately, he wasn't able to actually do anything. He wasn't given the invitation to test the data. He just looked at the report and made criticisms like a Monday morning quarterback. But even he, looking at the data, says, well, it's 3 seconds off or 2 seconds. Same window, same time. We can have all the arguments we want. They're there, they're together. The data matches up perfectly, perfectly. And so they make their way down to 34 Fairview Road. They don't stop. They don't stop at the driveway. They don't stop. And John O'Keefe gets out of the car. They go to the flagpole, and we know for two reasons. One, the data. And secondly, Mr. Nagel and Ms. Mason at Cedar Crest, at that intersection before it goes down to the right, they meet. They let Karen Reed go first. They fall behind in the truck. Now, at this point, Mr. O'Keefe has about 8 more minutes before the beginning of the end of his life. And he's in that car. He's in that car for most of it because Ms. Mason and Mr. Nagel don't see anybody get out of the truck. Nobody crosses the lawn. Nobody goes to a garage. Not just because they didn't see it. They didn't. Not because they didn't see it. Because the healthcare data on the phone shows that John O'Keefe is not moving. The car is stopped at the flagpole. The healthcare data stops. The battery stays at 77 degrees. The data is the data. You can't change it as much as you want to. It's data. And they sit at that flagpole for minutes. It's 12, 24, 33 when they get there. They're there past 12:30. Remember, Ms. Mason and Ms. Nagel said they're there about 5 minutes and then they go. It's not exact, but about 5 minutes, they said. So there's about 2 minutes left for John O'Keefe. And what are they doing in those 2 minutes? What are the last 2 minutes of his life that he can remember that would be open to him? They're arguing. They're arguing. They're arguing. And we know they're arguing because Ms. Reed tells us through first responder Becker. She was sad. Remember, he sees her in the back of the ambulance and he's trying to calm her down. She was sad because her last moments were arguing. They're in an argument. That's why they're not going in the house. But John O'Keefe decides to get out of the car. And we know because the dome light goes on. That's what happens when you open a door. Whether he's bent down, he's standing outside or on the other side, the dome light is on. And then you see the data. John O'Keefe begins to move. 12:31:56. It's the first time he has moved since they got to the flagpole, and it will be the last time he moves in his life. And he moves for 20 seconds. Ian Whiffen said that the satellites, they move, they reconnect, they pull information. He's no longer on high frequency data because waves are shut off. Now it's more random, it's low frequency. We would never suggest, and Mr. Whiffen did not claim, based on location data alone, at that point, you can tell exactly where John O'Keefe is. What he said is it was readings all night. The bullet is always near the flagpole. That doesn't mean he was always near the flagpole. He could have moved. He could have moved in the circles and come back. Location data is consistent with him never leaving the flagpole. But that in itself is not enough. But there's more. There is more. There is the healthcare data. There is the temperature of the cell phone battery. And so he moves for 20 seconds. It turns west. It does not say he walks to the house. That's not what the data says. It doesn't say that he goes straight line and he walks over to the door. In fact, could he even get to the door in 75 feet? Could he get there? Because when the investigator for the defense testified, he measures from the driveway. He never stopped at the driveway. He never measures from the flagpole. He never measures from the flagpole to the garage door. So this fantasy that somehow he walked in the garage, even though there's no evidence, there's no witness, there's no data. 20 seconds of his life, and he moves. And healthcare data registers his steps. It could be pacing. It could be a straight line. It could be shaking the phone. We don't know. We don't know. We don't know everything. We don't know every little detail and every little second. We don't have to. That's not doubt. That's not reasonable doubt. We know for that 20 seconds, he's moving. And in that 20-second window, when he moves. He has his phone and he looks down, 12:32:09, he sees a text message from his friend, John McCabe. And he looks at the text message and he closes it. And then it happens. We know from the uncontroverted data from that black box, we know that Karen Reed, after he gets out of the car, drives away. She drives for at least 33 feet away from him. He's back near the flagpole. She's gone. It's over. Whatever argument is over. Whatever anger and flame has been dispassioned, she's moved on. He's separate from her. He's safe. And then she makes a decision. That's what this case is about. Then she makes a decision. She could have driven home. She could have broken up with him. They could have talked about it the next day. Or like knocking on the door, like Kaylee said, getting the last word. She doesn't drive away. She takes that 6,000-pound Lexus and she makes a decision. And the decision is that she steps on the gas after banging it into reverse. Before we talk about what happens next, I want to talk to you a little bit about the charges in this case. And I hate to digress, but it's important so we really understand what we're talking about here. I have no authority to talk about the law in this case. The Honorable Judge Cannoni will do that. But I want to talk to you a little bit about the charges. Don't rely on my interpretation of the law. It's the judge who has that special power. But I want to explain to you a couple of things so when you think about what happens next, you can really assess the facts of this case with the charges against Miss Reed. She is charged with second-degree murder. It sounds ominous, it is. It's a serious charge, second-degree murder. When most people think murder, they think shooting or stabbing somebody. It's natural to think that. Second-degree murder is different. It's not first-degree murder. I told you at the beginning of this case, I told you that we were not going to suggest or try to prove that Miss Reed intended to kill John O'Keefe. That was never part of this case. We're not claiming that. I told you that we were not ever going to try to prove that she even intended to hit him. We never suggested we would try to prove that, and we're not trying to prove that she intended to hit him. We're not. What we are obligated to prove and what we have proven from the evidence in this case of second-degree murder is that she intended an act, and that is putting the car into reverse and heading back towards John O'Keefe. She intended that act. The question then becomes, did her conduct create a clear, plain, strong likelihood of death? Late at night, dark, beginning to snow, under the influence of alcohol, knowing where she stopped and left him after an argument, heading back in reverse to the exact spot or right near where she left him at over 24 miles per hour, accelerating at over 75%. You need to ask yourself, are you convinced if somebody does that, does that create a plain and strong likelihood of death? And if there's no doubt in your mind that she intended to hit that accelerator in reverse, and that conduct will create a clear and plain likelihood of death, then she is guilty of that crime. Whatever the label is, she would be guilty of that crime. Now think about this. Let me give you an analogy. If somebody, maybe a teenager, someone young, impulsive, is on a bridge and they see cars going by and they have a boulder and they want to throw the boulder off, they're not looking to hurt anybody. They're not meaning to kill anybody, but they throw the boulder off the bridge because they want to see the car break, the thrill. And when they throw that boulder off the bridge and it comes down and lands on the car and there's somebody, passenger, anybody in that car, and it then goes through the roof and kills the person in the car, do they intend to kill that person? No, they were trying to have a thrill throwing the rock. Did they have the malice to want that person dead? No, they didn't. But that would be an example of second-degree murder. When you take a boulder and throw it off a bridge, there's a plain and strong likelihood of death. When Karen Reed, in the midst of that tension and fight, after she drove away and was gone, disengaged, when she came back for the last word, in the darkness, the beginning of the snow, under the influence of alcohol, and decided to stop her Lexus, decided to put it in reverse, decided to accelerate 75% in the exact same direction of where she left him, and then hit him, and he died. I suggest to you that is second-degree murder. The other charge, operating under the influence of alcohol, manslaughter. It's different. It's a totally different and separate charge. Was she under the influence of alcohol? And then secondly, did she operate her Lexus wantonly and recklessly in a way that would very likely result in serious injury? When you're under the influence of alcohol and you drive a 6,000-pound Lexus in the heat of the moment at the direction of where somebody is, whether you intend to hit them or not, I submit to you that is wanton, it is reckless. And any reasonable person would think it's very likely that serious injury would result. It's not a matter of intending to kill. It's not a matter of intending to hit. It is the conduct of the operation and the risk that is created. And so those two charges are two of the three. The three is leaving the scene, knowingly causing death. And we'll get to that. So now, sadly, we need to get back to 34 Fairview Road where we left. We know from the text stream data that she drove 33 feet at least, because it only picks up a 10-second window. And when it starts to pick up the data, we know she's driving at a speed. So it's more than 33 feet. We just don't know. And then when she comes back, she covers the 33 feet and 50 more. 80 feet. 80 feet. Over 80 feet. Now, nobody has ever suggested, even Dr. Welcher, when she collided with them. This data doesn't tell you collision. It's a 6,000-pound Lexus. It's a 216-pound man. It's not going to show a blip. It could have been in that 10-second window. It could have been 2 seconds after. It could have been 4 seconds after. But it's in that pocket of time, and we know it. We know it because when you reconcile the data with the phone, that 20 seconds is in the same window of that 10-second window coming back. So even if it's a couple seconds later, 4 seconds later, whatever Mr. DeSorbo wants, he stops moving. John O'Keefe stops moving forever. Forever. Have slide 6, please. You'll get to see this more closely, and you can probably see it where you're sitting, but there's important data. Data doesn't lie. And you will see acceleration, 75%. You will see speed, 24 miles per hour backwards. You will see distance, over 80 feet. That's what you're going to see in this data on that night. Anger, although not necessary in any of these charges, anger can be inferred for somebody to come back that hard, that fast, that reckless, that obvious, likely to create a plain and strong likelihood of death. That data tells a story that can't be changed, can't be attacked. ARCA, they did some crash tests on me. You know what else they do? Text stream data. There's nothing about that data that is uncertain. Nothing. Take that down, please. When Ms. Reed hits John O'Keefe, hits John O'Keefe, collides with John O'Keefe. We don't know if he went in the air a foot. We don't know if it was how much of a clip it was. We don't know if he stumbled back, but we know there's a collision. There's no doubt there's a collision because her taillight's all over the yard. It's all over the yard. And when he falls back and he hits the back of his head, his basal fracture, he's then lying there helpless. When Miss Reed leaves, she leaves behind tons of her taillight all over the yard. All over the yard. It's called the debris field. And you've seen videos. You can't replicate the exact contact. You can't because you need where the person was hit, how fast the person was going, but you know what happened because when you look at the debris field, when a light is broken, it's no different than what was on the front yard. It's no different. She leaves him behind. She leaves her taillight behind. She goes home. And on her way home, you know she's still angry. You know she's still angry because she starts leaving him voicemails. Slide 7, please. Healthcare starts at 12/31/56, 12/32/04 to 12/32/12 is the data which is adjusted when you reconcile the clocks and the Lexus. 12/32/09 is when Mr. O'Keefe closes his phone after looking at Jen McCabe's text. 12/32/16 is his last steps. Mr. Disorder says that red range should move a little bit, 2 or 3 seconds. They can move it 4 seconds, 5 seconds. It doesn't matter. It's all in the same window. It doesn't change. We could have slide 10, please. Can you play that, please? Thank you. Each one of those pegs represents 10 feet. You can't place that car where it was in front of Fairview. You just can't. The data doesn't tell you that, but that tells you the movements of that car. Now, as John O'Keefe sadly lays on the ground, abandoned, you're going to have to ask yourself a question for charge number 3, leaving scene knowing somebody was injured and then died. You're going to have to ask yourself, is there evidence that Miss Reed knew that she had hit him? Don't need to prove it for murder 2. Don't need to prove it for OUI manslaughter. But for the 3rd charge, Commonwealth has to prove beyond reasonable doubt she knew she hit him. We weren't there, but there was an eyewitness. There was a guide. And that eyewitness tells us that she knew. And that eyewitness is Karen Reed herself. She tells you that she knew. We have slide 8, please.
Could I have hit him? Did I hit him?
How could that have been? I mean,
I don't know what that could have been. It was howling wind. I had YouTube blasting on the stereo. And I thought, did he somehow try to flag me down, which was the reaction I was hoping to garner as I slowly pulled away from the house. Did he come up and maybe trip or bend over to pick up his cell phone and I ran over his foot and then he passed out drunk? I mean, I didn't think I hit him, but could I have clipped him?
When she left Fairview and left John behind, she didn't think he was mortally wounded. But she knew she hit him. She knew she hit him. And so when she made her way back home, not only did she leave debris field all over the front lawn, but she took evidence with her too. Hair, DNA on the taillight, and she drove back to John's house. And she started calling on the way back, 12:33, just a minute and a half later. And then her messages show her anger. You see, this was John's fault. This was John's fault. And her phone calls tell you about the tone and the destruction of that relationship. 53 phone calls that night. 53 phone calls. Not one to 911. Not one to Jen McCabe, please go outside and try to help. Not one to a hospital. Not one to anybody but him. 53 calls. Slide 12, please. Can you play voicemail 1, please? The calls keep coming. Cell phone temperature, 72 degrees. He's been outside now, not moving, on that cold, hard ground with his cell phone under him. The warmth of his body, the cold ground, 72 degrees. It tells you the story. As this temperature plummets and that cell phone battery is compromised, so is John O'Keefe. And him and his cell phone alone on that yard. 66 degrees at 12:45. It is plummeting. Ian Whiffen's taking a phone and putting it in a freezer, not a same analogy. The idea that means that John O'Keefe was in the house, absurd. 66 turns to 61, it's 12:53. 48 unanswered calls from the defendant. He's not in at a party. He's not wrestling with Brian Higgins. He's not in a fight. If he's in a fight, his cell phone would be moving. There would be healthcare data. There'd be steps. If he got into the house in 20 seconds and his cell phone is found under his body the next day, then how would he get back outside? There would be more steps because this phone is working. The data is the data. There's nothing wrong with it. It's registering everything. The temperature, the movement. He doesn't go in any house. He can't go in any house. His phone never moves again. Voicemail number 3, please. Listen to this.
John, I'm the only fucking kid. Nobody knows what the fuck you are, you fucking pervert.
Did you hear that? Nobody knows where you are. It is 12:59. John O'Keefe has been on that lawn for about 27 minutes. She hasn't called anybody else, hasn't spoken, has no information. Nobody's called her. You'll see her phone records. And she says, nobody knows where you are? She knows. She knows. Nobody does know where he is. Except her. Except her. Why is she asking nobody knows who you are? She is starting to get panicked because she knows she hit him. Not suggesting she meant to kill him or for him to die, but she knows she hit him and now he's not responding and she's getting nervous and she's getting anxious and she's leaving call after call after call. He's not answering. He's not calling back. He's not even picking up the phone. And we know what's happening at this point. Panic, drunken denial, it's setting in. And so then we see the healthcare data from Miss Reed's phone. She doesn't move after a little after 1 o'clock. She could be sitting, she could have fallen asleep, but she doesn't move for a while. But she wakes up. She wakes up early the next morning. You can take that down, please. And when she wakes up, she doesn't call Jen McCabe and say, where's John? She doesn't call Brian Higgins, has his number, has been texting with him. Hey, was John at a party with you? Did you see John tonight? She knows exactly where she is and she's frantic. So she wakes up Kaylee, that young girl at the time, and she says, she's panicked, she can't understand what she's saying. Call Jen McCabe. Call Jen McCabe. Why is she calling Jen McCabe? She calls Jen McCabe. You know what she doesn't say when she calls Jen McCabe? When did he leave the house? What happened last night? No. She calls and says, I left him at the waterfall. I left him at the waterfall. See, now it's gone from panicked to self-preservation. I left him at the waterfall. And Jen says, left him at the waterfall? He saw you in front of the house. Click. Hangs up. Hangs up. So then she calls someone that she doesn't know very well. She calls Kerry Roberts. But now she has to pivot. because someone has seen her in the exact spot that John will be found soon. Whether she's the first one there or somebody else, John will be found. Maybe Lucky missed him. It's a snowstorm. You can't see, but someone's going to find him at some point. So she calls Carrie Roberts. It's no longer she left him at the waterfall. She pivots. And she calls, Carrie, Carrie, Carrie. John's dead. I think he got hit by a plow. Why do you think she chose those words? Why did she choose those words? Because she knew that there was a collision with a large motor vehicle, and she had to substitute her 6,000-pound Lexus for another big vehicle. I think he got hit by a plow. And so now we have the introduction of Jen McCabe and Carrie Roberts. Phone calls that they probably never, ever wanted. A worse nightmare to get a call like that for what's going to happen, what they're going to see, what they'll never be able to forget. But because the defendant is John O'Keefe's girlfriend, they wake up in the middle of the night in a blizzard out of their kindness, their loyalty, their devotion to John O'Keefe. And when she calls them and tells them that she wants them to come out, this soccer mom with a perfectly normal life gets drawn into this whole farce, and she answers that call. She gets out of bed. The spirit and kindness she displays to put herself in that position because someone asked for help, because that's what good people do. Carrie Roberts didn't know Jen McCabe. They both knew John. They met each other once years before. Carrie Roberts, separately at that time, answers the call, gets out of bed, drives to go help, because they have a common denominator, a common bond, John O'Keefe. And so you hear and see at 5:07, the defendant leaves Meadows. She leaves. And Kaylee is behind waiting. And you see her back up, and Judd Welch just showed you all of those demonstrations where you could see the unsettled snow in the back, and after the bump, you can see the pieces missing, no taillight. There's no taillight on the ground, all the white snow. There's no crack, there's no break. It's a nudge. It's a nudge. But the taillight has already been broken, because when you look at the video, not one little piece, it's still framed, little angle with the light, the brakes are, you take a look, you'll be able to slow it down. You'll see the exact same piece is missing, because it's back at Fairview. That's why it's missing. It's not there, it's back at Fairview. And then she leaves at 5:07. She gets to Jen McCabe's about, 5:35. 28 minutes. It's about a 10-minute ride. Where did she go in 28 minutes? Where did she go? We don't know. We don't have data for that. But we know when she gets to Jen McCabe's house, she is panicked, frantic, out of her mind, screaming, waking everybody up. Jen McCabe comes down, can't understand her, going out to the car to try to console her. Why is she so frantic? Why can't she speak? Why can't she say a word? Because John went out and had a drink and fell asleep on a couch? Because John would maybe be cheating on her? What is causing this extraordinary duress? Did she stop somewhere on the way by? Did she just see death? Carrie Roberts comes, take charge kind of person. She pulls him behind. She sees the broken taillight in Jen McCabe's driveway, and she decides she's going to commandeer this. We're going back to Meadows. You're going to follow me, leave the car, I'll drive. At this point, Jen and Carrie don't know each other. They've only met once. And they go back to Meadows. They obviously don't find John because he's back at 34 Fairview. And then they start their way towards 34 Fairview. They start driving towards 34 Fairview, and they're looking. And you heard from Carrie Roberts, Jen McCabe, they're looking out the window. They can't see a thing. The snow, the blizzard, the weather, the darkness, they can't see anything. And they're driving, and they decide they're going back to 34 Fairview. And this is remarkable. This is remarkable. When they start their way past towards 34 Fairview, they get close. And when they get close, they can see nothing. But the defendant screams, "Stop, let me out." And they look around and they say, "What? Let me out, let me out." She does not see John O'Keefe. She knows where he is. She knows exactly where he is. She knows where to find him. She knows where to expect to find him because she knows where she left him. She tells us. Slide 13, please.
Driving Jen's in the passenger seat. And I described this to everyone, so you probably heard this before, but John looked like a buffalo on the prairie. It was just a lawn and a heat that it wasn't a bush or a hydrant or a dog. It was a weird shaped lump at that time in those elements. And I was looking to find him on the side of the road. I was expecting I'd find him.
Thank you. A weird shaped lump in a blizzard, and you equate that to John O'Keefe? A weird shaped lump, not like a bush, and that is John O'Keefe? She tells us she knows where she left John O'Keefe. And so they go over to Mr. O'Keefe, Kerry and Karen, and she's upset, there's no doubt. I am not for a second trying to deprive her of the unrest and the trauma that is happening at this scene. Doesn't change what happened before, but I appreciate the trauma. And they're trying to help him. And guess what happens when they first move him around 603, 604? Ian with him. Data. The cell phone battery gets the cool air, presses on the battery, the cell phone battery drops. Healthcare data, he has not moved since that 22nd, hasn't moved. They start shaking him. You're going to see, when you look at the records, that healthcare data starts to move. He's been there all night. All night. Nobody else. Her. And so when they try to help him, she says something that is remarkable. She says, there's a piece of glass stuck in his nose. And she plucks it out. And she says when she plucks it out, blood spurts out. We'll talk about that in a couple minutes. Remember that. Piece of glass, pulls it out, blood spurts out. That's what she says. As they try to help John, Jen is calling 911. They would like you to believe there's a conspiracy. That the glass that's found in Mr. O'Keefe's body is somehow from inside the Albert house. The glass, well, you will hear in the clips, if we don't play it, you'll have all the clips with you. She talks about the fact that he took her glass. He took the glass. She says it. So the Albert house, they don't need to give glass. He already has the glass with the straw that's later found on the street, by the way. That's what happens on an impact, things move. The glass comes with him, lands near his body. Debris field moves past him. Shoe, hat, straw. Jen McKay makes a call to her sister, and they say because it registers 29 seconds, a Cellbrite record is not the same as a call detail record. There's no evidence. It was a conversation. No lights go on. There's no conspiracy. You can call somebody. It can ring. It can go to voicemail. They have no evidence, none, that there's a conversation between Jen McKay, the person who was ripped out of her sleep to come help, and her sister for some grand conspiracy. And so what happens next is traumatic. Kerry Roberts and Jen McKay see their best friend prone, lifeless, frozen on the ground, and they're living this torment because somebody brought them into this. When they're trying to help John, there is not one suggestion from anybody that John ever went into that house. There's no reason to go into that house because John was never in the house. Not one time does anybody say, what time did he leave? I thought he went in there. Not even a whisper of it because it never, ever happened. When they find their friend John, he's not 20 feet off the side of the road like Mr. Rentschler or Mr. Wolf thinks. He's right there by the side of the road, close by the curb. Could we have slide 14, please? You can see there's Kerry Roberts' vehicle. And then on the left, you can see where they're working. Right off the road, that's not 20 feet. That is a clip, a stumble, and a fall. And remember when John O'Keefe fell, there wasn't snow. It was just the beginning of a dusting. It was the cold, hard ground. Remember what Dr. Isaac Wolf told us about cold, hard ground? Causes this type of injury all the time. All the time. If we could go to slide 16, please. Remember the glass in the nose? The glass in the nose. See on the bottom left, that's where the Canton Police Department found the glass that he took from the car, from the waterfall. And then exhibit 195, matching glass. On February 3rd, the matching piece of glass was found on the street. The matching piece of glass, the glass that was found with Mr. O'Keefe, was found on the street. He didn't fall back 8-10 feet from the road. It broke, and then it shattered and went to the street. I would suggest to you it broke at the time of the collision, and he carried the glass with him, leaving the evidence behind, a trail to memorialize what happened to him that night. Remember the straw? I asked you to take a look at that picture and leaving the waterfall 1212, the black straw in the drink on the street. Collision, glass, nose, straw, back, hits his head. You play the clip on the left, please. 59.
So when John got out of the car at Brian Albert's house, he took my full vodka soda, which is sitting in the cup holder.
169, please.
So John's laying there, his left and his right, and I approached John from the left. That's where the street is. And he had a piece of glass, like perched on his nose, like just wedged like a splinter would be. And it just pulled it, and as soon as I pulled it, it just gushed blood down his face.
Thank you. 911's called by Jen McCabe. She's not hiding from anybody. She's trying to help. She's bringing attention to the situation. And when 911 comes, we have first responders. These people are heroes. Some of them, you've heard from some of them, they were born to help people. That's what their life is about. The detail on all their mechanics, getting to work 2 hours early in the middle of blizzard so that you're there on time so you can help people. These are the core of our community. Mr. Nuttall, this is what he does. He rushes to go help. He's the first person on his knees. He doesn't know this person from anybody, but to him it's another human being. This is his passion. Katie McLaughlin, first responder. This is not just a profession, it's her life. Yes, she knows Caitlin Albert. Do you think she went there that night at a party and set up a murder and came back? And so they tell you what happens at the scene. Some things hard to remember, some things people will never forget. When you're in a traumatic incident, sometimes it's something you'll never, ever forget. And Timothy Nuttall remembers speaking to the defendant. I hit him. Remember, he's on his knees. What happened? I hit him. She is now coming to terms with the moment. Her fear is realized. She hit him, she clipped him, she didn't think he was mortally wounded. She panicked, she can't come to terms with it, so she has to bring people with her to face it, and now she's facing the reality of what she had done. And her emotion is overwhelming. I hit him. She speaks to Miss McLaughlin. I hit him. Not did I hit him, could I hit him, perhaps I hit him, that was earlier. Now, she's recognizing what she did. I hit him. And these people are making it up. Anybody that says anything adverse or inconsistent or inconvenient is a liar or a perjurer or in on a conspiracy. Or is it that these good people who went there for a total stranger to do their duty to help happen to remember that she admitted what she had done? I know that doesn't reconcile with the boogeyman Proctor and the bad government. I know it doesn't reconcile with no DNA on this piece or that piece. I know it doesn't reconcile with everybody setting up the girl. I know that doesn't reconcile. But the reality is, you have independent core people who hear her say, I hit him. And the attempt is to portray everybody as a liar. But you don't have to rely just on these good people, although you should. You should. You don't have to, because we have a guide, and it's Karen Reed. Slide 17.
So I must have said was, did I hit him? I know I said I hit him, but did I really say this many times as law enforcement's claiming I said it?
Thank you. I know it doesn't fit the theme, the theory, the story, but she tells you herself. She endorses those good people exactly what they had heard. She tells you herself she hit him. It's undeniable, it's unmistakable, it's inconvenient. But the truth has a way of seeping up to the daylight. It can be oppressed and suppressed and pushed down and covered and twisted, but it rises. It rises. And it is not a coincidence. There's no coincidence that Mr. Nuttall and Ms. McLaughlin hear exactly that. She tells you. And Jen McCabe, when she's sitting next to or standing next to Ms. McLaughlin, she tells you that she saw or heard the same thing. Remember what happened to her on the stand when she had the audacity to say, I heard her say it? What happened to her? This woman who never even wanted to leave her home that day, pulled out into a storm to see her best friend dead. What happened when she had the audacity to say that? And now we know that the defendant herself said the same thing. And the funny thing, the ironic thing is, you will see in a photo when Ms. McLaughlin, firefighter, was speaking to the defendant, Ms. McCabe was next to her. Ms. McCabe was trying to protect her, trying to shut her up. Don't talk, you're upset, stop saying crazy things. The villain of this story was trying to help the defendant from incriminating herself. The irony. Can we have slide 9, please? This is the battery temperature. You're going to have a chance to look at it. If it wasn't so tragic, it is interesting. It is interesting if you like data. The 29, 12, 13, they're leaving the waterfall 82 degrees, 12:22. In the car, 77 degrees, 12:37. About 3.5 minutes after the defendant collides with John O'Keefe, it's starting to go down to 72, 12:45, 66, 12:53, 61. And you see it drop and steady off at 1:36. Remember, cell phone battery under him. John O'Keefe either struggling for life or he's passed. And the blood is still warm, either way, under him. Doesn't move again until 6:06. It drops down 7 degrees because the women are pulling on him. The cold air is hitting the battery. What happens at 6:15? You're going to see the video. You've seen it, still photos. Kerry Roberts goes over, picks up the phone. Not only does she pick up the phone, she puts it in her pocket, and then 20 minutes later, the next meeting, the temperature rises. That's not convenient. That's not a coincidence. That's fact. That's data. And then the vote is passed, put in a warm environment, and it raises up. 6:15. How can someone conspire to pick up a phone on the side of the yard that was under Mr. O'Keefe's body at 6:15 and know the battery temperature was then going to rise? Not only did the battery temperature rise, when you look at the healthcare data, at 6:15 when she picks up the phone, you know what happens to the healthcare data, right? It starts to move. It's data. It's data. So, while they're going through this duress, the defendant asked Jen McCabe for yet another favor. Look up hypothermia. Find out how long it takes for someone to die in the cold. And there's Miss McCabe in her winter jacket, soccer mom, trying to help. She has MS. Her hands aren't working. She's trying to type in what's happening during that time. It's a frantic scene. She tells you that. The defendant then wants to run back to the ambulance, so she goes with her, never finishes or completes the input. And then she tries it again. At 6:23, at 6:24. That's what this woman did that night, that morning. Not only for a friend, for her. For her. That's what she did. And what happens to her after? Because the timestamp, when you open the timestamp, it's at the time it's open, and she's in bed at 2:27 looking up Hockomock Sports because she is so interested in the kids' sports, and that timestamp stays open. And she goes to that tab the next morning when she puts in how long to die in cold. And that is being portrayed that she's in a conspiracy. She gets vilified as a murderer, a soccer mom who came to help. It took Ian Whiffen 5 minutes to show you a live demonstration on how simple that works. That she's not deleting anything. Jessica Hyde told you it's automatic deletions over time. You usually can't delete that information. That's not a click and swipe like the good Dr. Wolf from Arca knows how to do. This can't be erased. But they still hold on to this. As they argue to you and all the injustices that have been done, they tell you, they want you to believe or take a flyer on the fact that she looked up how long to die in the cold at 2:27. It is an absolute contrary to the science. There's no basis to support it, but they stand here in front of you. Why? Because every time they say something like that, you look the other way. Don't look at her. Look the other way. 2:27, look the other way. Don't look at what she did. Former Trooper Proctor, look the other way. Don't look at her. Every time they make those, oh, she got the glass from inside the Alberts, maybe in the basement. Look the other way. Don't look the other way. Look at the facts. Look at the data. And it all leads to one person. There's no grand conspiracy. It leads to one person, the defendant. And it's not just the data and facts. It's her herself. Let's talk about Mr. Proctor. You were invoked with this emotion early in the opening that this is a cancer. That's a tough word. Try to evoke that primal reaction, disgust. I'm not saying you shouldn't be disgusted by the text messages. You should. You should. They're not defensible. I don't stand here and defend impropriety. I don't. But that doesn't change the physical evidence, the scientific evidence, and the data. He was terminated. He paid a penalty. He was held responsible for what he did. He should have been. He should have been. But that doesn't get a free pass. That doesn't change the facts. It doesn't change the physical evidence. It doesn't change the science. It's unfortunate. It's distasteful. It's dishonorable. Remember, Trooper McKennick was asked, was the investigation with honor and integrity? And he said it was. Was Trooper Proctor's effort honor and integrity? And he said it was integrity. But he never said honor. That's a man of honor. Military service, dedicated to his country, highest level of clearances to the President of the United States, now a state trooper. He would not say that Trooper Proctor was honorable. Because he wasn't. He wasn't. But that does not change. It doesn't create a conspiracy. Doesn't invent a dog. It doesn't make somebody in a house something they're not. It just doesn't. When you read those text messages, they're hard to look at. It's unfair. It's unfair. And if there's a penalty more than being fired, well, maybe that penalty would be deserved. But it has nothing to do with the justice in this case. It just doesn't. There's not one piece of evidence, not one, that we can look at and say, this was tampered with. This was planted. This was distorted. Remember when we introduced the taillights at the beginning? I didn't introduce 3 of the taillights, but then the defense did, so I put them in. Those were taillights that were only found by Trooper Proctor. I did not put that evidence in. Understanding those text messages and appreciating the disdain one might have for his comments. Not that there was any evidence of tampering, not that there was any evidence that it was not true, but I didn't put that evidence before you because we didn't need Trooper Proctor in this case. We don't need Trooper Proctor to prove this case beyond a reasonable doubt. That's why I didn't introduce that evidence to you. Now, there's been a lot of talk about planting of taillight. We know the taillight wasn't planted because Trooper Buchanan and Mr. Proctor did not go down to Dighton to see Miss Reed until later in the afternoon. We know from the 507 video, we've seen that. We know the taillight was already missing when she's leaving the driveway. When the good Canton police detectives went to do a wellness check to care for those young children, and they went to the house inadvertently, they didn't even know it, the dash cam captured the back of the car. The taillight packed with snow is missing. It's already gone. It can't be planted. At this point, Trooper Proctor's still in his pajamas. He's not even on the case. He's not even on the scene. He hasn't been near the car. And then the Dighton videos themselves, when you close it, you can take it at an angle and it moves, but if you get the right angle, you can see it's missing. It's gone. Can we have slide 18, please? .507. You can play any angle you want, but if you look at this angle, it's gone. You know, plant is already gone. You know where it is? 34 Fairview Road, on a debris field. January 29, 2022, page 23. Look at the right-hand side. Look at the left-hand side. It's packed with snow. It's gone. It's gone. And the same thing when you do the videos, it's a different angle, a little smaller, but if you play that and watch the Lexus go up and down and slow it down, you'll see it expands. It's gone. So when you have Dighton Officer Barrows come in here and try to tell you what he saw in the salad bar, couldn't have been it. You got to ask yourself, what interest does he have coming in here in this case? A lot of attention on this case, a lot of people watching. Comes in after, of course, driving all the way out to the defense attorney's hotel to meet in a conference room so he can get a subpoena. He spends 2 hours driving up and back so that he can conveniently get a subpoena that tells him to appear, which he could have got by fax or in the mail. And so when he comes in, what he says is, that's absolutely not what I saw. Absolutely not. And then he claims at the last time he testified, he had made the same statement. I showed him his transcript. And did you see the redness creep over his face? He never said this before. In fact, he testified to the opposite. And so he sits on the stand with a new story after a meeting. We don't know why, but then I show him that bottom right photo with the snow, with it missing. And I say, is this the way it looked? It's, of course, before the snow melts out in the salad port so that you can see it unexposed. And he says, yes, he had to agree. This taillight was gone. There's no boogeyman. There's no plant. There's no Higgins at the salad port. There's no one tearing out pieces. In fact, remember I played you a clip and you'll have it where the defendant says, I was picking out pieces, it was crashed in, the bulb was showing when I was showing Kerry and Jen when they went back to Meadows. If you don't remember, listen to that clip, you'll hear it. Unfortunately, there's no ring video when they go back to Meadows. There's a ring video when she leaves, there's no ring video when she gets back. And so now when we're trying to look the other way, we want to find a dog bite. So enter Dr. Russell. Dr. Russell, according to her, nice woman, nice doctor, very accomplished. I respect that. She's the only dog expert in the world. The thing is, we know no idea what that expertise means. She volunteers for the job. She wants to be here. She's on her profile, but she can't explain the methodology. What are you looking for in a dog bite? She can't tell us. It starts a year ago that it's claws, it's teeth, and then it's claws, then it's teeth, then it's I don't know. And then when you look at each of the different parts of the abrasions, she says, well, I can't tell if I look at each one of them, but all together it's a dog bite. It's a dog attack. That is the masterful expertise that the defense has bragged about bringing in. Dr. Russell telling you, because she says this is a dog bite. She has never been in a forensic situation where she's looked at a wound and identified it as a dog bite before. This is the first time, the only time she's ever done it. And what she says is these are not punctures. Punctures means it goes into the skin, a wound. There's no punctures. And she's sure because she's an expert, so you should rely on her because she's coming in saying she's an expert and she's being presented. Yet, after saying there's no punctures, Dr. La Posada comes in and she sees punctures everywhere. It's an animal attack. It's a dog. How is it? No method, no methodology, no history of this, no prior testimony that we know of other than arbitrarily what she says. And she says the exact opposite of Dr. Russell. Why is that? How does that happen? So obviously, there is no science to looking at an abrasion and saying where it came from. They give us no detail. They give us nothing that we should rely on. They contradict each other. It's just to get you to look the other way. And so we have now the issue of the defense has said over and over again, there's no collision, there's no collision, there's no collision. And they had a number of witnesses come in to try to say that. And they point to Dr. Scotty Bello, who works at the medical examiner's office. She tells you that she doesn't see injuries consistent with a collision. She's looking at this case for 90 days. 90 days. The evidence in this case did not stop. It continued for 2 years. She knows nothing about the data, nothing about the black box, nothing about the interviews of Miss Reed. She doesn't know about the DNA. She doesn't know about the shards in the arm or in the clothes. Strike that, in the clothes. She knows nothing about that. So in 90 days, she didn't see any lower body injuries. She didn't see any lower extremity injuries, which are very common in car collisions. But that doesn't mean it didn't happen, because she, in 90 days, saw a fraction of the information. A fraction. And we know now, argument back and forth for days about lower body injuries, the suggestion is a car accident can affect everybody differently depending on the angle, the scope, the speed. Some people can get plowed over by a car, have no injuries. Some people can get touched lightly and have more injuries. And there was the debate about no lower body injuries. Well, ARCA dispelled that in their dummy test, that you can have a collision with no lower body injuries. They did that for us. Thank you. And so the idea that at the time, in 90 days, that she doesn't have enough information to say consistent with a car accident doesn't mean there was no car accident. Let me talk a little bit about ARCA. I don't want to waste too much time with them. What expert who's supposed to come to you, they're not the arbiter of truth. Their opinions weigh no more than yours. Your common sense has more value than an expert's opinion. Their job is to assist you, to explain what their expertise is, so that it's a tool for you so that you can make a decision. That's objectivity. We've heard words like confirmation bias, objectivity. Mr. Wolf got on the stand, and before we even started, you have to ask yourself, what expert has a court order for text messages and then deletes the text messages? What expert, what objective expert uses Signal, an encrypted app, to communicate about the case? Never used it before, hasn't used it since. And so when he did his tests, he used a lower weight arm. Wasn't trying to bash him, wasn't trying to insult him, tried to get him just to recognize that a 9.38 pound arm is less weight than John O'Keefe's metric, which would be 11.8. That's all. And because it's a lighter arm, it takes more speed to create the same damage. I don't know science, I don't know math very well, but that's basic. It's basic. And he fought me over and over again. Did he seem objective that he was trying to help you? Because Dr. Renshaw came in the next day and said, well, you have to adjust for that. That's all I asked him for an hour about adjusting, just like Judge Welcher adjusted. Do you adjust it? And he tried to talk to me like I was making something up. His own colleague had to admit it. Now, it's funny, he admitted it before he got through his credentials. No sequestration order violations. Nobody was coaching him, but he knew enough to come in at the beginning and get right on that point. And speaking of sequestration, remember Dr. Russell on her limo ride over? If Brendan asks you a question, make sure you ask for a transcript. Impede the progress. Slow down the questioning. Interfere. Sequestration orders is so there's fundamental fairness for all witnesses, not just some. And so what happens with Dr. Renshaw, we don't know, but we do know he comes in here and he tells you that he was not getting information that was helping him the last time he testified. He insisted. I asked him 5 times, was he getting information that would help him in his testimony? Not from the defense, from his former employer. And he said, no, no, no. And at the end of the examination, he reads his transcript and it's yes, yes, yes. And he tells us that he's independent and objective. I asked him about a luncheon, not a big deal, just asking him about it. And he says, I have a sandwich and I stand in the corner until I remind him that we got video footage from a documentarian and he's in one of the scenes. And then things change. So when you talk about objectivity and who to trust, they can come in and say, Judge Welcher said this and that. It doesn't make it so. Judge Welcher, Dr. Welcher, never in any report, in any presentation, in any testimony to you, ever suggested this is how it happened. This was how his arm was. This is how his feet was. He was trying to show whether or not the orientation. Could this happen with the angle, with the height? That's all that test was. It was no more. But what they do is they reposture it, repackage it, and say it means this when it doesn't, and we're going to show you why it's not that, therefore we win. That's all that is. It's semantics. Judd Welcher, Dr. Welcher, never suggested that. And his work on text stream data, unassailable. And so what we have, inevitably, is we have a timeline that never moves, data that never changes, physical evidence that can't be put in that spot without a collision. We have, inevitably, proof, without any doubt, that on January 29, 2022, Ms. Reed was with Mr. O'Keefe, and she got drunk. She drank. She was 2 to 3 times over the legal limit. And they went to a party, an after party, and they were fighting. It was a relationship in decline, and he got out of the car, and he had a brief window of life left. And when he got out, and she drove away, she couldn't let it go. She got drunk, she hit him, she left him to die. It's that simple. We don't know exactly how this collision happened, but we have a good idea from the physical evidence, and we know that it happened. Can someone have a collision without lower body injuries? Could I have slide 19, please? You bet they can. We don't know if this is the body position. We don't know if this is the exact speed, but what it tells us, this is viable. Look at the debris field. Look at his turn. Remember his sneaker on that curb that got lodged against the sneaker? Mr. O'Keefe then falls back, hits his head, counter coup, left to die. Thank you. Ladies and gentlemen, there is no doubt what happened that night. There is no doubt who did it. You have a very difficult task ahead of you when you consider the evidence, and you consider the law. Very difficult. There are 3 charges. There is second-degree murder. Ms. Reed, when she chose to drive back at Mr. O'Keefe in that night with a 6,000-pound Lexus, in that anger, 75%, whether she meant to hit him or not, didn't mean to kill him, she hit him. Straight, it is a plain and strong likelihood of death. You would never back down your driveway if your kids were at the end of the driveway. You'd say, well, you're going to kill somebody? You would never do it because you would expect, if you drove at them at that speed, that someone would die. That's second-degree murder. OUI manslaughter, she's drunk, she was reckless. She doesn't even have to know she hit him. She doesn't even have to know she hit him. But she did. She did. And she left a man who was kind and generous and thoughtful. She left him alone. She left him alone to die. Could I have slide 22, please? He is not an it. John O'Keefe is not a body. John O'Keefe is not a buffalo on a prairie. John O'Keefe was a person, and he was murdered by Karen Reed.
Take that, thank you. All right, jurors, the next up is my instructions to you on the law. I'm not going to do that right now. You've been sitting for a long time. So I do have to tell you, even though you've just heard the closing argument, you cannot discuss this case even with each other. All right, so we'll send you back for lunch. It's going to be a shorter lunch. My instructions are long, and we want you to be able to get this case to start deliberations today. So I'm going to send you back maybe about a half an hour. Is that enough time for you folks? All right, so we'll give you a half an hour for lunch, and then we'll come back. I'll give you my instructions on the law, and then the jurors will go out to deliberate. I know there are 18 of you. we seat only 12 deliberating jurors, so 6 of you are going to be alternates. I can just tell you that, you know the odds, right? And I can tell you it's Mr. McDermott's least favorite part of his job is Sleuthie. So we'll do that this afternoon. Do not discuss this case to see the matter.
It's a half an hour. We're going to see the jury in a half an hour.
I can tell you it's this afternoon.
We get the fan, then we get back. Half an hour. Not a half a day, it's a half an hour.
Counsel, can I see you just a second?
Just a second. It's a half a second. Half a one. Okay, so most have left. All right, well, make sure it's live. How many times did he contradict himself in his own closing argument? That's what I was like, wait, you just said that you don't have to prove this, but then you said that for this you're going to prove that, and then on the other one you're like, she didn't do this, but then it's like she did do this, and then it was like Jen doesn't do this, but then she did do this, and why would she do it both ways? So it's like, what? So while that was going, I probably shouldn't even tell you guys this right after listening to Hank. Thank you, Crime Ghost. I'll check it out. You know what? I haven't checked my email for a while. I need to check my email. So I took the time to go and listen to and read some comments by some of the very pro Karen Reed did it. I'm telling you that they all think that that Hank did a fantastic job. You know, he tried to say that Welcher's credible, but not only does he say Welcher's credible, he calls him Shannon Welcher, which is Shannon Burgess, the man Shannon. He called him Shannon Welcher. I was like, what? That's two people. That's two different people. Yeah, so there's a few people that are live talking about what a great job Hank did and how Hank destroyed Karen Reed. Destroyed her, and then there's a couple in the Facebook. They said Hank did good. They did. They really did. And then beforehand, thank you, honey. Any chance you'll make me chocolate milk? I already had one. My husband just made me breakfast because I'm starving. Then so in the prosecutors podcast Facebook group, they're talking about that this is the day that Karen Reed goes to jail forever. Like that she's done. Hi, Ange. Yeah. Yeah, he did. Oh, then he was like, and then why wouldn't she call Jen? If she wants to know what's going on with John. Why doesn't Karen Reed call Jen? And then it's like, then she goes into the niece's room and she's all frantic and tells the niece to call Jen. Well, why would she have the niece called Jen? And it's like, you just said, why didn't she call Jen? What am I doing in that Facebook group? I don't know. I'm in a couple that I don't know how I'm not kicked out of them, but I don't really talk in them. So I think maybe people just don't realize I'm there. Maybe, I don't know. Cause I really don't Facebook a lot. I use Facebook more as like, to communicate with you guys, like in my chats or to just like research like stuff or see stuff. But sometimes you're just doing a good scroll. And I'll be honest with you, I used to really like them. And then like it became like unhinged. So I just was like, okay, I guess that was a bad call on my part. For Indiana girl for Brennan, you went nope. Well, you should, because you could go back and count exactly how many times he says one thing and then says the exact opposite, and then tries to say that like the defense is the one that's doing like the bait and switch kind of thing or whatever. And I'm like, no, you are talking out literally both sides of your ass right now in front of the jury. So let me go. Let's find some tweets that are interesting. Let me see. Actually, first, let me do this. Thank you. Love you. Did you make it or did Daddy?
I did.
Thank you. Okay, hold on. There was another video. Hold on, I'm trying to find this video that I wanted to show you guys. Maybe it's in my history. No. I don't know. I'm gonna have to look for it later, I guess, because I don't know where the video is. I'll have to try to find it for you. Okay, so let's go. Let's check out Twitter. So someone on here says if you don't pay attention to how like your feelings on Karen Reed, just pay attention to Alan Jackson and what an impressive and persuasive closing argument he did. That's a good lawyer doing good lawyering, possibly his finest hour on the case so far. Hold on. Can I share this one instead? No, I don't want to do that. Do I want to do that? Yeah, I'll do that. Here. Let's here, check this out. The closing argument showdown: Alan Jackson versus Hank Brennan. AJ hears the science. Hank puts a pacifier in his mouth. I fucking love it. Okay, so Microdot says it's not being shown on the stream, but for every point Alan, I think I told you guys this. I had read, somebody else had tweeted that earlier too. That it's why? Well, where's the picture of it? How did we not see that then? Did you guys see that? I didn't see that. So another thing for reasonable doubt was popping up on the screen. Dr. Welcher's recreation confirms the taillight was broken at One Meadows Avenue. Me at my cubicle after Alan Jackson's closing argument in the Karen Reed case. I think we all felt that. We all felt that. Karen Reed's father addresses the media outside the courthouse. Let's see. Is that this trial? Because he did the same thing last
I wish I wasn't here, but this is what corruption is all about. Just look at the injuries. They don't correspond to being struck by any vehicle. I want justice for John O'Keefe, but that may come at a later day. It's all about the science. You heard Dr. La Posada, you heard the ARCA witnesses, the scientists from ARCA who are hired by the U.S. Attorney, the Department of Defense. Sorry, Department of Justice. Check that. So, This is the final stage. Just catch Attorney Jackson on its closing. Digest it all. Take it in. Because someday it could be your son or your daughter. God forbid. Thank you.
Thank you.
Oh yeah, what a great Father's Day present that would be, as if this was done. Okay, hold on, of course.
You are muted.
You are muted. Okay, so she told the jury she's giving them a half an hour, but that was, I'm assuming that she's still going to give the attorneys a half an hour, so I would assume we're probably not going to be back for at least a half an hour. All right, let me come back over here. I have goosebumps listening to Alan Jackson's gripping closing in the Karen Reed. It's perfection. Me seeing Alan Jackson is trending, but it's for the Karen Reed trial. Today is your day to shine. Alan Jackson is phenomenal. No one commands a room like he does, and he knew exactly what he was doing, saving that photo of the taillight intact for closing. Masterful. Yeah, I guess I missed it because apparently it was up for a second, I think Grace Base said. Alan Jackson has a board / screen up for the jury showing all the reasonable doubt at each point he makes during his closing. This is amazing. And it looks like a crumpled piece of paper. Or is that just me? Because that's kind of what it looks like. Like a crumpled piece of paper and just keeps putting stuff on it. Like little Post-it note kind of things. Like they're just piling up. Because it looks like there's a whole bunch like behind here. You know what I mean? It was like note cards. Half an hour. Half an hour. It's official after Alan Jackson's closing. If you still believe Karen Reed is guilty, you're delusional or just a pathetic shill. Tell him, microdots. Puts Alan Jackson's phone number on speed dial in case I screw up. He's an amazing defense attorney. Alan Jackson, during closing arguments in the Karen Reed trial, called out Hank Brennan for his stunt of the hoodie. He called out all three prosecutors for allowing it to happen. Well done. So happy Mr. Brennan's hoodie stunt was called out publicly like this. He really made Hank look bad no matter what Hank did. It was, if you're anti-defense, it was probably something to really piss you off about Jackson. But if you're pro-defense, then you see what he did by calling him out on that the hoodie situation. He said, he won't address it. He won't address it because he knows he was wrong. So if he addressed it, he'd have to explain that he screwed up and that he had essentially lied to the jury. And if he didn't address it, then the jury would go ahead and just believe that what Jackson said about how he wasn't going to address it because he knew he screwed up. Like he couldn't. There was no coming back from that. Hey, Richard. That put me way back. I literally wrote down every single word he said in that line of stuff. Well, that's when I was like, I don't know how anybody's even going to clip this. It's like the entire thing was golden. This one's, I volunteer to serve as a juror when Alan Jackson is on trial after this murder. What?
So they spent nearly $400,000 of taxpayer money to hire someone to dress up and look like John and paint his arm blue. So they spent nearly $400,000 of taxpayer.
I think because maybe the Commonwealth is going to set him up for something, because that channel or that Twitter account is typically very pro-innocent, I believe. If Karen Reed is found guilty after this amazing closing from defense by Alan Jackson, the court system is screwed. The fraud that was attempted on you. Alan Jackson blasts the CW prosecutor's Karen Reed trial.
At the time. It had to be the, and even with 3 prosecutors, all 3 of them.
Oh yeah, there it is.
Sitting right there in the room at the time. It had to be the defense to correct that record, to bring out the truth. If we hadn't done that, what impression would you folks have been left with? That's more than negligence. That's dangerous.
That's dangerous. All right, let me switch it to this. We'll see what Betero has to say.
How do you unsaddle yourself from what you're saddled with, the burden of proof?
Let me back it up. When does he come on? This is the Glares channel. I'll share the video.
Very surprised.
Damn, I didn't know it was almost at 50.
By what? Exactly.
By Brennan.
What? Oh, did you think that was a good closing argument?
No. I mean, I don't think they're going to win anyway, no matter what he did, but I expected more. He had a script and he stuck with it. You know, he does good at moving away from the podium. I think he's really good at using the courtroom, if you will, by moving here, moving there. But substance matters, and he gets the last word. And that's such a big advantage. And you can pivot, you can rebut what the defense says. And most experienced, seasoned prosecutors, and he's been doing this a long time, and he's people don't like to hear this, but he's good at this. He is. But he just had a script and he was sticking to it no matter what. And it was as if his summation and Alan's summation could have been submitted simultaneously, as if he never had the opportunity that he did, which was to work off of the defense summation and try to pick it apart. And the problem he has is that Alan's summation was, I mean, just a home run on reasonable doubt.
Yeah.
He did it exactly the way, you know, that all of us have talked about, that you wanted to see it, which is just constantly remind them reasonable doubt, primary focus on science, weave in some of the corruption and other facts. But at the end of the day, science and reasonable doubt, which is what he did. And Brennan just,
I mean, he pointed to the fence like Babe Ruth with that one. From the beginning of that closing argument, he drove the reasonable doubt subject home. He not only did he do that, but he explained to the jury in no better way that I could imagine what reasonable doubt means and how important it is and what their duty as a jury is. It was amazing.
Right. And all the lawyers who do this for a living were watching with pride, because that's exactly how you do it. That's definitely what you want to hear. And it was, again, mostly tethered to the science, and he used the science to connect the dots or Legos and stack them with some of the other facts. And it was really masterful. It was powerful. It was emotional. Clearly believes what he's saying, but
yeah.
So, and using that chart was great. That's literally piling the Legos. I mean, he's using sticky notes, apparently. Same idea though. And you only need one of these, but I'm giving you what looked like 30 of these. And Brennan did not address any of it. Not really. I mean, he only, you know, in an hour and a half, he probably spent 5 minutes total talking about the real science. I mean, you can talk about the data all you want, but none of that proves a car accident. And when it comes to the real experts, the medical doctors, the ARCA witnesses, and Welcher, I suppose, it felt like he spent about 5 minutes total at the very end, after he had been meandering, you know, in very monotone, mostly boring tone. And of that 5 minutes, most of it seemed to be related to ham sandwiches, deleting text messages, using Signal, taking limo rides, and things like that. He just, I mean, it was kind of shocking. You know, I mean, the one thing he did do, at least, again, I think he waited too long, was address Proctor and why in his mind it didn't matter. I mean, I give him credit, I guess, for acknowledging that Proctor was an embarrassment and all of that. But that seems to me something you come out in the beginning. And again, you respond to defense and you say they want to turn this into, a litmus test on Michael Proctor, and he doesn't matter. And you should have just done that in the first 5 minutes and just put that out of sight, out of mind, and deal with it, and then deal with the science. I mean, you have to pivot. You have to go off what the defense is saying, no matter how much you want to be tethered to that script. When the defense is making so many significant and powerful points, you can't just go into your monologue about, Jennifer McCabe responding to the scene and this and that and stuff about nothing, which is mostly what it felt like. And if you said to me, what is the most compelling point he made in an hour and a half, I would say it was this primacy and recency. His main argument in support of conviction is that you should have great sympathy for John O'Keefe, which is true, but that he was a great guy. That's almost certainly true, but that really has nothing to do with the case.
Right.
And
no one's disputing that. And it comes off like all you got is to try to garner sympathy from the jury.
Yeah.
And the jury's not stupid. Like you have to assume that they can sense these things. And one thing that I've consistently seen with Hank Brennan is he seems to always patronize the jury and treat them like they're stupid. And I feel like that has been really damaging to him throughout this entire trial.
I think so. But again, I mean, how do you get, how do you unsaddle yourself from what you're saddled with, the burden of proof and proof beyond a reasonable doubt? And there's all these major points being made by the defense. I mean, really, really powerful points supporting reasonable doubt. And you say, how do you get through it? And his attitude beyond the sympathy argument, I mean, that's not really an argument. That's just an appeal to sympathy. Is once again, these clips, which are wonderful. They were stupid. She shouldn't have done it. That's all wonderful. It's not great, but that's not working against the science. That's not proof of anything other than why are you talking? It's not going to establish the elements of the crime. And when you're getting pounded with all these points of reasonable doubt and you're arguing that this case is analogous to some teenage punk throwing a rock over a bridge, trying to argue about theories of murder, dude, abort, move, pivot. You've got to stay on how do you establish a pedestrian SUV crash? How do you do that when every medical doctor is telling you no? Things like that. And, you do almost get the opinion that he's influenced on some level by the Twitter law school, because his big finish on the science, again, which he only gave 5 minutes to, was to play the video and show the taillight was capable of cracking, which nobody disputed. I mean, that's an obvious fact. But there's so many other layers to what the ARCA guy said about the hoodie, the holes. I mean, we could go on and on, the physics, the science, and just saying, but see the taillight cracks, see the taillight cracks. I mean, that really feels like you're talking to the Twitter crowd.
Yeah.
The jury heard the evidence.
And not to be confused with the Glare Institute of Law and stuff. Very different. The prestigious Glare Institute of Law and stuff is not within that category.
Well,
I just want to make that clear.
The Glare Institute of Technology and Law, though, you didn't get your shoe comment. I felt kind of bad. I know you wanted the shoe.
Look, I mean, and I know you can sympathize with me because they didn't call Proctor to the stand, even though I know you felt wholeheartedly that they should. I know you get where I'm coming from, because the shoe is clearly as important as the lead investigator being called to the stand. Because this is, I mean, no other lawyer would probably agree with this, but the founder of the Glare Institute of Law and stuff says so. It is. Now, I am disappointed about the shoe. I am. But I know I said I would die on that hill. I'm on that hill. I'm dying on it. And I'm dying on it with my McLeans here in the chat because they've backed me up on it this whole time. And I said that I would have satisfaction, and they have provided me with such satisfaction. So
No.
I'm content.
Can you imagine? I mean, there's so many things that are wrong with this case, obviously. And it got to the point where, in a summation, that the prosecutor.
So he's always believed that the shoe at the scene had a black sole and that the shoe that they showed in court had a white sole. He's believed that since before the first trial. Does anybody know what changed his mind? I mean, I don't watch consistently at all. Does anybody know what changed his mind? What pick? So like there's a picture of the shoe at the scene, and it's like almost like shadow. We talked about it last trial too. That shows like it makes like the sole of the shoe almost black. He still believes it? I think he was saying he was satisfied with the answer. That he died on the hill. Oh, he does? Huh. That's not how I took it.
Was confronted with a situation where he had to look at the jury with a straight face in a case involving Michael Proctor, in a case involving Buchanan, in a case involving Kelly Dever, just, in a case where all these, the Canton police they just didn't do a good job. All of that, okay? That he looked at the jury with a straight face and said, the only honorable police officer who testified in this case, Barrows, in essence, lied. And if he thinks that's going to land with the jury and suggesting that he turned all red and this and that that was somehow a powerful moment.
Oh,
that to me was just such a dud.
Right, because there's no way that moment was any more powerful than that guy sitting on that stand and going, that's not how that taillight looked when I came to that. That is not how that taillight looked.
He put it in a situation with the burden of proof, again, where not that Barrows was a good cop, he was mistaken, it's unfortunate, but he's not credible because he's not truthful, because he ran to the hotel to pick up a subpoena. The ARCA people are lying.
He essentially said that Barrows was like wanting attention. He kind of said the same thing about Russell too. Like Russell, like good doctor, but she wanted to be involved in the case and so on and so forth. And then he talks about, and then you have Barrows, who wants to like essentially 15 minutes of fame, but that's not how he said it. He just said like he wanted the attention, which is just, it's just so weird because he's like comparing Barrows to Dever, whatever the fuck her name was. I always say her name wrong. But like she was a bitch and came across very not credible to me. And yeah, maybe I'm biased or whatever, but she just came across very not credible to me. She created a very detailed story that she tells the FBI and then says that it was just a false memory, but it was fucking detailed, like very detailed. Yeah, but Blue Man wasn't looking for attention. Yeah, no, that Blue Man wasn't looking for attention. Blue Man got a fucking payday. Out of the state of Massachusetts.
Because they're biased and he ate a ham sandwich, the other one used Signal. I mean, this is a guy with the burden of proof, and he's spending the majority of his time talking about dismantling the defense case by accusing these good witnesses of just basically being liars, or in the case of La Posada and Russell, not making sense. This is a guy who knows he's losing, okay? Because those arguments.
And like better to say, like when Brennan was talking about Marie Russell and La Posada, he was trying to say that they like contradicted each other. but I don't feel like they contradicted each other at all. Did you guys get the impression that they were saying things opposite of each other? Because I just didn't feel that way. I felt like they were pretty much on the same page. So, I don't know. What did you guys think of that? That's what Brennan's telling the jury, is like they were contradicting each other. Like they're putting witnesses on here that don't even agree with each other or whatever. And I was like, no, they didn't. I thought someone got to her and threatened her job. Well, that's the theory, is that she was called up to the commissioner's office, right? The commissioner's office, and was told to do the right thing, and that they essentially had her back, which is also pretty ironic because she also got transferred to Boston and got put on day shift when she was in Canton and working night shifts.
Arguments are just embarrassing. You need to say why they're wrong. You need not just all this nothing. His summation was mostly an hour and a half of nothing. There's really nothing memorable from it other than, you should feel sympathy, and, our theory of murder is like the kid who throws a rock off a bridge. I mean, that's kind of what I remember more than anything else, and that's not good.
No. Yeah. I mean, the thing is Brennan has spent way too much time, and I'm talking pre-trial, ever since he was brought onto this case, focusing way too much on the defense, focusing way too much on trying to cut the legs out from under the defense, which was very telling. It was telling to everyone who started to actually, the traction that it started to pick up, and the people that started to follow it and started to get attention. Like, you saw TikTokers slowly building up and going, hey, wait a minute, what is going on here? I've never seen a prosecutor do this. So this is something that just seems, it's like Jackson was explaining, the data is the silent witness. The science is the silent witness. It cannot lie. It not only does not lie, it cannot lie. So the same thing goes for this situation here. The same thing goes for the fact that when Brennan's entire strategy is to avoid having to present evidence to prove that Karen Reed struck John O'Keefe with her vehicle beyond a reasonable doubt, that should be enough to tell you. That should have been enough for Judge Beverly Cannoni to not let this case go forward. But here we are.
I don't even know what to say. He almost entirely walked away from Welcher. I mean, who was supposed to be the foundation of his case. I mean, he was supposed to be.
That was the case.
You can picture the image of Atlas, holding the world on his shoulders. That was supposed to be Welcher, as supported by Burgess's data. And on top of just merging them into one person, Shannon Welcher, which, whatever, I'll give him a pass for that. He just ignored it as if he knew he couldn't do it. But by doing that, where was his ability to establish how this happened, other than saying there had to have been an accident in front of 34 Fairview because, that's where the taillight was. And because on one of these clips, she says she pulled a piece of glass out of John's face. He just ignored all of the science. And if the idea that he was trying to do was to say, look, it's not impossible that it happened in front of 34 Fairview, then I guess he might have done that. But the problem is he's the prosecutor, not the defense attorney. He has the burden of proof, and he's saddled by a serious reasonable doubt problem that he didn't even come close to overcoming. But frankly, again, I can't reiterate this enough, didn't even really try to attack dead on. And if there's any debate at this point over who the better lawyer is and who the master of the courtroom is and whatnot, it should be obvious now, because the party that doesn't even have the burden of proof made a better presentation establishing what probably happened than what probably didn't happen without even trying to make that argument, without any need to make that argument. And I can't fathom how anybody who's watching this would say that, as Alan said very effectively, you should have questions. And if you have questions, there's reasonable doubt. And Brennan didn't answer any of these questions.
Right.
Created questions. He even said in his summation, we don't know how this happened.
Exactly.
You can't do that. You need a theory.
That's exactly what my next point was going to be. I was going to ask you, would you agree that this case was lost for Brennan when his own expert that, as you said, was carrying this whole case like Atlas carrying the earth on his shoulders, this guy sat there and said, well, we don't know when the point of impact was. We don't know where the point of impact was. We don't know. I mean, right there is your case. How can you possibly, that is the basis. That's the template for what you build your entire theory on. Your hypothesis is all built off of this. So if you don't have that, how can you possibly mathematically come up with a scientific theory that's sound as to what happened to John O'Keefe and Karen Reed's SUV being involved in that? It doesn't make sense.
There is no way. Again, the jury will do whatever the jury does, and we're all just, opining and don't know how they analyze this. All disclaimers apply with that. But right. That aside, if you find the quintessential reasonable person and say, do you have any clue what happened here? The best answer you're probably going to get is, well, I mean, I don't know. She kind of went over there and they had a fight, and maybe she, was pissed off and backed into him. I don't know. But
okay, so Kat says, T in chat, what do you think Maureen Hartnett wanted to correct on the second day of testimony? She wanted to correct the fact that was a reflection and it was the same. No, it was the same letter. That's what I believe. Was the whole reflection thing that she got called out on, and she wanted to correct that whole part of her testimony. That was my thought at the time, anyway. And then B, Brennan was going to call her on rebuttal 4 because of the dog bite stuff. So during her regular testimony, she did not testify about swabbing the sleeves and then having them packaged and sent off to UC Davis. So she was going to have to come on for chain of custody for that, and then he could bring Terry Kuhn, who was the tech from UC Davis who tested those swabs and came up with the pig DNA. So that's what the rebuttal for her would have been. And then let me see. Round guy, round red glasses. I don't know. That doesn't sound familiar to me. I mean, like, is he good at predicting things, or is that just, do we just like him and want to know what he says? That's what I wonder. So did anybody else notice that Brennan essentially used AJ's closing argument from last year with the look the other way? Look the other way. Yeah, look the other way. It's like he didn't even come up with his own closing argument. Like he took AJ's and tried to make it work for him. It's so weird. And so lunch, they said that she told the jury a half an hour, but then she had the attorneys at the sidebar, and she told them yesterday she was going to give them a half an hour. So I'm assuming that because 1:46 or not 1:46, what the fuck am I talking about? 9:46 my time, 12:46 Eastern time is when she let the attorneys go. And Court TV said court will resume at 1:15. So I think they were going off the half an hour after the attorneys left. Well, it has now been that half an hour. Check my messages. Okay, let me do that real quick. Yeah. He looks familiar. He looks familiar. Yes, he does. Thank you, Indiana girl. Okay, so let me switch over because we got a fan. So if you guys want to go listen to Betero over on Glarer, have at it at any point after we're done here. So I'll play this until we get some actual movement in the courtroom, and then I'll switch it. So if it switches mid-sentence, I apologize.
All the doctors are saying, not really. So I guess if you put a gun to my head, she didn't hit him, but she might have, but I don't know. I mean, you get my point. Like on a reasonable doubt standard, it's everywhere.
Yeah, it's literally. I've been saying this for a year and a half. I first started educating myself on Sleuthie Goosie's spreadsheet, right, with all of the documents and everything.
Hey,
and
Sleuthie Goosie getting the call out. What?
As I went through it, I got to a point where, and this was just before I decided to talk to Turtle Boy, I was like, you could pick something out of a hat involving this case and find reasonable doubt in it. It doesn't matter. Like, you could just blindly pick something, any detail in this case, and find reasonable doubt. Anything that is considered evidence in this case, you could poke a hole through it. And most of it is chain of custody and lack of documentation. All you got to do is just look at the statements, the dates on them,
everything. It's so funny because last night when I was talking to some other people about the summations, they said, what are you looking most forward to seeing? And I guess the answer was kind of surprising. I said, obviously you want to see, a master trial lawyer like Alan do this, and other, accomplished real trial lawyers like to wash other real trial lawyers and, absorb and just, it's good. It's good learning exercise as well.
Yeah.
They said, I'm much more interested, believe it or not, even though it's going to be a hell of a lot more boring, but from a lawyer standpoint, I'm much more fascinated to see how the hell is Brennan going to attempt to talk his way out of this mess and even make this plausible. So that, and of course, you got a home run summation by Alan. I mean, it was well done, well delivered, proper tone. He did focus on reasonable doubt, which I loved. He focused on the science, which I loved. I told people I was really hopeful that he would really come after not just the investigation, but the way they prosecuted the case with the hoodie. He did that. I thought that was beautiful. So how is Brennan going to deal with this? And so Brennan comes out and immediately starts with the sympathy. Okay, for a few minutes, I'm all right with that. And his tone I thought was actually very good. He kind of sounded more, or I should say less monotone. This is about 3 or 4 minutes. And then within 5 minutes of that, it was right back to as if he's talking about inserting widgets into gadgets and boring, and he's not even going to address what Alan is saying. We're going into a canned explanation, and this went on, and I'm waiting. Is he ever going to address anything important here? And we're playing more clips, and I'm still waiting. And then he's talking about Nuttall and McLaughlin, and we're still not talking about any of the science. And now it's after an hour and 20 minutes, and he finally does. And it's just, he even says, I don't want to talk too much about this. And you know what? He didn't. You're just sending a message to the jury. I got nothing, because if you don't think it's important to talk about the science and trying to kneecap all those witnesses, how do you expect to win? Because these are incredible witnesses who are dismantling everything you tried to prove over the course of 2 months. And you don't think that's worth talking about in summation because you have to play clips of Karen talking about a water buffalo on the prairie? It's one way to do it. It's just not an effective way.
Right. And it was predictable. I would be surprised if this jury didn't predict that Brennan was going to hang on these clips like their gospel in his summation.
I mean, you knew he was going to go heavy on clips, but I will tell you, I was stunned that he didn't do what all trial lawyers do when they have the last word, if they've been doing this a long time and they're effective, and that is use the last word to your advantage and confront head on, not what you wrote down last night for notes, but what you just heard in the courtroom 20 minutes ago. And he didn't even try. He just had his speech, and he could have given that without you having even heard what Alan said. I mean, there was no effort at all to address the points that were raised. And in doing so, I mean, it's almost like he just conceded in some way that those points were, but I'm going to talk about this.
It could be construed. I mean, everything at the Glare Institute of Law and stuff, we teach that everything in trial, all that matters is what the jury sees, hears, and how they perceive it. That's all that matters, right? So you've got Brennan. It's interesting how you put it that way. It's almost like conceding simply because he seemed to avoid it. And when you seem to avoid it, it's almost like you're admitting guilt. It's almost like you're conceding. Right.
I have one piece of advice for you guys. Do not go to whatever law school that the Glare is hosting. And that has nothing to do with liking or disliking. But that is not the law. That is not the law school to go to. I'm just going to put that out there. Don't do that.
Right. It can absolutely be construed that way.
But that's been the whole way he's handled this case. You know, what did he do with Proctor during the trial? He just put him away. He never, you know, what did he do with the Alberts?
Right.
He just didn't mention them. You know, none of this matters. And he told the jury in his opening that this was going to be about data and science. And he starts talking about data, but the data doesn't prove a car accident. And the data relies on Burgess. And he says, oh, you know, they can talk about maybe he made a mistake on his LinkedIn. Dude, he didn't make a mistake on his LinkedIn. He affirmatively misrepresented what he did. I would have liked to have them to say facts matter. That's what Brendan said, facts matter. And they kept moving the goalposts to change the data to fit throughout the whole investigation, whatever. It wasn't that important, but he just was relying on that. And he offered no pushback. And when he tried to say, you know, we didn't bring Welcher in to recreate what happened, then, you know, I thought that was handled beautifully as well, to say they spent $400,000 of taxpayer money for this guy to dress up like John O'Keefe, arm out, pretending he was John O'Keefe and leaning into the car. And they're trying to tell you that was not designed to show you how the arm injuries got with it. Of course, that's what it was designed.
That's exactly. That is like zeroed in on what that was designed to do. It's like,
you know, one of the other ways too, you know, that he just didn't pivot. You know, I thought this was handled beautifully by the defense when he was really attacking Brennan about the hoodie, and he said, watch what he says or what he doesn't say. Okay.
Right.
Hone in on that. And if he doesn't tell you anything, he's admitting he's got nothing. And you have to respond to that. You know, you have to, and he just turtled up, pardon the expression. He just left it alone, and he just ignores all the problems. And in many ways, he seemed dispirited. I mean, he didn't have the same gusto that he had in the earlier part of the trial. And as it seemed to just get worse and worse and worse, you had a summation where, you know, Alan looked emboldened, really into it, you know, just powerful in presentation, in substance, in manner, and just emboldened to like, I'm telling you what's going on. And Brennan felt that he just, I got to get through this, and I'm just going to go through my script. And look, you can't believe Dr. Wolf because he used Signal, and you can't believe Dr. Rentschler because, you know, he ate a sandwich and sat down, and you can't believe Dr. Russell because she was told what to do in a limo ride, and, you know, Barros is a liar. But other than that, this is going great.
But But pay attention to the science and the data, folks. Pay attention to the science and the data.
Now he doesn't. He
what are you
doesn't
saying
say
on
that. He doesn't say science. He only says the data. The data doesn't lie. The data doesn't lie. The data. The data. The data. That's a Brennan thing. Jackson was like, the science doesn't lie. You can't manipulate the science, but you can manipulate the data, which is what they did, or at least manipulate the way that you're perceiving the data, because it was always 12:30, 1:38. It's been that way for almost 3 years. 12:30, 1:38. That's always been it. It's never changed until they realized they were wrong, because John O'Keefe was still using his phone and they had to change the way you perceive the data. That was it. So they say like the data doesn't lie, but 12:30, 1:38 has been the data forever, according to the Commonwealth, including the beginning of this trial. So it's not like Lolly's data. It was the data. But Brennan stayed with data. AJ stuck with science. The science doesn't lie. And the science, the doctors, all the doctors, including the ME who was called, including Dr. Welcher, all of them are telling you about the science. And that John O'Keefe was not hit by a car. And even with Dr. Welcher, he just tells you like, oh, yeah, it's a possibility, as he walks himself into the back of a vehicle. Yeah, it's not just the data, it's the process to the data, like the bioengineer said. You're putting the horse before the cart. Yeah, and then Whiffen goes and changes the software so it doesn't show anything deleted anymore. The data of the flipped video footage, the data of the holes in the back of the shirt. Right. Hi, Schmeed.
The other side of his mouth. And you're like, okay, but
FYI, the fan is still just spinning in court, and I have it live on another screen so I can see it, and it's nothing's happening there. And we're going on almost an hour for the jury to have been out. "45 minutes of the jury being out."
Dude. I absolutely agree that I think that this is the problem with Brennan is, and the thing about passion.
Yeah.
When someone speaks,
you have the data doesn't agree with your theory, so you essentially go change the data so it agrees with your theory. That's what they did. That is exactly what they did.
Passion. What that does it tells the jury specifically that they believe in what they're saying. That they believe what they're saying. When Brennan lacks passion and Alan Jackson stands up there just oozing with it, I mean, just beaming with it, it's gonna tell the jury something. Maybe even if they can't even put their finger on it, but it tells the jury something. You know, and
you tell him,
man, Brennan fell short. Brennan
right.
fell short in that department for sure.
He did, but you know what he must have realized, and why he didn't know this a year ago is beyond me, or 9 months ago, whenever he jumped into this. At the end of the day, you know, you got to go to the dance with the one you brung, right? I mean, it is what it is,
Yeah.
and that's what I don't know why. Just because they brought in a new lawyer that wasn't Adam Lally, that everyone naturally assumes, well, that's it. I mean, the evidence is still going to be what the evidence is. Now, he tried to make it,
I've always said that,
a more streamlined case. He did try, look, he did do the text stream stuff. In many ways, at least philosophically, he tried a better case than Lally, but his summation was about nothing. Really?
Mark, let's just call this what it is. I mean, the fact is as you said, because I've been saying the same thing for a year. I've been saying the same thing since Brennan was brought on. They bring on Brennan. Turns out it's Whitey Bulger's attorney. I'm like, okay, this stinks already. You know, if it quacks like a duck, it walks like a duck, it's a duck, right? So I'm like,
I think you butchered that, but that's okay. I know what you mean.
yeah, I did. But
walks like a duck and it quacks like a duck. It's a duck.
Right.
That's
Yeah,
okay.
yeah. So I'm looking at this and I'm thinking like, okay, the evidence is.
Court is now open, you may see.
So who wanted to see me? I'll see you at Sidebar for just a minute.
Okay, I went over here because I heard court back in, and then now we're at a sidebar. Better hurry up. I'm not going to switch back just in case, but if it does take too long, then we'll see. 10:32. Well, Leslie's already coming back. Oh, okay, it was quick. That's good.
No, Kristen, yes. Yes, I'm sorry. Some space here, please.
Yeah, it's 1:32 there. It's going to take her, what, at least probably an hour to go through all of this, you think? That's 2:32. She's asked them to stay till 5. They have 2.5 hours to deliberate approximately. I don't know. What do you think? I mean, I guess if they just all walk in there and like, do you want to do a, what are they calling the straw hat? What is it? That's not the right word. Yeah, that's why I said unless they walk in there and they're just like, okay, let's just see where everybody stands and then what we agree on and what we should talk about. You could knock a few out if you just sat down, if you all just agree right off the bat on a few. But isn't it straw like a straw? Straw? Why can't I think of the right word?
You okay with that?
Oh, okay.
Are you okay with that? Yeah, okay. A little hot mic. I don't know what they were talking about though. A straw poll. Yeah, I said that, but that just doesn't sound right when I say it out loud. You know, sometimes when you say stuff and it's just like that doesn't sound right.
All right, jurors, I'm going to give you the instructions now in the law. But first, I want to thank you for serving on this jury and for being so attentive. You'll soon deliberate for the purpose of reaching a verdict. But before you do that, it's my responsibility to give you the instructions concerning the law. These instructions are divided into 3 parts. The first part, general instructions that are provided in every criminal case. The second part, specific instructions concerning the crimes alleged in this case. And third, guidelines for your deliberations. Please listen carefully to all of the instructions. Do not ignore any instruction or give any special attention to any other instruction. To make sure that I give you the instructions accurately, I will read them to you. You'll also get a written copy so that you may refer to it in the jury room during deliberations. I will try to make sure that my oral instructions match the written instructions. If there is any difference between what I say aloud and what the written instructions say, please follow what I say aloud. You must take the law as I give it to you. You may not quarrel with it. You can't do that regardless of any opinion you may have as to what you think the law ought to be. Lawyers or witnesses may suggest something about the law That's not necessarily the law. That's because it's my responsibility as the judge and mine alone to instruct you what the law is.
Okay, so just real quick, Aiden posted, during the break, Bukaki was standing menacingly in the hallway wearing a black suit, eyeing the jurors up and down. Karen Reed's lawyers complained to court security about this, and he was forced to go inside the DA's office. He said, I would have taken a picture if I could, but he was literally standing there in the hallway with his arms folded, dressed like an Eastern Bloc Men in Black, and the jurors were all forced to walk by him. He was also upstairs when the jurors were first brought into the courtroom. There is no reason for him to be here today. So again, Bukaki standing, watching the jurors. So he did it before court, and then he did it again at lunch.
I'll now turn to part 1 of these instructions, which are general instructions that apply to all criminal cases. As I've explained to you at the beginning of the trial, there is a fundamental rule that applies to all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Ms. Reed is presumed innocent of the charges in this case. That means you must consider Ms. Reed to be innocent unless the prosecution has proved beyond a reasonable doubt through evidence presented at this trial that Ms. Reed committed the crimes charged. I'll explain what I mean by reasonable doubt in a moment. Ms. Reed does not have to do anything to convince you that she is innocent. She does not have to explain anything. She does not have to testify, call, or question witnesses, or provide any evidence at all, because you must presume she is innocent. Instead, it is up to the Commonwealth to prove the charges against Ms. Reed beyond a reasonable doubt. This burden of proof never shifts to the defendant. After you have considered all the evidence carefully and fairly, if you have a reasonable doubt about Ms. Reed's guilt in a particular charge, then your verdict must be not guilty on that charge. You may find Ms. Reed guilty of a charge only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. Now, what is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt. For everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. How do you decide whether the Commonwealth has proven that each element of an indictment is true beyond a reasonable doubt? Let's talk about the roles we all have. First, the function of the jury. You are the most important people in this room. It all begins and ends with your function. You will determine the facts in this case, and that is your job and yours alone. You are the sole and exclusive judges of the facts. If there are any conflicts in the testimony, it is your job to resolve those conflicts if you can do so. Once you determine the facts, it is your duty to apply those facts to the law as I explain it to you, and to determine whether the Commonwealth has proven its case beyond a reasonable doubt. You must decide the facts solely and entirely on the evidence as you have seen, heard in this courtroom, and on nothing else. No prejudice, no bias, no fear, no favor. You must not be swayed by personal likes or dislikes. Your deliberations are no place for emotion, sympathy, passion, or prejudice. The Commonwealth and Karen Reed have a right to have the case judged by fair and impartial jurors. All parties who come before the court stand as equals before you. Therefore, your verdicts must be based on the law as I'm giving it to you, and on the evidence and the facts that you find, and nothing else. You cannot allow yourselves to be influenced by any personal feelings you may have about the nature of the crimes with which Ms. Reed has been charged or the consequences of your verdict. Just the cool, reflective, and impartial sifting of the evidence so that here in this courtroom, justice may be done. Your focus is on the evidence. I am the judge of the law. My job is to teach you the law that you must follow in the case. However, I have no opinion about how you should decide this case. You should not consider anything I have said or done during this trial as reflecting any opinion by me about how you should decide this case. If you believe I have an opinion about the facts of this case, you must disregard it. You must decide this case based solely on your evaluation of the evidence. The arguments of the lawyers are not evidence. They are not witnesses. If a lawyer during argument made a mistake in summarizing the evidence or argued something not supported by the evidence, you must disregard it. It is the jury's collective memory of the evidence that controls the matter. Lawyers' objections are a proper part of the court procedure and are not part of the evidence. So don't hold it against the lawyers or their client if they made objections, motions, or other requests. They're simply doing their job during the trial. There was testimony at trial that the lawyers interviewed witnesses when preparing for the trial. You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the lawyers are obliged to prepare their case as thoroughly as possible and may interview witnesses. The verdict must be based only on the evidence and the jury's collective reasoning applied to the evidence in a fair and impartial manner. The extent to which you believe or disbelieve a witness or what an exhibit purports to show, and the importance to give any testimony or other evidence is entirely up to your own good judgment. The evidence consists of the testimony of the witnesses and the exhibits that were introduced in this trial. You will have those exhibits with you in the deliberation room. In addition, as you heard during the trial, the prosecution and defendant agreed that certain things are true. Therefore, you must accept those things as true. There are some things you have heard about that have not been introduced into evidence, such as previous testimony of witnesses, police reports, autopsy and accident reconstruction reports, and perhaps other reports. You may naturally wonder why neither side has introduced any of them into evidence. The answer is that under our rules of evidence, such reports usually may not be admitted, although the parties may refer to them for certain limited purposes while questioning witnesses. So you should not hold it against any party that you do not have them, and neither should you speculate on what they may or may not contain. Similarly, as you review the exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try to guess what may have been removed from there. Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any other comments I made, the lawyer's opening and closing statements and any comments they made are not evidence. If the lawyers or I made any comments during the trial, those comments are not evidence and you must base your verdict only upon the evidence. In an interaction between a lawyer and a witness, you may consider only the witness's testimony as evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witness, that is, their answers to the questions and the exhibits are evidence. Finally, on this topic, if one of the lawyers or I refer to some part of the evidence and that does not coincide with your own recollection, it is your collective recollection which you are to follow in your deliberations. It is important to remind you folks that the verdict cannot be based on emotional reaction or sympathy for any person or side of this case. Certain of the testimony and exhibits may have provoked an emotional reaction in all of us. You may feel sympathy for the family of Mr. O'Keefe, and you may feel sympathy for the defendant as she sits here in the courtroom. But your job is to decide the case without bias, fear, sympathy, or favor, to view the evidence with a certain clinical detachment, and to decide the case based solely on the evidence and the application of the law. I have allowed you folks to take notes during the trial if you chose, and you may refer to those notes during your deliberations. But remember, they are not evidence or a substitute for the evidence and your recollection. They are for your personal use. Please do not share them with the other jurors. Please consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you've gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Keep an open mind until then. For each indictment, you must decide whether the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of that specific charge. Your decision as to each charge must be unanimous, meaning that all 12 deliberating jurors must agree. You will receive one verdict slip for each indictment. When all 12 jurors agree on the verdict for a particular indictment, the foreperson should check off that verdict and then sign and date the slip in ink. For each charge, if you all agree that the Commonwealth has proved every element of the charge beyond a reasonable doubt, then you should find Ms. Reed guilty of that charge. On the other hand, if you all agree that the Commonwealth did not prove one or more elements of a particular charge beyond a reasonable doubt, then your verdict must be not guilty on that charge. You'll remember that we took a view in this case. It seems like a very long time ago, but we took a view in this case. The purpose of the view is to help you better understand the evidence that you heard during the trial and to help you appreciate the locations and their surroundings. Your responsibility in the view was to see the places, observe them carefully, and remember what you saw. The view is part of this case. You may use and consider the observations that you made while on the view in your deliberations in reaching a verdict. The same is true about the demonstration we saw from the witness stand. The demonstration was done simply to help you understand the evidence, and you may consider it in your deliberations. It is the jury's job to earnestly seek the truth of the matter. In doing that, the jury must decide questions of credibility and reliability. The jury must decide how truthful or reliable or convincing any part of the evidence is. You should evaluate the testimony of a police officer in the same way you would evaluate anyone else's testimony. You must not automatically believe or disbelieve a witness just because the person is a police officer. In deciding questions of credibility and reliability, you may rely on your common sense and reasoning powers and your life experiences. Consider a witness's testimony in the context of all the other evidence, not in isolation. You may consider the demeanor, candor, and appearance of the witness in testifying. Who was the witness? What relationship did they have to the case, to the other witnesses or parties? Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations and ultimately as to whether or not it impacts the credibility of the witnesses and the assessment of the evidence presented. Is the witness someone likely to give an honest and impartial account? Consider not just whether the witness was honest, but also whether the witness's testimony was accurate and reliable, or honestly mistaken. A prior statement by a witness, if inconsistent with his or her trial testimony in any way, may be considered on the witness's credibility and reliability, and only for this purpose. Also, if there has been a suggestion that a witness recently contrived their testimony, you may take into account any earlier statement the witness made which was consistent with their present testimony. The prior statement is relevant only as to the witness's credibility and reliability, and only for this purpose. You have heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider three questions. First, whether the omitted test or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted tests or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the test or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involve factual determinations that are entirely up to you. And you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. During the trial, I gave you some instructions on how you were to consider some of the evidence you heard, and importantly, how you are not to consider the evidence. I'm going to summarize those limiting instructions here. Ms. Reed is not charged with committing any crime other than the charges contained in the indictments. You've heard evidence about interactions that Ms. Reed may have had with Mr. O'Keefe in Aruba and others in Aruba. The evidence was admitted solely for your consideration as evidence of the nature of the defendant's relationship with Mr. O'Keefe and whether it goes to her knowledge or intent or motive on January 29, 2022. You may not consider the evidence as proof that she has a criminal personality or bad character. You may not take the defendant's prior acts as a substitute for proof that the defendant committed the crimes charged here, or to conclude that if she committed the acts in Aruba, she must have committed the offenses with which she is charged here. You can only use the evidence for the limited purpose of how it goes to the defendant's state of mind, motive, and the nature of her relationship with John O'Keefe. Before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the persons who authored the electronic communications were in fact John O'Keefe, Ms. Reed, Michael Proctor, Brian Higgins, or others alleged to have authored or created them. If you do not find it is more likely true than not that the persons alleged to have authored or transmitted or created the communications were the persons alleged to have done so, then you may not consider the electronic communication in deciding the case. Photographs have been entered into evidence, and in some instances, those photographs will be inside an envelope when they go back to you to the deliberation room. The photographs may be graphic and unpleasant. As I told you when you first saw them, your verdict must not in any way be influenced by the fact that these photographs may be graphic or unpleasant. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy. Consider a photograph only as it may show a medical condition, the nature of the injuries, or the details of the incident itself. You heard evidence of statements made by John O'Keefe. These statements were admitted only for a limited purpose of establishing John O'Keefe's state of mind. You are not to consider this testimony as proof that the defendant has bad character or propensity to commit crimes. The testimony of witnesses recounting conversations with Mr. O'Keefe or messages the defendant's phone received from him can only be used as they go to the defendant's motive or intent on January 29th, and only if you find that Ms. Reed was aware of Mr. O'Keefe's state of mind at the time of the crime and would be likely to respond to it. There need not be direct evidence that the defendant learned of Mr. O'Keefe's state of mind, so long as you can reasonably infer from the evidence that she did learn of it. Now, you have heard testimony about statements allegedly made by Ms. Reed. Before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence or not, and for what purpose it may be used. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all of the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she's alleged to have made and that she made it voluntarily, freely, and rationally. In determining whether or not any statement made by the defendant was voluntary, you may consider all of the surrounding circumstances. You may consider any evidence you have heard about the defendant's physical and mental condition, her intelligence, age, education, and experience. Your decision does not turn on any one factor. You must consider the totality of the circumstances. Some testimony came from witnesses who saw or heard something. Some witnesses also told you about opinions or conclusions they reached based on some special training or experience. But special training or experience does not necessarily make the witness's testimony any more believable or important than any other evidence. So you should consider the same questions about witnesses' testimony that I mentioned earlier, including any bias or motive these opinioned witnesses may have had to testify in a certain way. You may also consider the witness's level of experience and training and whether they base their opinions on the facts that you find to be true. There were hypothetical questions asked of some of the witnesses. You may give whatever weight you deem appropriate to the opinion based on the hypothetical, but only if, after careful consideration, you find that all the facts in the hypothetical were true. Remember that witnesses, even those with special training or experience, do not decide cases. Juries do. It is up to you whether to accept or reject, in whole or in part, any opinion or conclusion that a witness offered during the trial. You have the same powers with respect to the exhibits that you do with respect to the witnesses. Look them over and decide the weight, that is the value, that they deserve to receive in helping you resolve the case as you make your ultimate judgment about whether the Commonwealth has proved its case beyond a reasonable doubt. You do not have to believe something simply because it's written on a piece of paper or appears in a photograph. You are not, of course, required to disbelieve it because it appears there. You decide whether to believe what an exhibit purports to show and how much weight, if any, to give the exhibit. Certain charts and summaries not admitted into evidence have been shown to you as testimonial aids intended to summarize, clarify, simplify evidence, or to help explain the contents of records, documents, computer data, or other evidence introduced in the case. Charts and summaries are not new evidence, and you should give them only such weight as you think the underlying evidence deserves. So you've heard me talk about sources of evidence in this case. Those are the tools that you have to decide the case. Now, with that evidence in mind, what can you do with it? As jurors, you may bring to bear all your knowledge and experience. You don't check your common sense at the door to the jury room. Just the reverse. I instruct you to use your common sense. Give the evidence a reasonable and fair construction in the light of your common knowledge and experience. In determining the facts in this case, you may draw reasonable inferences from the evidence that you believe because you're entitled to rely upon both direct and indirect or circumstantial evidence. Direct evidence is evidence of what a witness claims to have seen or heard or touched or somehow perceived with their own senses. Indirect or circumstantial evidence exists where a witness does not testify directly to the fact that is sought to be proven, but you are provided with evidence of other facts and then asked to draw reasonable inferences from them about the fact that's sought to be proved. Such inferences may be considered with all of the other evidence in reaching your verdict. Indirect or circumstantial evidence alone is sufficient to establish guilt beyond a reasonable doubt. Now, what do I mean by an inference? An inference is a logical deduction or conclusion that you may, but are not required to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. Sometimes you can draw more than one inference. You have to decide which inferences are reasonable and decide which seem more reasonable to you. Remember, when you're dealing with inferences, you never have to infer anything. You may, but do not have to draw inferences whatsoever. An inference drawn from indirect or circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one, which is not too remote in the ordinary course of events. You may not guess. You may not speculate. You may not engage in surmise. You should not pile inference upon inference until the pile gets so high that it tips over logically, or that the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure that they're still reasonable. Further, when the evidence tends to equally give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all of the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt. Let me give you an example of an inference. Suppose that the issue you must decide is whether the U.S. Postal Service delivered the mail today. If you go home and someone in your household hands you the mail and states that they observed the letter carrier deliver the mail and retrieved it from the mailbox, this would be direct evidence that the U.S. Postal Service delivered the mail. The witness perceived the events with his or her own senses and told you what he or she observed. The issue you would have to decide is whether that witness was credible. On the other hand, if you go home from court and find mail in the mailbox, you may infer that it was delivered by the U.S. Postal Service today. You draw this reasonable inference based on the following known facts. The mailbox was emptied yesterday. You know that the mail is delivered by the U.S. Postal Service Monday through Saturday. The letters in the box are postmarked. You have exactly the same power in this case, not the power to speculate or to guess, but the power to draw reasonable inferences warranted by the evidence in the fashion I've just described. You may have noticed that Ms. Reed did not testify at this trial. Defendant has an absolute right not to testify since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. The fact that Ms. Reed did not testify has nothing to do with the question of whether she is guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You're not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. Now that completes the first part of my instructions. Now I'm going to turn to the elements of the charges against Ms. Reed. The Commonwealth has alleged that on January 29, 2022, Ms. Reed did assault and beat John O'Keefe with the intent to murder him, and by such assault and battery did kill and murder John O'Keefe. So in that indictment, Ms. Reed is charged with second-degree murder. Now, I just want to tell you that our Supreme Judicial Court has promulgated jury instructions on homicide charges that I have to read verbatim. So I want to make sure to do that right. So murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. 1, the defendant caused the death of John O'Keefe. 2, the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which, in the circumstances known to Ms. Reed, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of John O'Keefe. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. The second element is that the defendant intended to kill John O'Keefe, or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, the second element has 3 sub-elements, which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of these 3 prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill John O'Keefe. This means that the defendant consciously and purposefully intended to cause John O'Keefe's death. The second prong is that the defendant intended to cause grievous bodily harm to John O'Keefe. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that she intended to perform the act, you must then determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. If you have a reasonable doubt as to whether John O'Keefe's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved that the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. If the Commonwealth has proven both elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the second indictment is the indictment charging manslaughter while operating a motor vehicle under the influence of liquor. And there are lesser included offenses on this verdict slip as
That's
well,
where you gotta
and
pay
I'll explain
attention.
those to you as well.
Yeah, the whole
In order to
town-
prove manslaughter while operating a motor vehicle, the Commonwealth must prove the following 5 elements. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place which the public has the right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that the defendant operated the vehicle wantonly or recklessly so as to create a high degree of likelihood that substantial harm will result to another. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. To prove the first element, the Commonwealth must prove beyond a reasonable doubt that the defendant was operating a motor vehicle. A person operates a motor vehicle while doing all of the things, the well-known things that drivers do as they travel on a street or highway, and also when doing any act which directly tends to set the vehicle in motion. A person is operating a motor vehicle whenever they are in the vehicle and intentionally manipulate some mechanical or electrical part of the vehicle, like the gear shift or the ignition, which alone or in sequence will set the vehicle in motion. To prove the second element, the Commonwealth must prove beyond a reasonable doubt that the defendant operated a motor vehicle in a public way. Any street or highway that is open to the public and is controlled and maintained by some level of government is a public way. This would include, for example, interstate and state highways, as well as municipal streets and roads. In determining whether any particular street or road is a public way, you may consider evidence, if any, about whether it has some of the usual indications of a public way. For example, whether it is paved, whether it has street lights, street signs, curbing, and fire hydrants, whether there are buildings along the street, whether it has any crossroads intersecting it, and whether it is publicly maintained. To prove the third element, the Commonwealth must prove beyond a reasonable doubt that while operating a motor vehicle, the defendant was under the influence of intoxicating liquor, that is alcohol, and or the percent of alcohol in the defendant's blood was 0.08 or greater. I will now instruct you on both theories. What does it mean to be under the influence of alcohol? It is not illegal to drive after consuming alcohol as long as the operator is not under the influence of alcohol. However, neither does someone have to be drunk to be under the influence of alcohol. A person is under the influence of alcohol if they have consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected emergencies. The amount of alcohol necessary to do this may vary from person to person. The Commonwealth is not required to prove that the defendant actually drove in an unsafe or erratic manner, but it is required to prove that the defendant's ability to drive safely was diminished by alcohol. You may rely on your experience and common sense about the effects of alcohol. You should consider any believable evidence about the defendant's alleged consumption of alcohol, as well as the defendant's appearance, condition, and behavior. In deciding this theory of whether the defendant operated a motor vehicle under the influence of alcohol, you may also consider whether a blood test showed that the defendant had consumed alcohol. However, no matter what the reading is, the blood test is not sufficient by itself to prove that the defendant was under the influence of alcohol. Under the second theory, the Commonwealth must prove beyond a reasonable doubt that at the time of operation, the percent of alcohol in the defendant's blood was 0.08 or greater. The Commonwealth may prove a person's blood alcohol level by a chemical test or analysis of their breath or blood. In deciding whether the Commonwealth has proved the defendant's blood alcohol level beyond a reasonable doubt, you may consider evidence, if any, about whether the test was administered within a reasonable time of operation of the motor vehicle, whether the person who administered the test was properly certified, whether and how the pre-test procedures were followed and employed, whether the testing device was working properly at the time the test was administered, and whether the test was administered properly. You may also consider any other evidence pertaining to the test or the test results. The fourth element the Commonwealth must prove beyond a reasonable doubt is that the defendant operated the vehicle wantonly or recklessly. A person drives recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or they are indifferent to whether someone is killed or seriously injured. It is not enough for the Commonwealth to prove that the defendant acted negligently, that is, acted in a way that a reasonably careful person would not. It must be shown that the defendant's actions went beyond mere negligence and amounted to recklessness. The defendant was reckless if she knew or should have known that such actions would pose a grave danger of death or serious injury to others, but chose, nevertheless, to run the risk and go ahead. Whenever I refer to the defendant's state of mind or her intent, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite state of mind or intent, even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Here, the defendant must have intended her acts in the sense that they were not accidental. But it is not necessary that the defendant intended or foresaw the consequences of those acts, as long as a reasonable person would know that they were so dangerous that death or serious injury would probably result. As such, the Commonwealth does not need to prove that the defendant intended to kill John O'Keefe. Rather, this is in that category of cases where public safety requires each driver, once they know what the situation is, to determine and to adhere to an objective standard of behavior. In determining whether the defendant drove recklessly, you should take into account all the facts of the situation: the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well the defendant could see and control her vehicle, the condition of the defendant's vehicle, what kind of road it was and who else was on the road, what the time of day, the weather, and the condition of the road were, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The fifth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant, by her actions, caused the death of John O'Keefe. The defendant caused the death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act is a natural and continuous sequence, results in death, and without which death would not have occurred. If the Commonwealth has proven all five elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the lesser offense of manslaughter while operating a motor vehicle under the influence of liquor includes the lesser offense of involuntary manslaughter. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with that lesser included offense. The Commonwealth may prove the lesser included offense of involuntary manslaughter, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence. So I'm going to define involuntary manslaughter for you. To prove that the defendant is guilty of involuntary manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that the defendant caused John O'Keefe's death. Second, that the defendant intended the conduct that caused John O'Keefe's death. And third, the defendant's conduct was wanton or reckless. I will now discuss each element in detail. The first element is that the defendant caused the death of John O'Keefe. Remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove that the defendant intended to cause the death. You may consider any credible evidence that the defendant was affected by her consumption of alcohol. The third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving grave risk of harm to another that a person undertakes with indifference or disregard of the consequences of such conduct. Whether conduct is wanton or reckless depends either on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of great danger. Even if the defendant herself did not realize the grave risk of harm to another, the act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that a reasonably careful person would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I have defined that term. In deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite knowledge even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the offense of manslaughter while operating a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI, and negligence. As a matter of law, the indictment that is before you that charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor also charges her with the lesser included offense. With that lesser included offense, the Commonwealth may prove the lesser included charge of motor vehicle homicide, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. You may find the defendant guilty of motor vehicle homicide only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide. On the verdict slip, that just means you start from the top and you work your way down. In order to prove the defendant guilty of motor vehicle homicide, the Commonwealth must prove the following 5 elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has the right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that while operating a motor vehicle, the defendant did so in a negligent manner so that the lives or safety of the public might be endangered. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. Elements 1, 2, 3, and 5 are the same as manslaughter while under the influence of alcohol, as previously instructed a few moments ago. The difference between manslaughter while operating under the influence and motor vehicle homicide is the 4th element, so I'll focus on that. To prove the 4th element of motor vehicle homicide, the Commonwealth must prove beyond a reasonable doubt that the defendant drove negligently in a manner that might have endangered the lives or safety of other people. A person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances, or by not doing something that a reasonable person would do. The defendant acted negligently if she drove in a way that a reasonable person would not have, and by doing so created an unnecessary danger to other people, a danger that she could have avoided by driving more carefully. The defendant's intent does not matter, so do not consider it in determining whether or not the defendant was negligent. There is no requirement that the Commonwealth show that the defendant intended to act negligently or unlawfully. Under our laws, public safety requires each driver to determine and to adhere to an objective standard of reasonable behavior. Therefore, what the defendant may or not have intended to result from her actions is irrelevant. The issue is whether or not she drove as a reasonable person would have under the circumstances. In determining whether the defendant drove negligently in a manner that might have endangered the lives or safety of other people, you should take into account evidence, if any, about the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well she could see and control her vehicle, the condition of the defendant's vehicle, the kind of a road it was and who else was on the road, the time of day, the weather, and the road conditions, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The offense of manslaughter while operating under a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI liquor, and the lesser offense, and the lesser included offense of operating under the influence. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with these lesser included offenses. So the Commonwealth may prove the lesser included charge of operating under the influence, even if it fails to prove the greater charges of manslaughter while operating a motor vehicle under the influence of liquor and motor vehicle homicide. You may find the defendant guilty of operating under the influence only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are not convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide, but are convinced that the defendant is guilty beyond a reasonable doubt of operating under the influence. To prove the defendant guilty of operating under the influence, the Commonwealth must prove elements 1, 2, and 3 that I instructed you on motor vehicle homicide while OUI. So the third indictment is leaving the scene of an accident resulting in death. In order to prove the defendant guilty of leaving the scene of an accident resulting in death, the Commonwealth must prove 6 things beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated a motor vehicle on a public way or in a place which the public has a right of access. Third, that the defendant knowingly collided with John O'Keefe. Fourth, that the collision caused injury to John O'Keefe, resulting in his death. Fifth, that after causing such injury, the defendant failed to stop and provide name, home address, and registration number of the motor vehicle. And sixth, that the defendant failed to do so for the purpose of avoiding prosecution or apprehension. Jurors, I've already instructed on the first and second elements. The other four elements should be given their plain meaning, and the parties agree that I do not need to define these any further, correct? Okay, thank you. All right. As a general rule, you're permitted but not required to infer that a person who intentionally uses a dangerous weapon on another person intends to kill that person or cause him grievous bodily harm, or intends to do an act which, in the circumstances known to him or her, a reasonable person would know creates a plain and strong likelihood that death would result. An item that is normally used for innocent purposes can become a dangerous weapon if it is used in a dangerous or potentially dangerous fashion. The law considers an item, in this case a motor vehicle, to be used in a dangerous fashion if it is used in a way that it reasonably appears to be capable of causing serious injury or death to another person. In deciding whether an item was used as a dangerous weapon, you may consider the circumstances surrounding the alleged crime, the nature, size, and shape of the item, and the manner in which it was handled or controlled. That completes my second part of the instructions. I'm now going to turn to the third and final part, which is shorter. In order for a jury to return a verdict, that is, to reach a decision in a criminal case, the law provides that there may only be 12 persons on the deliberating jury, and you will note that there are 18 of you. To avoid the need for a new trial if one or more jurors becomes ill or is to be excused for some good reason, we customarily impanel extra jurors at the beginning of a trial, as we did in this case. Because of the anticipated and now actual length of this trial, we impaneled more jurors than are commonly impaneled. However, when you begin your deliberations, the law in Massachusetts is that only 12 jurors can deliberate. Therefore, at the conclusion of my instructions, Mr. McDermott will reduce your number to 12 on a random basis. The jurors not selected to serve in the jury will become the alternate jurors. If you are selected as an alternate juror, please do not feel that your efforts in this case have been wasted, because as I've indicated, it's important that we have extra jurors in case of an emergency. If we did not impanel extra jurors and a juror became ill, or for some other reason had to be excused, we would have to try the whole case all over again with the new jury. In the event that a juror has to be excused once the jury starts deliberating, then an alternate juror will be chosen to take that juror's position, and the jury will be required to start deliberations from the beginning. Therefore, it's important that the alternates not discuss the case with anyone else, including each other. For if an alternate becomes a member of the jury for deliberations, the alternate's views should be his or her own and not be influenced by anyone else. Different states and jurisdictions use different means to select a foreperson of the jury. In some jurisdictions, the jurors select their own person. In Massachusetts, the judge is responsible for selecting the foreperson. A foreperson of a jury has been described as the first among equals. He or she is responsible for organizing the deliberations, communicating with the court if necessary during deliberations, and presenting the verdict following your deliberations. The foreperson has no greater say or vote in the jury's deliberations. However, and in that sense, the juror is equal with all other jurors. I am going to ask the juror seated in seat number 1, your juror number 5, sir, would you agree to be foreperson in this case? I'm going to ask you if you would be foreperson in this case. Thank you. I always appreciate it when people say yes before I tell you what's involved, but thank you very much. All right. So the foreperson will be given the verdict slip setting forth the charges against the defendant. 12 jurors must agree. So, all right. So I skipped the line. And when you return to the jury room to deliberate, the court officers will deliver to you all the exhibits in this case, as well as the verdict slips that you'll be using. in returning your verdict. So the foreperson will be given the verdict slip setting forth the charges against the defendant. 12 jurors must agree before you have a decision to any specific charge. That means that to find the defendant guilty, all 12 must agree. To find the defendant not guilty, all 12 must agree. You should consider each indictment individually and continue deliberating until you've reached a final verdict. You should not begin deliberating until all 12 jurors are together in the jury room and should cease deliberating if any one juror is not present in the jury room. It is important that you not communicate with anyone outside the jury room about the deliberations or about anything concerning this case. Further, I remind you that no juror is better qualified to determine the truth of the facts in this case, to dispute or to deliberate on a verdict solely because of education, background, or experience. The parties and I have chosen each of you as fair and impartial jurors, and your voices have equal weight. To reach a unanimous verdict, each juror must agree. Jurors have a duty to consult with one another and to deliberate with a view to reaching an agreement, if it can be done without violence to individual judgment. At the same time, each juror must decide the case for himself or herself, but only after impartially considering the evidence with his or her fellow jurors. Don't hesitate to re-examine your views and change your opinion if convinced it is wrong. But no juror should surrender an honest conviction to the opinion of fellow jurors simply for the purpose of reaching a verdict. Although how you conduct your deliberations is up to you, I urge you not to begin by conducting an immediate straw vote. Rather, I encourage you not to take any votes before you've had completed a careful and thorough collective view of all the evidence. At this point, I want to remind you of an important issue that I raised with you at the beginning of this trial. I told you that our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. I also pointed out that we all have our own built-in expectations and assumptions, even if we are not conscientiously aware of them. And I talked about some of the ways we can try to deal with them. First, slow down. Do not rush to a decision. Hasty decisions are the most likely to reflect stereotypes or hidden biases. Take time to consider all the evidence. Second, as you start to draw conclusions, consider what evidence, if any, supports the conclusions you are drawing and whether any evidence casts doubt on those conclusions. Double check whether you are actually using unsupported assumptions instead of the evidence. Third, as you think about the people involved in this case, consider them as individuals rather than as members of a particular group. Fourth, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? Fifth, listen to your fellow jurors. They may have different points of view. If so, they may help you determine whether you are focusing on the facts or making assumptions, perhaps based on stereotypes. Of course, your fellow jurors could be influenced by their own unstated assumptions, so don't be shy or hesitant to speak up. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you find important. In fact, when you explain your thoughts out loud to other jurors, you are also helping yourself to focus on the evidence instead of assumptions. If you use these strategies, then you will do your part to reach a decision that is as fair as humanly possible, and that is your responsibility as jurors. Now, during the course of your deliberations, you might have a question concerning the law in this case. Perhaps I said something you did not understand. If you have any questions, please feel free to bring them to my attention by writing a note dated and signed by the foreperson and sending it to me by way of the court officers. I'm not suggesting for a minute that you have to have questions, but if you do, that's the process. Because your rule as the jury is to determine the facts in this case, I cannot answer any questions you have concerning the facts of the case. I have no role in this case when it comes to deciding what the facts are. Neither is it possible for me to provide you with a transcript of the testimony. If you send a question to me, I'll respond after consulting with the lawyers. Please do not ask a court officer or anyone else to answer any questions concerning anything material to the case. Generally, we will not answer a question or take a verdict from 1 o'clock till 2 o'clock, but I think you've all waited so long to get this case, I think we can change that. But the court staff needs a luncheon break. You'll have lunch brought into you, and you can decide whether or not you want to stop your deliberations during lunch or continue and deliberate. At the end of the day, if you're still deliberating, I'll send in a note asking if you want to continue deliberating or break for the day and return the next morning. Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before you until such time as you've reached a unanimous verdict. You are going to notice shortly that the court officers are going to take an oath, and you will hear from that they too, as well as all other persons, are forbidden to communicate in any way or manner with any member of this jury on any subject touching on the merits of this case. Remember that the decision of the jury must be unanimous, and the foreperson should be certain that each member of the jury is in complete agreement with the verdict on each indictment. After the final vote of the jury, the foreperson should check the appropriate boxes as to each charge, then sign and date the verdict forms and notify the court officer when you've reached a unanimous verdict. You will then be brought back into the courtroom where the foreperson will deliver the verdicts. This will be the last time I'm going to see counsel at Sidebar, but I'm required to see counsel at Sidebar.
She has to tell them who the alternates are before she tells them. I don't think the foreman choice is a bad thing. The juror does not come across as the kind of guy who likes Hank Brennan and blindly trusts police. He showed zero facial emotions the entire trial. That's probably why she picked him. That's from Turtle Boy. If it's a fast decision, in my opinion, it's not guilty. Otherwise, I think they're going to have to do a compromised verdict, something on the lesser counts of 2. That's where I'm stuck at. So I think if it comes back quick, not guilty. But she's now advised them that she doesn't think they should go in and do a straw vote. Which I don't understand why not. Go in and see where everybody's head's at. If you already agree on one situation, that move on. Guys, I have a weird scoop. I have a connection who knows Bev's son and is a lawyer with him in New York. Oh, wow. Here you go. Here's your bingo. I think it's going to be not guilty.
Could the juror sitting in seat number 13 step down and take your place as an alternate? Could the juror sitting in seat number 7 step down and take your place as an alternate?
These people are probably so fucking mad right now.
Juror 6, could you step down and take your place as an alternate? Juror 17, could you step down and take your place as an alternate? Juror 2, could you step down and take your place as an alternate? And Juror 8, could you step down and take your place as an alternate?
6, 7, 8. I'd be so fucking mad.
All right. Yes, please do.
Could I have the court officers raise your right hands? Do you swear that you will keep this jury in alternates in some separate but convenient place until they agree that you not suffer any person to speak to them and to speak to them yourselves, nor ask them if they agree, nor suffer them to disperse until they are discharged of their verdict, except by further order of the court, so help you God. Thank you.
All right, so members of the jury, I need not remind you that you have an important responsibility, but I believe that you will bring to bear all the wisdom and the judgment and conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide the case with integrity and with principle. We all expect you to reach an impartial verdict dictated by your logic, without bias without prejudice or sympathy, and not prompted by any facts except those that you've heard here in court during the trial. We are looking for impartial judgment dictated by your reasoning and the fullest discharge of your oaths as jurors. You may retire and deliberate your verdict.
Jurors, make sure to take your notebooks with you, please.
Hot damn, you guys. We're so close to being done. So, I mean, I think she called them up there so they could see that the amount of balls going in had the numbers of the remaining jurors and not seat one.
I'm going to see counsel one more time.
And then Turtle Boy says that there was only three black members of the jury. One is the foreman. The other two have become alternates. I don't know if that matters. I mean, as long as it really was random, it doesn't. There's no. It is what it is. I mean, you had 18 of them, and only 3 were black. The odds of that, I mean, the odds of them being pulled, I don't think is anything nefarious at all. I just think it is what it is. Make something that I don't think is something out of nothing. Sue said that her science, that the person she thought was really into the science is now an alternate. Right, one is the 4-person, 2 are alternates. Yeah, I don't think that it really. The guy with 4 notebooks didn't make it on the jury. That dude is so pissed. That dude is gonna be. I mean, I would be so freaking pissed. If I sat here for 32 days, got paid $10 a day or whatever their stupid amount of money is, $15 a day, and then got made an alternate, I'd be like, you fucking assholes. Not the science juror. Some brown folk don't like police. Marco, some white folk don't like them either, but I see your point there. I don't know. Like I said, if they all went up there, she showed them all the numbers. I think that was the first questioning shady thing of like, are all the juror numbers even going into the pot? Like, is that even happening? You know, that's the number one question. I mean, what are the balls weighted? So then, like the ones, I mean, that's the next conspiracy of how they're picked. So. The cop's been calling me all week trying to get a donation. I'm going for harassment. The fire department calls me all the time for donations. I'm like, legit fool, I don't have any money. I think no, I don't have any money to give you. Like, back up off of me. 3 days ago I didn't have any money. I didn't just win the fucking lottery and now come into money to be able to donate to you. Now, like, stop. Back up off of me. If he doesn't show the balls, he could be lying about the numbers. That's true. Like, you want him to like hold the ball up to the courtroom. That's true, Grayspace. I'm confused. I thought they only used alternates if they had issues. I've never seen them do it this way. I guess I haven't watched enough. I don't know. Well, so they always have alternates for the jury. It's actually just what's very surprising in this case right now is that none of them.
Judge, the first thing is counsel this morning and yesterday looked at exhibits, and I believe that we were pretty close. We had one exhibit that needed to be dealt with. Ms. Little, what number is that one again? 150?
Yes, this is exhibit 155.
155, and I'll let Ms. Little take it from there.
Yes, there's just one page, Your Honor. I believe, and my memory is not perfect, but I believe that we were going to have this redacted 7 it the same redactions from last trial. I think there's just one line here that needs.
So they're just going over exhibits. So the jury is out deliberating at this point. So what I was saying is that my what I'm actually very surprised about was that the entire jury made it to this point. Normally, by now, we've had at least one have to go, at minimum, for any case. Much less Karen Reed trial. You'd think at least 3 or 4 of them would have already been booted for something.
Okay, is the Commonwealth in agreement with that one line?
No objection. I believe those were redacted last time, so if defense
Okay.
wants to make that reduction, you can go into evidence.
Great.
See that Sharpie and maybe I can just take care of
I think we probably have one here you
I
can
have
have.
one. I definitely have one somewhere.
It's just cleaning it up for the record.
All right.
That's number one. And number two is, can counsel look at the verdicts and just tell me if verdict slips and just tell me if they're okay? Thanks.
You'll see that it's not what you provided me yesterday, Mr. Annetti.
Aw, Mr. Yannetti, you didn't get your way. Revisiting this, the best 3 jurors remained on the jury, including the 2 women, 10 and 11, who I believe are most noticeably impressed with the defense and fit the demographic of people who would believe Karen Reed is innocent. At this point, I don't think race, gender, nothing should prevent people from understanding that he wasn't hit by a fucking car. Therefore, Karen Reed is not guilty of hitting him with a fucking car. I don't think you could be fucking purple and not understand that. Yeah, they're gonna inspect the shit out of that form. Do you guys think she did a good enough job making sure that the jury understands that they can vote, like they can be hung on just one, unlike last time? And Jim's got loaded balls. They're very weighted. He's getting up there in age. Gravity does take effect. Karen's gonna enroll in law school soon. I wouldn't fucking be surprised, Indiana girl. Come to California, you don't even have to go to law school. You just take the bar. She's gonna come work for Jackson. Ew, see, gross. Blame Thomas. He started it.
Counsel, you can keep doing that. Mr. Rose, can you raise your right hand? Do you solemnly swear that you will keep that jury in some separate but convenient place until they agree that you not suffer any person to speak to them yourselves, nor ask them if they agree, nor suffer them to disperse them, they to charge their verdict, except by further order of the court, so help you God? Simply because you weren't in the room. Thank you.
I don't know whose name he said. I wasn't paying that close of attention. Hey, you can come out here and be a lawyer. You just got to pass the bar. And that, obviously they say passing the bar without going to law school is much harder, but people do it. I've contemplated it.
So, Your Honor, I understand that you've rejected our proposed verdict slip.
So everybody else can sit down. Mr. Yannetti can stand.
Thank you. I understand that you've rejected our proposed verdict slip. Our concern with this verdict slip is that there are 4 options for, actually more than that, 7 options for guilty verdicts, 1 option for not guilty. And we're concerned that this is too confusing for the jury. So we are asking that there be not guilty options for each of the charges, including the offense charged and each one of the lesser included offenses. We really ran into the same issue last time. I think what complicates it is the fact that there are two theories for two of the lesser included.
Do you suggest that doesn't accurately reflect the law?
It does reflect the law. I'm not saying that. I'm saying that it makes things very confusing, and that's why we believe that it cries out for some not guilty option, given the amount of options for convictions on this verdict slip. So
Okay.
we would again ask the court to adopt our proposed verdict slip.
So your proposed verdict slip did not cite any case law. Do you have any case law that supports that proposition, Mr. Yannetti? I have not found any. I've looked.
There's not a lot of case law out there in this verdict slip either.
Other than that has never been proven, has never been found to be inaccurate.
Not yet.
Okay.
And I mean that
So
with all respect.
that's fine. So your rights are reserved. Does that help you?
No.
Right, well, all we can do is object, Judge, and you make
Okay.
the decision.
Okay.
Judge, the last couple.
If you find authority for that, let me know.
We'll do.
Okay.
The last couple of things, judges, that we were provided with a clean computer laptop. Thanks. With a clean laptop. Defense counsel had a chance to, or at least defense had a chance to look at it, and I think that's fine. But
All right. So we'll send that in with the exhibits. I need to go edit my charge to fix all the typos.
and then the final thing is I provided counsel with the exhibit list that we had, and it was satisfactory for both sides.
Great.
Thank
All
you.
right. Thank you.
All rise to the court, please.
She's going to do verdict slips after they've already had lunch. They're deliberating now. So she's got to go in and she's got to go fix the shit that she found was wrong when she was reading the charging documents. That she was like taking notes when she saw the typos. And then the verdict slips are, I'm surprised they didn't take care of the verdict slips yesterday when he said like, this is our proposed verdict slip. And she was kind of like wishy-washy about it. Yeah, but I think it's not really about autocorrect. It's more about like bad form of English. So 7 guilty blanks and 1 not guilty. Well, I think what he's asking for is for all the lesser included counts on count 2, for it to be like yes guilty or no not guilty of this lesser included. Like they want. Like
there's no way that happened, but their ending was good. Recall, they being the prosecution, recall to some of the things that the defense did. The most ridiculous thing I think they did was presented this whole thing about the possible dog bite. And they were able to kind of take that and say, there's no scientific way. This person that they got to testify about the dog bite never has. They don't know anything about dog bites. They don't know what they look like, what they smell like, etc. So that's a good last thought to say, hey, go back to your common sense. Go back to the evidence that we have. And here it is saying that she's guilty beyond a reasonable doubt.
But Joe, the fact that you were able to just articulate so well either side, isn't that reasonable doubt? Isn't the fact that we really don't know what happened and you could argue either one, isn't that enough theoretically to be reasonable doubt?
There's no doubt about it. And to be honest with you, if I had to pick a pony, I would say the defense is in pretty good shape here because it's just not as clear as it needs to. Sure, the prosecution had some things to say, but the defense, the idea that the chief investigator was not testifying at all this time means you make the whole case about him. That's what the defense was going to do. The prosecution tried to sideswipe it a little bit, and they did the best job that they could, but it's truly taking a lemon and making lemonade, because if you were so sure Proctor would be a central witness, not just somebody that's talked about centrally, but the jury doesn't get to hear from.
Yeah, it doesn't get to hear from. Huge in this case, in my opinion. All right, just in the last few seconds, does it make a difference to, darn it, I lost my train of thought. I had such a good question I had to ask you to, is a hung jury a win for the defense? If there's another hung jury, do you count that as a win?
Absolutely, because they're up for 2. But what they really want is they want an absolute acquittal, and I think that it could happen. And I don't know if they're going to prosecute her a 3rd time.
Wow, it might happen. All right, we don't know what's going to happen. We're going to keep an eye on the verdict clock. It's 11 minutes, 25 seconds. Again, the jury is deliberating in the hearing.
11 minutes and 29 seconds. No, so based on the instructions this time, they could acquit on 1 and 3 and hang with no verdict on any of 2. So we obviously don't have it, but it would be like guilty, not guilty, count 1. Count 3, guilty, not guilty. But count 2, it's guilty of the full count 2 or guilty of one of the lesser included charges, and then or just not guilty. And so he wants it to say like count 2, the regular charge, not guilty, lesser included number 1, not guilty, lesser included number 2, that you're either guilty or not guilty. He wants it like specified. But I think this just comes down to why aren't the verdict slips like talked about during the jury instructions on how to fill it out? Do you know what I mean? Why isn't that more clear? I don't know. I've only been on one jury, you guys. So, and I didn't have any problem reading the verdict slip. It was very checkboxy. It's like, if you have this element, this element, this element, then your answer is yes. You think the person's guilty. But if they get stuck on either lesser, there's no way to mark not guilty, manslaughter, but nothing on the 2 lessers. No, you only mark one of the lessers. If you find her guilty on one of the lessers, you mark the lesser. Because you can't be guilty on the charge and guilty on the lesser included. You can only be guilty of one. So it's not like I can be found guilty on count 2 plus found guilty on each of the lesser included charges. It's you're guilty of the charge, or you're guilty of one of the lesser included, or you're not guilty of count 2. There is only one not guilty for count 2. So I understand her point. I think the bigger issue is just making sure they understand how to read it and that part's clear. You can't be found, if you put a not guilty under each box, then you don't need a not guilty at the end. Does that make sense? Indiana girl. No, I think the issue isn't about the verdict slip itself. I think it's about making sure that a juror knows how to read a verdict slip, which I don't understand is why that is not discussed more so. No, because you're still guilty on count 2, just one of the lesser charges. It's still the same count. They're not different counts. So you're still found guilty of count 2, but on the lesser of the charges of count 2. If they think she might be guilty of one of the lessers, they're not going to want to mark the main charges not guilty. Well, they can't, because it's still count 2. Yes, you have to. Well, no, because no. I don't think you have to be like. I don't think you have to mark not guilty to go to the next one. This is the count, and then these are the lesser included. So if you're not guilty here, then you go to here. You just don't mark it. You're not marking it because you're not finding her guilty on that. And if you find her not guilty on the entire count, then you just mark the bottom. That's what her instructions told them last year. Yes. That's why I said I think it's not necessarily about the verdict form itself. I think it's about making sure they understand it. How one person in that jury room last year thought that one, much less 12, which is another reason I just have such trust issues with juries at this point in my life. Not one person out of 12 thought, we should be able to vote separately on all of these, and if we aren't sure, we should ask. Not one of the fucking 12 thought about that. Not to mention the jury last year had a foreman who'd been on a jury before. But they're starting out without the instructions on paper. I think that's fine. I mean, they're just going to go. I think they're just going to go in there. They're either going to decide if they're going to do a straw vote, which she's pretty much told them not to do, and then they're going to decide what they're going to, what if they want, what evidence they want to look at. I still think they should do a straw vote, but that's me. The foreman can't answer. Once again, this is exactly why I think that during the jury instructions, it needs to be clear on how to fill out a verdict form. Doesn't matter. Well, doesn't matter what Ronnie says at all anyway. So this is how you do it. Last year, she said they had to be in agreement on all charges before they completed any forms. This year, she said complete and sign each indictment when they agreed. So that was my question earlier, was like, did you guys feel that what she said this year clarified that enough for them to know they could go to each, like, conclude each count individually? We make a video about the easy shit and just, here you go. Here you go, courtrooms. You can just use this. It's like on old school VHS in the jury deliberation room. So, but she just had a couple typos, so they're going to have the instructions. I mean, within minutes. I don't think that's going to be a big deal.
Read case, and you don't want to miss it.
I wanted to see that. Why did it skip ahead? Now I'm like Sleuthie over here. Shit's just skipping around.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott. Of course, honored to be with you today. Court TV is in Dedham, Massachusetts, where the fate of Karen Reed is now in the hands of the jury. You can see the clock is up. 16 minutes is how long this jury has been out deliberating. Reed's first trial, of course, ended in a mistrial last year after the jury could not come to a unanimous decision about whether or not Reed intentionally struck her boyfriend, Boston police officer John O'Keefe, with her Lexus SUV. Prosecutors point to fragments of Reed's taillight at the crime scene as evidence of a collision, but the defense believes that Reed is the victim of a wide-ranging cover-up by O'Keefe's friends and local law enforcement. Right now, let's bring in Court TV crime and justice correspondent Matt Johnson, who is live outside of the courthouse. I say this every time.
I just want to be clear. She said by O'Keefe's friends. I don't think any of those fucking people are O'Keefe's friends. Jen McCabe, Carrie Roberts, they weren't. They think they were, or they want to be now and say that they were friends with John O'Keefe. But if anything, they were the glorified rideshare, and that's all they were. So, I don't think so. His friends, his actual friends, didn't have anything like that to say about Karen.
Remind everyone, Matt, that you were there the entire first trial. You've been there the entire second trial. So tell us, if you would, please, first, the mood at the courthouse right now.
Yeah, it's a bit of deja vu, Judge Ashley. We are standing outside the courthouse here in Dedham, Massachusetts. This jury, the deliberating jurors, are now in that jury room, and we are officially in a verdict watch. Just a few minutes ago, this defendant, Karen Reed, along with her attorneys, were walking down the courthouse steps, making their way through the crowd of supporters, hundreds of people.
I will politely disagree with Indiana Girl. That being said, honestly, I think Carrie was manipulated by Jen severely. I disagree. I do think she was John's friend and had nothing to do with any of it. I disagree. I think that she's a bitch, and I think that she treated Karen like the bitch she is, because that's how she talked to her, telling her to shut up, to saying that she was crazy to Jen before they even got out of the fucking car. Shit like that. Nah, I don't think Carrie was his friend. So Carrie was the neighbor of his sister. So she was a person that was useful because she helped with the kids after his sister and brother-in-law passed away. I do not think she was friends with him. I don't think he called her and was like, hey, Carrie, you want to go hang out? And I think Kurt, on the other hand, was probably closer to friends with John, but Carrie was just a means to an end. And I think that she was a bitch to Karen the entire fucking time. So I don't think she was necessarily manipulated. I think that she was an easy target for Jen because she was already a bitch.
People that are here at this.
Carrie went to prom with John. I know she did, because that's another issue of why I think she's a bitch, because I think that her and Jen both wanted to be with John, and neither one were.
Courthouse in Dedham Square, along with medium from all across the country. They are all also in silence as they stand behind this defendant. Let's listen to Alan Jackson from earlier today. Take a listen.
This means more to us than you can imagine. But if the volume comes up even a little bit, we're gonna be ordered to stay in the building, and y'all are gonna be ordered off the lawn. So just please do us that favor. This means as much as you yelling out. Bless your heart.
Thank you, Jackson.
God bless you.
All right, and again, just moments ago, as I mentioned, they just left the courthouse here as we're in verdict watch. Let's listen together.
Happy with the jury selection process for y'all? Alan, guys, we're not going to make any comments right now. We will see you in a couple of minutes, though.
David,
how will you spend the time waiting? David, were you in there this morning?
See you in a couple of minutes, though. Why are they seeing him in a couple of minutes?
You'll think something? Wait, I get a no comment from David after all this time?
I was in the courtroom. I was not in the. I was in the courthouse, not in the courtroom.
Yeah,
all coming up, guys. All coming up. Here, left. Sorry. Random nature.
Yeah.
Mr. Yannetti, were you surprised you didn't have the verdict slip ahead of time?
You okay? I'm right here, man. You're still good? Wait a minute. Sorry, guys. Oh, is this me, John? I'm sorry. We're right around the other side. I'm yes. All the lawyers yes.
Sorry, I'm
Hospital.
Thank you. Karen, do you have a message for your supporters? I hope that.
You stay strong. You stay strong.
Very much resembling what we saw this time last year, the number of supporters for this defendant growing in numbers, many of them wearing pink, but they are being silent this year because they are within the buffer zone and they are told not to hold any signs or to make any noise, shouting or cheering. So we haven't heard that much. But last year, if we are going to compare again, the deliberations ran approximately roughly 3 to 4 days over a span. And of course, that ended in mistrial. Today, we're learning that they are allowed to deliberate this second jury until 5, maybe 5:30 today.
All right, Matt, now tell us what specifically do we know about this jury?
Right. So 11 weeks ago, jury selection began here at the courthouse behind me. So what was impaneled was a panel of 18 jurors that heard the case all the way through. We did not lose a single juror throughout the process. We had 9 men and 9 women. It was a complete split. And they heard testimony from 49 witnesses over 8 weeks of trial. The deliberating jury, we just learned just moments ago, that is comprised of 5 men and 7 women. The jury foreperson chosen by the court. That person is seated in the first seat of the jury box. That was the case last year as well. And as I mentioned, that's a man.
All right, now talk about these closing arguments. I'll tell you what, they both came prepared. No surprise, you've got very good, zealous, great attorneys on both sides. What stood out to you about these closing arguments, Matt?
That's a good way to put it. Very zealous, very energized, and completely silent courtroom. And keep in mind, it's a very tiny room. We had Alan Jackson and Hank Brennan, the special prosecutor, squaring off for the closing remarks. The defense goes first in the Commonwealth of Massachusetts, doubling down on reasonable doubt and a faulty police investigation, as they put it. And the prosecution, the Commonwealth, doubling down on her own admissions, playing clips of TV interviews, but also each was referencing their experts, especially their crash reconstructionists. Let's listen.
There was no collision. There was no collision. There was no collision. You folks are the last line of defense.
Members take so many notes, they have a stack of notebooks from this 8-week process. Today, they were fixated on these attorneys that were delivering those powerful closings. Judge Ashley?
Thank you, Matt. Very powerful closings, and they have a lot to talk about back in the deliberation room. Thank you to Matt Johnson, as always. I'd like to welcome our guests for this hour. Joining me in the studio, we have trial attorney Miguel Custodio, and also joining us, trial attorney Jean Rossi. Thank you, Miguel, for being here in person with me. Always appreciate you. Let me start with you, please. Tell me your thoughts as this jury has now been out for 23 minutes and what you think it might be like or where this might go.
I think, first off, hats off to closing arguments by both sides. They were masterful arguments. I thought Jackson really played into the passion and the corruption theme, whereas Brennan was just about data and just facts. He was very methodical, and I thought that was great. I personally think that the jury here is going to be very, very confused about where to go. I really think that there's a lot of doubts that have come up here as to the investigation of the police, and I think that really just doesn't sit well with jurors.
Yeah,
If that doesn't sit well with the jurors, why are they going to be confused on where to go?
Agree with you. This jury has so much on their plate. Jean Rossi, of course, great to have you. But Jean, tell me, what do you think about where this jury might be and how you think it all shook out with each side, really excellent attorneys on both sides?
My view is this, based on winning some and losing some. When you have two powerful closing arguments in a case that focuses on data.
He also agrees that Hanks was powerful. I thought Hanks was garbage.
Yeah. And there's no eyewitnesses, and there's a lot of conflicting testimony. I think that inures to the defendant's benefit. That's point one. Number two, if we get a verdict today, it's going to be not guilty.
Yep.
But we're not going to get a verdict today. The jury is exhausted. They want to go home. There was a mention of the stacks of notes. They're going to deliberate probably till 5 p.m. today and come back Monday. I predict a verdict by late Tuesday or Wednesday. And if I had to bet money, if I was in Vegas, I think the odds are in favor of her getting, at best, an acquittal, and at worst, a hung jury. And here's why. It goes back to what I said a couple days ago, Judge Ashley, when you have a battle of experts, and you know, the prosecutor kind of led with his chin in the sense, this is about data. Well, if you have a battle of experts and one side says, oh, there was this hit and then the car was moving this way and that way at the right time, and then you have another couple of experts that said, no, this didn't happen, a jury is going to be torn with that. And I think that the defense looked at the first trial and pruned their case in a brilliant way. And we talked about this a couple of days ago, where they got rid of some witnesses in the house. So they got rid of all that stuff. And now they're just focusing on data. So when the prosecutor said this is a case about data, it could easily be said that defense is about data. So that's why I think it's leaning in my gut, my Malcolm Gladwell gut, is that she has either a hung jury or an acquittal.
Wow. All right. So, Miguel, weigh in on that. And I have to say this, as Matt said, 3 to 4 days last time when there was a hung jury, Jean. And what must it be like? 2 questions for you. First of all, where do you think they might land? But second of all, what must it be like for any defendant, much less a Karen Reed that the entire nation, likely world, is following, watching, and either supporting or not, to have to wait while this jury deliberates?
I think there's going to be a hung jury again, and I just...
Hey, Travis, what's the official time they went out? Well, according to Court TV, they've been out for about almost 30 minutes. I kind of paid attention. I think it was right about 11:50 my time.
So I don't know if the prosecution really convinced the jury here in this case. I mean, there are just too many little holes here that I think creates a reasonable doubt. Karen Reed right now is probably very confident. I think she's very confident in what's going on. Obviously, she's nervous. She's very, scared of what's going on, right? Because there's always a consequence that she can go to prison. But I really think that she's in a really good position right now.
And I'll tell you, watching her today, no comment when they left the courthouse, when the jury began deliberating. That's unusual. She's been saying things. She seems very hopeful. This time, she didn't have anything to say. I want to listen together, gentlemen, and then circle back to Eugene, what the judge had to say about the jury instructions, because we know the defense was concerned about them, argued for some changes because they wanted to be clear what was in those. Let's listen to that together, please.
And I will give some version. I know that there was a lot of attention paid and some appellate decisions on the each individual indictment. I'll give some further language on that. You've got an instruction to propose on page 4, reaching a verdict. I will make it crystal clear, though. I think it was, and I was upheld on it. So I will make it crystal clear.
All right, let me ask you, Gene, because I believe that you may know this judge, and I think to me what it meant was, listen, it was clear before, but I'll look at it again because we want to make sure the jury knows exactly what the law provides for that they have to follow.
Absolutely. A full and fair disclosure. I'm a big fan of the judge. We teach at Harvard trial advocacy law. And I was the courtroom deputy in the mock trial. So I was the one standing in front of her, sitting in front of her, swearing in the witnesses at the mock trial. So I like her a lot. But this is the nerd in me. I love.
At what mock trial? In school? What is he talking about? What mock trial?
Jury conferences. I can't tell you how many trials I've had where I've gained a little advantage or lost an advantage of significance during the discussion about what you're going to read to the jury. And I can't tell you how important jury instructions are, because whether you're defense attorney or the prosecutor, you're going to hold them up or refer to them, and they could help decide your case and create either a guilty, hung jury, or an acquittal.
I absolutely agree with you because, Miguel, the jury instructions, I mean, that's where the rubber meets the road. They go back there, they decide which facts they agree on or don't agree on, and then they have to look at those to say, and this is the law we have to apply. If there's any bad wording, wrong wording, confusing wording, it can throw a jury completely.
Absolutely, because we got to remember, jurors are lay people, right? So they are not exposed to this type of language on a regular basis. And so every single word matters that they're reading in terms of the jury instructions. So it's very important that it's clear, crystal clear.
Yeah, you're right. That's a great point. It's lay people that are having to make this decision and follow those instructions. Well, good news. We get to listen to those jury instructions together because we do need to hear exactly what this jury will need to consider while they're deliberating. Again, 30 minutes. We have been bringing you all of the closing arguments, which is why we're just now getting to the jury instructions. And then
yeah, okay. So I'm going to leave this one. And Betero popped on with Sean from Potentially Criminal and Bob Mata. So I'm going to show you guys that, and let's see what the lawyers are saying.
Speech, which was fine, how Proctor basically is a dirtbag and all of that, but why wouldn't you do that and say 5 minutes told last year?
Instructions and my verdict slip. The jurors didn't people go on.
I just want to see when Better opens on.
When Hank stood up there and
she said crystal clear. She knew the judges were confused. It doesn't make any sense to me how she could just say there's no legal authority. The SCJ said, or the SJC said that I was right. And even though I know jurors were confused, I'm not willing to unconfuse them.
Why can't you just put a not guilty next to every guilty and make it clear what you're suggesting? I mean, it's not rocket science.
No.
So I got chills with Alan Jackson's closing.
It was good.
It was really good.
No, that was really, really good. And it was perfect tone, perfect delivery. I was, hammering reasonable doubt, hammering the science, obviously, weaving in nicely some of the other problems they had with the case, and finishing up again with the science. And I mean, I loved it. I thought it was a home run. And the idea of making the little electronic board with the sticky notes of reasonable doubt is perfect. And I don't think Brennan addressed 10% of it, which I mean, that's a whole nother conversation, what he did, which I still don't know what the hell he was doing.
I know. And you had Alan Jackson say, I venture to guess he's going to ignore those x-rays. He's not even going to mention it. And his silence speaks volumes over and above any concocted, he didn't say bullshit, but, bullshit excuse that he can come up with. And that's exactly what he did. Now, there's a couple things I thought AJ should have added in there that he didn't, but one that stands out to me that could have been switched to a Commonwealth trying to pull the wool over your eyes was about the weight of the arm. I would have wanted to hear him say something like, and what did Hank try to do? Why did the Commonwealth go after Dr. Wolf about using the 50th percentile arm and act like it was outrageous and try to impeach him on this and make it seem to you he did something wrong when their very own expert used the same thing? And when Dr. Rentschler explained, this is the way it's done in the standard industry. And I bet you, despite all of that, Mr. Brennan's going to get up here after this and try to tell you that Dr. Wolf did something wrong using the same 50 percentile arm that their expert used and sort of take the wind out of that.
That's exactly what I thought. I'm like, did they ever talk about what that dummy, if that dummy that he threw on the ground was a 50 percentile? Because I bet it was.
That sale.
Yeah, to me though, the part that was really stunning is what did he do? Brennan probably spoke for almost an hour and a half, and I think he must have given no more than 5 minutes total to any form of science, whether it be a pathologist or an engineer altogether. And of the approximately 5 minutes, it seemed that a lot of that was spent on Signal, deleting text messages, eating sandwiches, and taking Uber rides and all that nonsense. And then I think he even said at the very end, as far as the ARCA guys, I don't want to get into that too much. Dude,
I'm not going to dignify their response.
Yeah, I mean they annihilated your whole case. You might want to talk a little bit about that, as opposed to maybe spending more time on analogizing your theory of murder to some teenage punk throwing a rock over a cliff.
The worst analogy to me. I was like, this analogy is literally crazy. It doesn't speak to what he's even trying to say that she did, and he builds it up like she makes this decision and she drives forward and she puts it in reverse. And then he breaks to say how I'm not going to tell you that was intentional for him to kill it.
So he gets the last word. It's such a huge advantage, obviously. And, you would expect that he would have, I understand he has a script. You could tell he's, whatever. And he's very good at not using notes and all that stuff. But it's remarkable that he didn't, in responding to the defense summation, I mean, they really bludgeoned him with so many easy to understand concepts of reasonable doubt. And he just stuck to his script and didn't even address and pivot. And that's surprising because he's very experienced. He's been around a long time, whether you like him or not. He knows how to do this. And it's just, he said, I'm sticking to my script. And he really didn't respond to any of the very strong arguments.
Right.
He wanted to do it his way. And to me, that was a huge mistake.
He didn't even mention the damn x-rays. I'm going to swap out for Bob. So, and then I'll come back and join you guys.
Downgrade. Downgrade in progress. Downgrade in progress. Gentlemen,
Also,
how are you?
Mark, nice to meet you. I haven't had a chance to really run into you.
Sean.
Neither, Mark.
Mark Betterow.
Yeah. I'm a schmucky attorney in Cleveland, so there you go.
All right. Well,
I'm not a big fancy Boston lawyer like some of
neither
we're
am I.
watching.
I'm just a Boston move to.
Travis said that the problem here is that there are some great instructions and a couple of really good ones for the Commonwealth. The one big one for the Commonwealth is inferences and circumstantial evidence with the postman.
Sleazy New York City, but what's that?
So what did I miss? How was the jury? How was the charging of the jurors?
I didn't watch, as I just confessed.
Bev is awful. Bev is an awful judge, and it came through there. The verdict forms were not. Nobody saw the verdict forms until about 10 minutes ago.
Wow.
Which, like I said, I'm out here, shoeing horses in cow country when I go to trial. But we even get the verdict forms before the jury gets them. Like it's just nonsense what she's done.
Yeah,
Are they using pattern? do they use pattern instructions in mass or? Like,
How could they not? You'd have to think they do, but
Bev says they do.
why wouldn't they look at the verdict sheets before she gives the charge and sort that out?
Yeah.
What is the point of a charging conference if she's going to write up some shit and show it to him 10 minutes before she's going to read it? Like, that's the whole point of a charging conference, so you can like debate and argue and bicker about what you wanted to say. Wow. I don't know. I don't know.
Did let him. I missed. Yannetti gave her the defense's proposed verdict slips. She said she'd take them into consideration. She let him make his point. And then she came in today and did what she always does. She did it Bev's way.
What did you guys think of the Mark? I caught the ass end of your evaluation of the closings. Yeah, dude, Brennan, like zero factual evidence geared argument at all. He wove a tale. Like, he literally just wove a story about what he thinks happened using
it. I think part of his, I mean, obviously, if you had a perfect world, you would, walk around, no notes and all that. And he's good at that. He definitely is one of those. That's fine. But I almost wonder if in this situation, he damaged himself because he had a script and he was going to deliver it. And it becomes harder if you're going to pivot and go to respond to what he's saying, to walk around and not be, maybe attached more to the program, if you will. And he just seemed bent on wanting to do it his way, but he wasn't responsive. He had the last word and he gave it away. You wouldn't even know that he was responding to Alan. They could have given those simultaneously, like same time submissions. I mean, how do you not go after these compelling points that, the sticky notes, the electronic sticky note that was going up one at a time, and not try to dismantle those? I don't get it.
Well, even worse though for Hank, and this is something, he didn't even start off with the most obvious thing, which I would have, Alan Jackson says there's no collision, there's no collision, there's no collision. You know what? There's Hank could easily just started with, I hit him, I hit him, I hit him. Regardless of whether or not you think that's bullshit or not, that is a very powerful thing. And just starting off with that, he didn't even do that. And
that would be addressing some of the things that, or another thing I thought he could have come right out. I mean, there came a point, but it was like an hour and 10 minutes into it where I think he mentioned the word Proctor for the first time.
Yeah.
And, when he gave that little speech, which was fine, how Proctor basically is a dirtbag and all of that, but why wouldn't you do that and say, ladies and gentlemen, let's get in front of something right here and right now and talk about, he called him the boogeyman. And why he's not necessary in their view. Why would you just kind of bury that an hour and 20 minutes into it when you've already kind of lost the jury? And why would you not address the science? Why are you talking about all this stuff about, and they pulled up here and they did this? And I mean, his strongest arguments or, these freaking clips.
Oh, Mark, I said, imagine a world in which Karen doesn't do the interviews and try to imagine what that closing would have looked like.
Oh, that would have been awful.
It would have been terrible.
It's devoid of any kind of evidence or facts, and they're the ones with the burden.
But even the clips, how are you overcoming the science?
That's the thing.
Well, you can't.
Yeah,
he just didn't address it at all. It was,
and that's where I think Alan Jackson, messed up a little bit. He should have said, "Yeah, the data doesn't lie. John O'Keefe's arm isn't broken. So there's, either John O'Keefe has an indestructible arm." And I think that's where they should have really focused.
Data, that's the science. That's the science behind it. And he does say the science doesn't lie.
On the fact that even Walter said, well, I'm not going to stand there and get hit at 20 miles an hour.
Yeah.
It's because your arm's going to break.
Right.
Either John O'Keefe.
Yeah.
And either John O'Keefe, yes, was one of these astronomical lottery ticket odds of he got hit by a car and nothing happened to him. Which, point out to jury, you don't get to be unreasonable doubt by saying, oh, well, maybe the 1 in a million thing happened.
Right.
What is the most logic? Why would you not do this yourself? Because you don't want to get hurt. And he didn't get hurt. And, this is where the data doesn't match the reality of what you're seeing, well, something's wrong. And John O'Keefe's x-rays are correct. So then something else doesn't add up. I understand a lot of people are very confused. Like, well, what about all the glass? And I know there's a lot of people who don't believe the theories of planted evidence, but yes, people have survived falling skydiving and their parachute doesn't open. That doesn't mean we can all go do that. The logical outcome is
I wouldn't try it based on the fact that a couple people have survived.
Yeah. Or I think the funny one on Twitter is they're talking about the guy who survived the plane crash in India. And they're like, well, he survived. I'm like, what happened to the other 250 people on the airplane?
Jesus.
Yeah.
Mark.
The Twitterverse.
I'm just saying it's a great example of just when your reality, when your perception.
Grace says the difference between the 3 charges in count 2 are 1, intent to do a thing with high likelihood of death, 2, intent to do a thing recklessly and wantonly, and 3, no intent and just negligent. It's just essentially saying that you know that your actions could cause somebody to get hurt or die, and you either you intend to do it, or you intend to do it and with reckless and wantonly, or 3 without intent and just because you're negligent and being an idiot and did it anyway, but you knew it could result in somebody getting hurt. Does no accident require the jury to believe planted evidence? Yes, I think it does. I think it does. For me, Rentschler kind of said it best. It's like, yeah, all these things might be there, but if there's no accident, then there's another explanation for them all being there. If he's not hit by a car and his body shows that he's not hit by a car and the car shows that it didn't hit his body, then there has to be another explanation for it all being there. Whatever that explanation is, it's not up to him to decide because it's not something that he needed to take into consideration. I think that's probably the best way to do it. It's like, can the jury see it like that? Can they go, okay, regardless of how all this stuff is there, they're saying he's not hit by a car. And that's what we have to determine. We have to determine whether he was hit by this car. And we don't have to determine how all the other stuff got there. I think if they look at it like that, which I don't know if they will, and that's what Hank's hanging his hat on is all of this stuff is there because she hit him with the car. But he's skipping the point that the injuries don't match and the car doesn't match the injury. So if she barely hits him where he doesn't break any of his arm or any bruising on his body, then the car has to just barely tap him like at 2 miles an hour, right? And he's intoxicated and falls over and hits his head on the ground. Or it has to be going so fast that it shatters the taillight and shatters John O'Keefe, which doesn't happen. I don't know how they'll look at it. If they look at it like Hank, they're looking at it backwards and saying all of these things you have to conclude she hit him with the car. If they're looking at it from point A, which is what they're supposed to be determining, which is did she hit him with the car? And if his body shows that she didn't hit him with the car, then I don't think they have to care necessarily how all this stuff got there. So the second degree doesn't include intoxication or driving. No, it's just second degree. Yeah, so it's not up to them to figure out how all the shit got there. They don't have to.
Don't match reality.
Hold on, Travis says, then those are tough cases. To get a jury to believe planting would happen, defense has done very well to show that that's a distinct possibility, but explains why they wanted lesser included just in case. Right.
You need to reevaluate your perception. You don't reevaluate reality. And I think Jackson could have really hammered on that and just say, look, she couldn't have hit him without her. If he didn't get hurt, if he wasn't hurt, she didn't hit him. Or I don't know. Try to be a little cute with that. But I think the only thing I was thinking as I thought about that is, Hank could say, well, you know what? He got hurt. His skull fractured. But I don't know if Hank would have been that slick to counter that. based on things there. But
I don't know how he could have. I mean, my thing, I thought it was a home run as well by Jackson. I was exceptionally impressed with it. And like I was telling Mark last night, it's like I'm not a reader. I've never kind of been chained to the podium and gone through. But the advantage to doing that is it's well rehearsed, and we know that Alan fine tunes that thing immaculately, and the delivery was beautiful. It was poignant in all the places you wanted it to be poignant. You needed that strong constitutional language in there, and he hit everything that I wanted him to hit, and he gave the appropriate shade to Higgins, and because it equaled exactly what they put forth during the trial in terms of the cross. You know what I mean? He did what he needed to, and he touched on what he needed to touch on.
So I thought he did a masterful job in dealing with Higgins and Proctor. I mean, look, as you know, I would have called them even still, but knowing what their strategy was and how they were going to do it and not calling them, I thought he did a superb job in using Higgins. Obviously, there's a lot of sketchy things, and the jury's going to wonder, again, not that it's the third party culprit. Obviously, they're not arguing that, but tethering the Higgins sketchiness to Proctor and saying they didn't even look. Very good job at that.
Great job.
If you're not going to call them, he did it the right way.
I mean, you need a boogeyman, because if John didn't get hit by the car, how the fuck did he die? You know what I mean? It's like you need to give the jury at least that much, and he planted the seeds beautifully. And Mark, as we both called for, and I'm sure, Sean, you've been calling for it on your, I mean, they pounded him over the head with reasonable doubt, what it is, how it's defined. Read it repeatedly, talked about the concept of moral certainty, and I agree. I loved what they did, and we didn't really get to see it the way that the jurors were seeing it in terms of the sticky notes of like reasonable doubt after reasonable doubt, like all these different things are reasonable doubt, and like it's everything I could have asked for in terms of them just absolutely pounding them over the head with what the concept of reasonable doubt is, because that's where this case lives. So, I mean, I gave it an absolute A+, even taking into consideration that I'm exceptionally biased. I mean, my position on this case is very clear. It has been for a long time. Notwithstanding that, the guy fucking knocked it out of the park. The thing,
he really did a nice.
Yeah, I mean, like us as attorneys, when you're watching it, and Mark, you were talking about it last night. I love watching closings, and I was excited to see what the fuck Hank was going to do, Disappointed, he whiffed just like I thought he would.
Yeah, like we were talking about last night. I mean, in many ways, I was more intrigued to see how the hell is he going to dig himself out of this. And he started with, the sympathy factor. And I'm like, all right. I mean, and he actually, by his standards, was almost emoting. He was almost sounding, like you actually are able to modulate and sound more than just that,
monotone, droning.
And so I'm like, all right, he's going to like try to butter him up and then go for the jugular with when he's got him all soft. I'm like, let's see where this goes. And then 3 minutes of that. And then it just turned into we're right back where he started and what he's doing. And you start looking at your phone and doing other things. And it's not like we're like Alan just grabs you.
I was riveted.
Yes. Yeah. I mean, he just grabs you with the manner of delivery and the substance. And, again, Brendan's going, and I'm thinking, when is he going to get to the science? So it's getting late. I mean, I can't believe this.
Mark, I tweeted, I think he was about an hour 10 in, and I said, I'm still waiting for, I'm like, he's well into deep into this thing, and he hasn't talked about any of the evidence.
Well, this is the funny thing. Look, obviously none of this is all that compelling to me, but he didn't mention the cert taillight recovery, which if, look, you're going to argue it's not planted, there is a motive or an opportunity to plant that. But, from his perspective, do you really think that could happen? He never, as far as I could tell, unless I was daydreaming because it got boring, so I might have tuned out. I don't think he mentioned the shards of glass in the hoodie because
He
I don't think he wants to touch the hoodie. It's like the third rail for him now.
Yeah.
He is because of what he did, and he got clobbered on that and never pushed back.
That was smart of him not to go there.
Right, but he made his own bet on that.
Well, I don't think he could talk about the hoodie at that point because then he'd have to address what Jackson said in his opening about the sneaky Pete of it all.
So he never talked about the CERT team. He never talked about the shards of glass.
Look, Matt, thank you.
He never talked about all this, so-called powerful evidence that is supposed. I mean, he basically abandoned Welcher for the most part.
He abandoned Burgess.
And then misled on his LinkedIn. No, my guy, they didn't mislead. He lied.
Well, and the funny thing that he did with Burgess is like, oh, you all can laugh about him and his, his little LinkedIn not being updated. And like, no, the fucking guy lied flat out.
He made up a degree that does not exist.
Yes.
Nobody else could have done.
Okay, let me show you guys the verdict slips here. And let me just save them because I can't zoom in. This is, you guys can't see that. That's ridiculous. Hold on. What the heck? Okay, let me bring this down for a second. I'm going to start closing stuff on my computer. I can tell it's starting to go slower with having so much stuff open. It doesn't want to do what I want it to do. Okay, so here's... is this last year's? Nope, this is this year's. Okay. Here's one, murder in the second degree. In the above entitled case, we the jury say the defendant is not guilty or guilty of offense as charged in the murder in the second degree. So super simple. And then I'll skip to count. I know I skip her over 2 because the two we have to talk about more. So I typically go from 1 to 3 and then back to 2. So 3 is leaving the scene of an accident resulting in death. In the above entitled case, we the jury say the defendant is 1, not guilty, 2, guilty of offense as charged leaving the scene of an accident resulting in death. And then here is the one that they want changed. So here's the offense 2 is manslaughter while operating a motor vehicle under the influence of liquor. In the above entitled case, we the jury say the defendant is 1, not guilty of the offense charged or any lesser included charge or offense. Any lesser included offense. So that's off the bat, not guilty. 2, guilty of offense as charged, which is the manslaughter while operating a motor vehicle under the influence of liquor. So you can check one or both. They only have to find one of these, or they can find both that they believe apply to make her guilty of this manslaughter while operating a motor vehicle under the influence of liquor. So 1, manslaughter while operating a motor vehicle under the influence of liquor, or manslaughter while operating a motor vehicle with a blood alcohol level of 0.08 or greater. So could be both, could be 1. Now here's your lesser included. So guilty of lesser included offense, which is involuntary manslaughter. Next one is guilty of the lesser included offense motor vehicle homicide, which is a felony OUI, operating under the influence of liquor and negligence, check one or both. So here's one: motor vehicle homicide by operating a motor vehicle under the influence, or a motor vehicle homicide by operating a motor vehicle with a blood alcohol level of 0.08 or greater. Then the next one is guilty of a lesser included offense, operating under the influence of liquor. So operating a motor vehicle under the influence of liquor, operating a motor vehicle with a blood alcohol level of 0.08 or greater. You check one or both. You just need to have one for any of these. So what Yannetti was asking for is under these three, wants a not guilty. So guilty of this lesser included or not guilty. Guilty of this lesser included or not guilty. Guilty of this lesser included or not guilty. So the not guilty of the offense charged or any lesser included offense is what she's saying encompasses that whole thing. So she doesn't need one under each one, and he has no case law to say that there should be one. And he says, well, there's no case law to say that this is okay, but yet we still use it. So they just want it to be like, here's the offense charged, guilty, not guilty. Here's the lesser included, guilty, not guilty. Lesser included, guilty, not guilty, guilty of lesser included, or not guilty of lesser included. He just wanted it for each one of these lesser included charges. Yeah, the charges and the lessers are exactly the same as last trial. Let me see. Plain OUI is a new lesser included. Plain I think I'm pretty sure I have the ones from last year too. Let me go see. I think they're identical. That's what I was at. 0.5 was not there, or 5 point was not there. Hold please. Let's see if I can find them. It's getting warm out here today. Gotta let that load for a second. I gotta close some stuff down on my computer because it's getting a little overloaded. Watch me not have them in this file anyway as I sit here and let all this stuff load. To me, it looks exactly the same, but I mean, shit, that was a year ago. I've done a lot of stuff since then, so I'd rather find it and then, let me see if I can Google it. Okay, so on this one, this is 3. 3 was here. Nope, that's 1. Let me go. 3's here. And in case the jury said the defendant is not guilty of offense charge, leaving the scene of an accident resulting in death. That is exactly the same. And then we go to 1. In the above entitled case, we the jury say the defendant is not guilty of offenses charged, murder and insanity, 25. That is exactly the same. And now let's look at 2. The above title case, one not guilty. Okay, so this was not there. This not where it says not guilty of the offense charged or any lesser included offense. This whole part past not guilty was not there. I'm wondering if this is the proposed ones or if this is the actual one though. Because remember, shit, I don't have a date on them, so it's like going to be hard to tell. Because remember, Jackson argued with her to have her change something, and I'm wondering if that's what got changed. Do you guys remember? Okay, let me go back. Yeah, see, that's what I'm thinking too. So now I'm like, wait, am I even looking at the right ones from the first trial? Because there's two sets from the first trial. After AJ argued about it, right? Okay, so then this is all identical. This is all identical. This is identical. This is new. So gray space, yeah, this is, if this is the one that went to the jury room, then yes, 5 is completely new. Guilty of lesser included offense, operating under the influence of liquor. This is all new. This whole number 5 down here. This was not on there last year, at least not on this version that I have, which I struggle with just because I don't think that got changed later. So yeah, gray space. Yeah, you're right. 5 is completely new. Yeah, and Unetti was like, nope. Yeah, okay, so that's interesting. That's an interesting add-on then. Just operating under the influence of liquor, like, just a basic OUI? Like that, how would that be a lesser included of manslaughter? Just a basic OUI? That doesn't make sense, no? It's so they can charge her with something. Like everybody that fucking night needs one then. Like how does that become a lesser of manslaughter though? Like how would that even end up there and not just a completely separate charge? You know what I mean? Travis, where you at? I have a question. I don't understand that. Right, but so then essentially this charge being a lesser of manslaughter still says she hit him. Sure, Gray. Yeah, let me drop. I'll drop you a link. Hold on. Because that doesn't make sense. It's still saying she hit him. Because otherwise it's still a lesser included of manslaughter. And I think the whole point would be that if you're just going to charge her OUI, like straight up OUI, that would be a separate charge. Hey, Gray, thanks for popping up. What are your thoughts here then?
So this charge isn't just manslaughter, right? It's OUI manslaughter.
Yeah.
So I think a lesser included can be anything that's like a subset of the charge. So the first 3 requirements of OUI manslaughter are the requirements of OUI.
Right. So, but that's my thing is, so then how does just basic OUI come in under a manslaughter while operating a motor vehicle?
Under the influence of liquor.
So you're taking off the entire beginning of it, the manslaughter while operating?
Instead of, because like involuntary manslaughter is a lesser of the manslaughter part.
Right.
Motor vehicle homicide under the influence is basically the same as the main charge, except it's negligent instead of with intentional with a high likelihood of whatever.
Yeah.
And then OUI is also just a subset of the top charge, except you take away the manslaughter part and it's just the OUI part.
So like taking away the OUI for manslaughter and then taking away the manslaughter for the OUI?
Yeah, like if you put together 5 and 3, you almost get 1.
Yeah, I see what you're saying. And you put together 5 and 3 and you get 4 just on a lack of intention. Just more of a reckless.
Yeah, well, because 4 is negligent, and the step above negligent is wanton and reckless, which is 3, and the step above wanton and reckless is intend to do an act that has a high likelihood of causing death, which is 2. And then
I still think this should be a separate charge.
I mean, but they would have to like indict her.
I don't think they could, though. I don't think they could because I think it would fall outside the realm of statute of limitations.
That actually might be true. Also, like you would have to like do a probable cause hearing and a bunch of other shit to add a whole charge.
Yeah, I see what you're saying about it being split. Like this is the first part, this is the second part, this is
because all of these are
not. Yeah,
are a set of the or like the same but with a lesser intent requirement.
It still bothers me that it's under a manslaughter charge.
Well, I think that the reason, because I think the defense pushed for this, maybe
they pushed for the lesser included. The Commonwealth didn't. They didn't want it.
Yeah, I think the reason is because there's a lot of talk last year about people being like, I feel like the jury wants to just charge her with something because she was drinking and driving. And so they were afraid last year that they would charge her with like the least included of charge 2 just to be able to say like, oh, she was drinking and driving, except like the maximum for motor vehicle homicides like 15 years. So they want that to be like, they won't.
Regarding your verdict is to count 2.
Sorry, I didn't mean to play that while you were talking.
That's fine. But I think that they wanted that so that the jury wouldn't just find her guilty of something to be like, well, she was drinking and driving. Like now they have an option that, I mean, a first offense OUI is like
a nothing burger.
And her license has already been suspended for 3.5 years. So like, you know, she probably already done the sentence of that.
True. Okay, let me play this real quick. This is from Catastrophe.
So, jurors, we're in receipt of your question. Can we request the cert report detailing the search performed? I take this as a request, and the answer is that you folks, you have all the evidence in the case. So what you have is the evidence in the case. You won't be receiving any additional evidence. But as long as I have you here, I want to clarify my instructions regarding your verdict is to count 2 of the indictment. As I instructed you yesterday, there are 2 lesser offenses of that crime, which are involuntary manslaughter and motor vehicle homicide, felony OUI, liquor, and negligence. Therefore, count 2 encompasses 3 separate charges, the most serious of which is manslaughter while operating a motor vehicle under the influence of liquor. In considering count 2, you should first focus on the crime of manslaughter while operating a motor vehicle under the influence of liquor, and if the Commonwealth has failed to prove that crime beyond a reasonable doubt, then you are to consider the remaining lesser included offenses in descending order. So, the lead charge is manslaughter while operating a motor vehicle under the influence of liquor. If you find that the Commonwealth has proven all 5 elements of this charge beyond a reasonable doubt, then your verdict shall be guilty of manslaughter while operating a motor vehicle under the influence of liquor. If, however, you find that the Commonwealth has not proven all 5 elements of manslaughter while operating a motor vehicle under the influence of liquor, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 3 elements of the lesser included offense of involuntary manslaughter. If the Commonwealth has proven the 3 elements of involuntary manslaughter, then your verdict shall be guilty on the lesser included offense of involuntary manslaughter. If, however, you find the Commonwealth has failed to prove beyond a reasonable doubt the crime of manslaughter while operating a motor vehicle under the influence of liquor and the lesser included offense of involuntary manslaughter, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, felony, OUI, liquor, and negligence. If the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, then your verdict shall be guilty of the lesser included offense of motor vehicle homicide, OUI, liquor, and negligence. If, however, the Commonwealth has failed to prove beyond a reasonable doubt all the elements of manslaughter while operating a motor vehicle under the influence of liquor and has failed to prove all the elements of the lesser included offenses of involuntary manslaughter or motor vehicle homicide, felony, OUI, liquor, and negligence, then your verdict must be not guilty to count 2. So I'm going to send in a new verdict slip on count 2 that's just a little bit different, and we have to sort of change we have to indent something and change the spacing a little bit to make it a little bit clearer for you. Okay, so we'll get that into you in the next 10 minutes. All right, thank you all very much. All right, so jurors.
That was so fast, Catastrophe. Like, I was even fast for me. I was like, holy shit, Bev. Like, good thing it had the subtitles on it, because I was like, that is way too, like, I don't think, I mean, maybe that's my issue, is my brain can't function at 2 times speed after going so slow with listening to the trial. I'm like, holy shit, that was really fast. Okay, so does that help? That was her last year explaining the jury instructions, which is what I was saying this year she should have done when she was giving them the actual jury instructions. But she didn't, because she didn't even have the verdict slip finalized. So now is she going to have to do that again? Because I don't think they understand how to fill it out.
Yeah, did she just leave out the part with the here's how you go through the charges?
She didn't do anything when it came to like how to actually go through like the elements and decide if you cannot find that one, then you go to the next one, and if you cannot find that one, then you go to the next one.
Yeah, I've already forgotten.
I've already forgotten.
I feel like, because like it's blending with last year in my brain, and I'm like, did she say that?
Yeah.
Oh god.
Yeah, I feel you. I feel you. But yes, but you were 100% right. 5 is completely new, but I don't like that it's under the manslaughter. But I guess I see if they're trying to just make it, if they want to find her, because 2 was so up in the air last year, and that's what the jury was hung on, according to the jurors that have come forward. I guess they're like, if they're gonna compromise a verdict, let them compromise on giving her an OUI.
Yeah.
I don't even know how they can prove that, though, because they can't prove the last time she had a drink.
Exactly.
So you can't do that through the extrapolation and say, well, we know she had her last drink at this time. It's like, if even the experts, the criminologist took the stand, or the criminalist took the stand and said, no, we can't. Hold on real quick. Can you talk for just a second, Grace, please? I have a tiny human.
Sure. Yeah, and honestly, the way that hello, the way that Hank handled the part where he was like, well, they say that we don't know when her last drink was, and maybe she drank when she got home and was upset, and there's no proof of that. And I'm like, well, there's no proof that she didn't. So who's got the burden of proof again? Burden shifting motherfucker. What else should I talk about, chat? Yeah, I guess Brennan did have Nagel there after 12:30 in his during trial timeline, but I don't know. In reality, he probably wasn't. So Jackson probably was not focusing on that. My cat. I don't know where my cat even went. He was bugging me earlier, but I gave him some food and now he's probably off sleeping. Oh, hello, Haley. Pyre ran scared from Hank. I mean, he was here for some of that. You're walking your cats? Are they leash trained? I mean, some of my friends have cats that are leash trained, but Pyre was never very into that. One time he did get out for like 2 days, and then after that he never wanted to go outside again. What part of Hank's closing was the worst? Well, he really kind of ended on a dud. Like, of all the things to quote from any of her interviews that you could be like, oh, here's a thing that she said. Like, he was like, oh, he wasn't a buffalo on a prairie. I'm like, that's the quote you picked? It's also, especially because it's like, yeah, no, he's not a buffalo on the prairie. He was just the guy, or a man passed out in the snow. Like, you're talking about Karen dehumanizing John after he died? No, let's talk about the McAlberts in their text thread. Oh, yeah. I've also kind of hated the way that the phone temperature data has been talked about for the entire trial, because I'm like, more could have been done with that. Like, I did some basic math physics with it and found that the data was consistent with what you would expect, how you would expect a phone to cool if it were sitting in an environment that's about 37 degrees Fahrenheit, which could possibly be consistent with an unheated garage when it's like extremely cold out.
Okay, I'm back. Thank you very much. You can keep going, though. I didn't want to interrupt you.
No, I'm just rambling about phone temperature data. But also, Hank used that as such a like gotcha for everything. And I'm like, you don't know what the fuck you're talking about literally at all.
Don't forget about the poll. Yes, thank you. Okay, so I put a poll up about when you guys think the verdict will be in. Well, 31% of you said that you think it's going to be in today. Let me go find, where is Court TV? The jury has been deliberating for an hour and 25 minutes and 30 seconds. I figure they'll go about 2.5 hours today, so I think they got about another hour in them. So 31% think you'll get a verdict today. 44% think Monday, 14 Tuesday, and 11 Wednesday. So I have a question. Those of you who voted Wednesday, are you thinking hung jury, or what are your thoughts on guilt versus not guilty? Because that's a long time. And they deliberated 4 days last year and came out hung on count 2, at least, that we know of.
When did they first send a note saying they were hung?
Oh, before she gave them the...
Because they sent one note and she was like, not enough time, go back. And then they sent another, and then she did the Tui Rodriguez charge. And then sent the last one.
I want to say that was like on a Monday or Tuesday.
Yeah.
And then she made him go back. And then they came back and they were like, no. And she was just like done with it. I don't remember. I mean, I don't remember the timeline of that. I wonder if Sleuthie has that in her spreadsheet. I said Wednesday. I want people to stand their ground. Well, I'm hoping that their ground is all pretty much the same and they don't have to go back and forth on it. I think they've been back there an hour and a half. What do you think they've done so far? Pausing Bob on a cheesy grin. What do you think the jury's done so far? Do you think they did it? You think they did a straw vote, even though she told him she doesn't recommend it?
Probably, at least formally.
I would do it.
Yeah. I mean,
And then say,
probably honestly, they've been
discuss whatever we want to discuss.
they've been sitting there for 8 weeks not talking about it. They're probably like, "Oh my god,
We're ready to just say all the things."
yeah."
I mean, even if they
they're
do a straw vote, like you said, they don't have to. It doesn't have to be concrete. They can still be like, "Let's just see where everybody's head is, and then we can go. All right, let's go through whatever we want to go through to confirm even if we all agree, we can confirm what we're thinking on whatever count we're agreeing on, and then we can go through what we don't agree on."
Yeah, it's going to take them 2 hours to decipher all the sub counts of count 2.
Yeah, that's the only reason I don't think today. I think it just because of the documentation and everything that they have to look at. I just figured that at least Monday. But then, there could be a very much like, we don't want to come back next week. We do all already agree that none of this ever fucking happened, or we agree that she absolutely did this. You know what I mean? Like, they could right off the bat just agree and just be like, yeah, we're done. We don't want to do it.
That's true. They could. I do feel like people feel bad coming back with an acquittal on like a murder case real fast.
You feel bad?
No, I think people feel bad.
Oh, so you think that they would wait, like Indiana Girls saying, like, even if they've decided, they're going to wait just because they'll feel bad about it?
Possibly.
I don't know. If you come back with a not guilty, you just don't. That means the Commonwealth should feel bad.
That's true. I mean, they should feel bad.
They should feel bad anyway because they suck. This is gonna sound so bad, but I can't wait for a not guilty just so Lolly gets some vindication in his life.
Honestly, yeah. Though Lally's kind of back at the top of, or near the top of my shit list after his argument yesterday about Hank and the fucking sweatshirt.
Oh yeah. And then today when he was like, "That's garbage." Yeah, I agree. That's garbage. They shouldn't be able to do any of that.
Yeah. Lally was like, "Oh, but like other stuff like this has happened before and there hasn't been a curative instruction." I'm like, "Oh, you mean the inverted video or what?"
Yeah. Let's see. Oh, that's Court TV is just still talking about jury instructions. All right, I'm gonna go back and listen to Bob. You could stay up here if you want to, or you can hop down, whatever you want to do.
Okay, I'll probably hang out.
Okay, sounds good.
Done that.
And he couches it in the terms like he's like, y'all can laugh about him and his, his little LinkedIn not being updated. And like, no, the fucking guy lied flat
He
out.
made up a degree that does not exist. Yes. Nobody else could have done that.
And he couches it in the terms like he's like,
we've all been there.
If they can't attack the data, they attack the person. And then what does he do? He goes and he attacks Arca. Like, no, he didn't challenge personally. He attacked them, saying, they're biased, they're using signal, and doesn't address any of the science. Any of it.
He spent more time talking about Uber rides, signal, deleted text, and ham sandwiches than he did in explaining why the taillight, in his view, could not have been planted.
Right.
That's shocking to me.
He had zero answers. That's why, like, we can't sit here stunned, but because we know what the answer as to why he didn't do it. He didn't have a response.
That would result in added that the criminal person. Now, the second indictment is the indictment charging manslaughter while operating a motor vehicle under the influence of liquor. And there are lesser included offenses
First of all, there's a live shot, and we just saw Karen Reed returning inside the courthouse, Michael. We don't know yet why. We'll certainly report on that. There goes the team as well. Second of all, I have to say this to you because you and I were just talking about the evidence and where you fell in this. And to me, this is such a perfect behind-the-scenes illustration of the importance of closing arguments. Because before
Come at me.
The Karen Reed murder retrial on Court TV.
Tonight on Closing Arguments, it's been the murder retrial of the century. We break down today's
I'm over here just talking on fucking mute and just saying all kinds of like really philosophical crap, and nobody can hear me. And it was probably the best things I've ever said, most intellectual conversation ever, and now I can't repeat it. I know, I hate that. No, I was saying I don't know why. So maybe a jury question, but I mean that's it's still really fast for a jury question, in my opinion.
closing arguments.
I do think that Bev said something about asking the jurors if they want to go home or keep deliberating at the end of the day.
Yeah, it's live. It's live right now, Mav.
So
but so okay, so it's 4:15 there. She said she was going to have them there till 5, and then they could stay later. So now maybe they never decided they were going to stay after 5.
well, I thought the latest they were going to stay was like 5 or 5:30.
Yeah, it's only 4:15.
Yeah. Maybe the jury wants to go home.
Yeah, with a jury question. What the fuck does that form mean? Let me check Twitter.
Hi, Judgy.
See about the peeps that are there. Where in the world is my Twitter? I mean, it's interesting. I don't know why they'd be going back to court right now, unless they're going home. And I don't know how they'd already have a question. Unless she's calling them back and saying, okay, let me explain this verdict slip to you like I had to do last year because I didn't bother to take care of this beforehand.
Yeah. I mean, there's plenty of things it could be.
Trying to find somebody who's actually still there. I don't see. Sue isn't saying anything. Aiden's not saying anything. I don't see anybody saying anything.
Yeah.
They're not deliberating over the weekend. No, nobody talked about it. Nobody's there. I can't find anybody there that knows what's going on. If you guys find something, let me know. Somebody asked, oh, Lacey, what about the pink shirts? So they can't wear anything that has like free Karen Reed or in support of Karen Reed or anything like that. So last year they all made the decision to wear pink, and the pink would be in support of her. Okay.
Yeah. Verdict watch. What do you like to do?
Not much you can do but try to occupy your mind.
How do you feel that it's almost over?
Is it familiar?
Anything to say to your supporters?
Thank you. I love them.
What do you say to the supporters?
Thank you.
This is when they were just walking back in.
Yeah.
All right. See you.
Okay.
So that was just moments ago as Karen Reed returned to the courthouse there in Dedham, Massachusetts, because, of course, we are on verdict watch in that courtroom where a jury is now deliberating the fate of defendant Karen Reed.
And prosecutors have accused the former adjunct professor of striking her boyfriend, John O'Keefe, with her SUV while driving in reverse and then leaving him to die outside a home in Canton, Massachusetts.
Of course, Reed insists that she is innocent and has pleaded not guilty to multiple charges, including second-degree murder. She claims to be the target of a vast police cover-up. All right. So here we are. We're waiting to find out what's exactly going on in the courtroom. As I just mentioned, there you see Karen Reed. That's just moments ago as she was returning to the courtroom. And you see Matt there following behind, asking her questions. We're waiting to find out why she was called back to the courtroom. We can speculate, but we won't do that right now. The jury clock is still going at 1 hour, 38 minutes, and 20 seconds.
Although I will say, we've talked about it would be very unusual given the amount of evidence, the length of the jury instructions, the magnitude of this case, how long they've been in trial, that this is a verdict. We don't anticipate at this point it's going to be a verdict. Now, we just need to comment that the jurors are not expected to deliberate over the weekend. They are not sequestered. These are things the court has to decide, has already decided. So that does mean once they go home for the day that they would then come back on Monday to continue their deliberations.
Yeah, and it's be perfectly understandable if they decided that they didn't want to continue today because they weren't going to come to a conclusion today. I think that's pretty clear. And they said, hey, you know what? We'll go home today. It's been a long day. We heard all these closing arguments. We'll go home, come back with fresh minds on Monday morning.
Yeah, they've got to be exhausted. What was it, 31 days? I don't want to misquote. I don't have that note in front of me, but I believe it was 31 days of testimony that they heard. That's a very long trial for any juror, and they're exhausted. Now, the other thing I wanted to ask you about, Michael, was I felt like watching Karen Reed's demeanor during the closing arguments, I just felt like she had the weight of the world on her shoulders and appeared differently than she did through the trial.
And no question about it. Today, well, not today, but ultimately either Monday or Tuesday going into next week, her life is going to change.
Yeah.
It's either going to change in a good way because this will be off her shoulders with a not guilty verdict, or she'll be found guilty of something and find herself going to prison on some level.
Or it could be a hung jury, and good Lord, that means it's still out there.
Well,
and we'd have to figure out what happens.
Do you think at this point, after 2 tries, if there's another hung jury, this prosecution will go after her again?
I don't know. Let's find out from our guest. Joining us now, defense attorney, former head prosecutor Bob Bianchi, and former head prosecutor. It begs the question, if there is a hung jury on any of the 3 charges.
All right, I'm going to stick over here on Court TV just so we can find out what's going on in the actual courthouse. So I'm going to stay here for now. So we'll just listen to whoever this guy is.
And then lessers too. Would you try this case again?
To look at things differently. One, the evidence in this case, to me, even if I believe the person is guilty, was so convoluted, confusing. We had so many issues with the way the investigation took place. If I never was in this position, but 2 cases that a jury could not come to a conclusion of guilt beyond a reasonable doubt, I personally, on a case like this, would not go forward a 3rd time. I know that I would share a minority view here, and that another school of thought would be, if I believe she's guilty, try again until you get the conviction. And that's valid too. It's just that for me personally, I've got so many problems with the way this case was investigated that I'm queasy about it, just generally speaking.
You know, and folks, we're just standing by to find out what's going on. As you saw there, that was just moments ago when Karen Reed was returning to the courtroom. As soon as we find out what's going on or have an opportunity to take you there, we will do that. Bob, one of the other considerations as a former prosecutor, you tell me, is the amount of money that a county or whatever is willing to spend on a case. What we know is that a lot of money, maybe close to $500,000 was spent just on experts this go around by prosecutors. Does that factor into a decision to say, okay, we're going to go back and do this again?
No, I don't think it factors in at all. You know, we're government officials. It's funny money. It's taxpayer money, right? So that's one of the advantages a prosecutor has, and it's a tremendous advantage. Not only do you have an incredible amount of power, an incredible amount of discretion that is in the hands of a good prosecutor, a good thing, in the hands of a bad prosecutor, not a good thing, but you do have, quote unquote, unlimited. Now, they're not unlimited resources. But again, if I really believe the person was guilty of an offense, if it took me 3 times and $1.5 million, $2 million, in order to bring justice to the victim and justice to the victim's family, there really would be no cost. That would not enter my lexicon, my equation at all, in the least.
Fair enough. Judge, do you think, now, as a, you know, I'm more sort of a criminal defense attorney, so, you know, when we start talking about 3 times, 4 times, 5 times retrying someone, I wonder if you feel like maybe there should be some limit as to how many times someone could be retried.
I think so personally, but there is a way to accomplish that limit. The judge, we looked this up together, and the law in the state has the ability to dismiss either with or without prejudice, meaning it can be brought again or not, new charges. So the reality is the judge has a say in it, and she may step in and say, no, thank you, we're not doing it again. Bob Bianchi, I don't know if you had a chance to watch closing arguments. Of course, the defense went first, followed by the Commonwealth. And if you want to watch great attorneys, to me, you watch this trial because they're very good attorneys. They know what they're doing. And I felt like the Commonwealth really stuck to the data, the science. They really said, listen, the defense experts didn't have any science. And the defense leaned into Proctor and the investigation and some of the emotional pieces of it I thought that they brought out. How much does this affect a jury if it does the closing arguments?
I think closing arguments affect the jury tremendously. I believe opening statements are more persuasive in my mind, however, than closings. But closings, look, when you try a case, at least when I train people on how to try a case, whether you're a defense lawyer or prosecutor, I say you need to go to what you want to say in summation. Because as you know, you can only comment on the evidence that was adduced during the course of the trial and reasonable inferences drawn from that evidence. Once I know, like I'm preparing a homicide case right now. Now I know what I want to be able to say to that jury. I map that out first, and then I back my way into the witnesses and the evidence that I'm going to need to make sure that
Okay, so Aiden posted on Twitter and said that they're back in the courthouse. They're not sure what they're in the courthouse for, but he's told it is not a verdict. He said the that's it. That's all he said so far. So
I have it first. So look, I mean, emotions are important. The defense only has to play to one juror. Of course, they want an outright acquittal, but they want to be able to get to that one person. So they're going to be more in that emotional space. It sounds like I didn't see the openings here, where the prosecutors always want to be more methodical. The prosecutors don't want to work so much on emotion. They want to work on hardcore, solid evidence that's going to convince that jury beyond a reasonable doubt in a dispassionate way. Last point. Once a jury feels that the prosecutor is overly invested emotionally in the case, then there could be something where the jurors say, I don't know whether I trust this prosecutor. That's why prosecutor summations and defense are always so different.
Yeah, I think it's fair to say that the prosecution in this case took that methodical approach, the more scientific approach this time. All right, Bob, stand by. Folks, we're standing by to figure out what exactly is going on in the courtroom. We showed you about 10 minutes ago, Karen Reed returned to the courthouse. So what we'll do here, we'll take a break. And coming up, Court TV's Matt Johnson will join us live from outside that courthouse with all the latest. So keep it here on Court TV.
okay, I just muted it. It's still I think it has to do with the new forms, the new instructions. Well, I mean, you can't really change the instructions. You can just give them to him, but she would just give them to the bailiff who'd give them to the instructions that without, with fixing the typos. I'm just trying to see if anybody else on Twitter has any update. He said, it's weird seeing 12 jurors sitting down instead of 18, looking at this jury of 7 men and 5 women. I just can't see this jury coming back with anything but a not guilty verdict.
Did the Court TV people say that the Commonwealth is taking a more scientific approach this time? Did I hear that?
I don't know if they said that. I missed it because I would have laughed. Seems like it might be a jury question. They're sitting on the same seats as they were. This is from Sue. Jurors released for the day. They are sitting in the same seats as they were, surrounded by empty seats. The alternates stand behind them. Court is dismissed. Judge says she hopes everyone has a good weekend with no work. So there you have it.
I guess we're done for the day.
Yep. Seven men, 5 women. Where did you see that, Joanna, that the jury has a question? I'm seeing that they are released for the day and they want to go home. I'm looking to see if anybody else has said. Aiden says same thing. The jury has been adjourned for the day. We will continue deliberations on Monday. See you then. So that's it, folks. That is all she wrote. Karen Reed updates. Yeah, I don't know. Multiple people in there are saying the jury's gone for the day. So they'll be back. Maybe that was the question. The question was, can we fucking leave? We're done. Can we go home? We'll take the weekend. We'll think about it.
Yeah. I mean, I guess if it's like we're not going to come to a decision today because we have to have an argument, we might as well start it at the beginning of the week instead of right now.
Damn. All right, then. Well, what else should we just come back Monday? What time should we start? Are they coming back at 9? Is the jury coming in at 9 on Monday?
Presumably.
Yeah, that's what I'm thinking. So I guess I'll stick with the 7. I don't think they're going to have an hour. I don't think they're going to have a verdict in an hour.
No.
So I think I'll start probably about 7 Monday.
Well, I'm hoping to be in Dedham on Monday.
Are you?
I think so. I'm probably going to drive up to my friend's house in Albany on Sunday and then over to Dedham Monday morning.
Are you gonna go hang out there?
Yeah.
You gonna hop on it so you can show us your camera?
Yeah, I'll do that.
Now we're going to go back into the courtroom in Dedham, Massachusetts to see what happens. The jury's been deliberating for an hour and 47 minutes approximately. So we're going to see.
Yep. Jurors, I understand you want to go home. It's been a long day for us. We appreciate everything you've done today. I do have to tell you those same cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. Do not talk to anyone, and that includes each other. So when you walk out the deliberation door, you have to stop talking about this case. Even when you come into the courtroom, don't mutter anything to each other, certainly not on the ride or anything like that. So it's very important that you remember that. And you cannot, even if you get here before you're called into court on Monday, you can't discuss the case then either. And that goes for the alternates as well. So we really appreciate that. Watch your social media use and the papers and the news. Stay away from all of that if you can this weekend. We'll see you Monday morning ready to start up fresh.
I mean, we could say that there might have been a disagreement. We don't really know. They could have just been like, you know what, this is a lot of shit to read and go through. Let's take a vote on who wants to just go home for the weekend and start fresh Monday, when we can just come in here and just, start reading through everything we need to read through. I kind of feel like that might be it too. Like we're done for the day. Let's just go think on it and come back Monday. Or they could have done a straw poll and been like, you know what? we're not going to agree here. So I just don't think they would have. I don't think they would have gotten through it all yet. I don't know, unless they did the straw vote. That's it.
Yeah. I suspect also they probably looked at those jury instructions and were like, I don't want to figure this out right now.
Yeah, it's Friday. Let's just go home, be with our families for the weekend. It's Father's Day weekend. You got 7 dudes on there. They're all young, so maybe they don't have kids yet, but still. Leave your phone on so if they come early, we can reach you. Do a Brian Albert and sleep with your phone. Okay, I will do that. So then that way, but I'll set it for 7. Like I said, I mean, it takes them forever to get in. Get everything set up anyway. I think I'll just set it for 7 and kind of just play it by ear.
Make sure not to accidentally butt dial anyone, though.
Right. All right. So just a heads up for anybody here who does follow the Delphi case. I do have the quote for the transcripts. I think I've shared that with you guys. It's $4,600. It'll take care of all the trial transcripts plus all the missing transcripts from the 3-day hearing. We do have a fundraiser going, All Eyes, and a few of us have been kind of working behind the scenes to do like a fun, more of a fun, like live to kind of just, hang out, talk Delphi and raise some money, but it has already been spread across like Twitter. And I think currently, let me look, out of the 4,600, we are at 1,460. That is like real time, unless somebody sent me something while I was live in the last couple of hours. So 1,460 as of right now of the 4,600. So if you guys are wanting to contribute, like by all means, please, any help is appreciated. She has until July 9th. That's Jody, the court reporter who put the transcripts together. They are currently done, but being reviewed, and then anything that needs to be fixed is being fixed. She will post that they are being sent to the appellate court, appellate attorneys, not appellate court, but appellate attorneys by July 9th. And then as soon as she does that, then I will send her a cashier's check, and she will email me all of the transcripts. So just want to give you guys the heads up. She has until July 9th to do it, but essentially we have to pay her the day that she posts on the docket. So if you see it on the docket that says that is it has been sent to the appellate attorneys, that means that I can send the money order, overnight it, she gets it the next day, and then I get the transcripts and we can do our lovely read-throughs. And just an FYI for anybody who is wondering, I've been tracking all the donations, so if there's ever a question about who's donated what or anything like that, I don't thank anybody publicly because I don't know if you guys even want your names out there publicly. So if you have contributed already, a huge thank you. I mean, we're not going to be able to do it without you guys. I can't do 4,600 on my own, by any means. So when we do get the transcripts, they are going to be public. They're not going to be watermarked because if they're purchased by you guys, then there's no watermark on them. I only watermark what I purchase myself. Other than that, they're going to be public documents. Anybody will have them. So I know that some people are like, watermark them anyway. I won't do that. They will not be watermarked. They will be public. I do not want to pay. And even people I don't care for, I do not want them to pay more money to Carroll County than Carroll County deserves. So I want they can get paid one time, and that would be, best case scenario. If somebody else chooses to continue to pay them anyway, that's on them. But these will be public for anybody to see, use, read, whatever. They will just be put into a Google Drive and put out into the universe. And I just want everybody to know that. So if you donate, know that you're donating for them to be public for everybody so that Carroll County does not continue to get more money from us. 4,600 is already a huge chunk of fucking change for a transcript that, mind you, is not being printed. It's not being handed to me. I'm literally going to pay 4,600 for somebody to send me an email. So just think about that for a hot minute. And I don't think people need to overly pay Carroll County to do that. So if you want to contribute, it's my Cash App, it's my PayPal. It's all being put into one account. It's a separate account I don't use for personal reasons. It's only for, I had it as a separate savings account that I just stopped using. So at this point, I've only used it for transcripts. That's what is all just sitting in there, so it's not going to me. It's not. If you want to Cash App me, then tell me it's for me. If you want, or PayPal or whatever. If you are doing it for transcripts, please put transcripts in them. So just an FYI, they will not be watermarked. People have asked me to watermark them. I will not be watermarking them. I do not want Carroll County to get any more money than they deserve. That's it. That's my bottom line. So if you contribute, know that everybody's going to have access to them.
Hell yeah.
And if you do want like me to thank you publicly, I absolutely will. Just know I intentionally don't, because I don't know who does and who doesn't. And I don't want anybody to be like, oh, shit, my husband was listening to you and now I sent you $100. And now he's like, how the hell did you send her $100? I don't want any of that. I don't want to be responsible for it. So if somebody else throws a watermark on it, then they throw a watermark on it. I can't stop it, but at least nobody will have to use theirs with a watermark, because there will be a very clean copy for everybody to have. So, and I'll grab my link tree for you guys. It's you can do my Cash App, my PayPal, my Venmo. You can even throw it in a Buy Me. I think I have it in there, Buy Me a Dr. Pepper. It's like I said, it's all, if it says transcripts on it, it's being transferred to one individual account that I've been tracking on a spreadsheet. So if there's ever any questions that anybody has and things like maybe their donation wasn't counted, or there should be more money, or there should be less money, or whatever, like it's all there. I'm trying to do my best to document everything. I don't ever want anybody to think like I'm trying to take money for whatever, you know? So, and then every day on Twitter, I have posted an update. So for how much comes in like the day before, I add it, and it's like a little thermometer thingy. So I make a little graphic and put that on Twitter so that everybody knows daily like where we're at. So yesterday was day 3. We're on day 4. I gave you real time, so tomorrow may look very similar to what I just said. My link tree. Like I said, if you're donating for transcripts, just throw transcripts in the comments section of any app you use to donate. The best is Cash App or Venmo, because they don't take money. PayPal does take a chunk of it unless you do it friends and family, which a lot of people don't like to do. So if you're sending me like $20, know that I'm getting like 18 of it. So you did, Chelsea. I got yours. Yours is actually part of, yours is already added into the 1460, the current real-time amount. But that's my link tree. It's got all my links in it. PayPal is the hardest one. They do take the funds, but I've been putting in there the funds that you send, and I'll just make up the deduction of whatever it is, because I think that's the right thing to do, because you guys are still contributing that amount of money, even if PayPal takes it. Facebook Pay, I don't have that in my link tree, but I mean, you guys, if you want to do Facebook Pay, like Messenger Pay, I mean, that's fine too. Like I said, as long as there's a note that says it's for transcripts, I will transfer it into the transcript account. So friends and family does not take a cut, no. But you have, people won't use friends and family all the time because you have no, on PayPal, there's no, what do you call it, like payment security or whatever. So like if they want, you know, if you want to dispute it with PayPal, you can't dispute like friends and family, but it doesn't take a cut of it. It just is, you know, a flat rate. It is the entire Delphi trial plus the transcripts of the 3-day hearing that I'm missing. So that's what we should be getting with the, and she said approximately 4,600. So if it comes out to be like 4,650 or something like that, it is what it is. I'm not gonna like get mad at her. It just, so she said in the email it's approximately 4,600. I'll read you guys the email so that you guys know. I've also posted this so that I'm trying to do everything I can with like absolute transparency. So if there's something else you guys require of me to be transparent for you, please let me know, because I'm doing everything I can think of on my own. So Jody said the transcript will include all hearings requested in the notice of appeal, including the motions hearings from July, August of 2024. At present, I anticipate it will be approximately $4,600, which is 4,600 pages times $1 per page copy fee. The policy continues to stand that I will, because she could email it. She could print them and email them to me if that's what I wanted. I don't want that. So I don't, her and I have communicated about transcripts obviously a lot. So she kind of already knows that. And she knows where I live and versus where she lives. So she said the policy continues to stand, because I did ask, because we used to have somebody who lived nearby, a friend of the channel, that would go in and hand her, I would Venmo her the money. She would walk it in as cash, and then like Jody would hand her the transcripts. About a year or so ago, somebody went in there, caused a scene, and she messaged me and she said that my person was no longer going to be able to come in and do that after what had happened. She did not tell me what happened, so I can't tell you what happened. So I'd asked her, is that still the policy that nobody can come in? And so she responded with that too. She said the policy continues to stand that I will do no more business in regards to this case in person. In regards to this case, based on the length of the transcript, I will transmit it via email. I would ask that you send no money until the transcript has been filed with the clerk. So wait until it's filed. Well, because it can be because she would print them for me. She would print them and mail them to me. So I think that's how they're doing it. But I'm not going to argue. I just want the transcripts. I don't want to fight with anybody about it. I just want the transcripts. I want them free for the world to have, and that's it. Like, that's where we're at with it. Like, let's buy them one time, put them out in the world, and then they're there forever. But she won't. Yes, she will not give the transcripts to anybody now. So that's kind of where we're at. So we're gonna pay the $4,600. I requested them immediately after trial was done. So I mean, we're on board. I'm on board with whatever she's got going on right now. I'm not setting up a fight with Jody. I just want the damn transcripts, and I want to let the rest of it go. That's where I'm at. So if you're in disagreement with that, then you don't have to contribute. Just letting you know where I stand. I'm not gonna argue back and forth to get a reduction in rate or anything. It is what it is. Yes, Judge Jessica. Right. No, but Judge Goal, I think, does, and the situation occurred with Judge Goal, I believe. And Jody. Yeah, you can fight with Jody after we get the transcripts. Unless she's the court clerk for trial number 2. Then we probably don't want to do that either. I'm not about burning bridges here. I just want the info. So, all right. So that is that. I just wanted to give you guys an update on that. I will do my best to try to update that throughout the weekend too. So, is there anything else, Gray Space, that I have missed?
Not that I know of.
Okay. I think we've covered all of it. Thank you for coming up and helping with the figuring all the ins and outs of the verdict slip. I appreciate that.
You're welcome. I've thought about this too much.
I'm ready for this to be done. I'm so ready for this to be done. Can we just send the money to RA's new counsel for the transcripts instead of Jody? I have no communication with the attorneys to be able to say that they would even do that. That's why I said at this rate, I just want to pay her, get them, and be done with it. Yeah, the dog is not happy that I'm paying for any transcripts. That's for sure, Travis. 100%. Hold on real quick, you guys. Okay. All right. I'm going to wrap it up. We'll be back Monday. I will do around 7 and 7 a.m. my time, which is 8 Mountain, 9 Central, 10 Eastern. And once again, I know you guys have 1,000 other places that you can hang out and watch this trial and verdict watch, and I'm so happy that you guys hang out with me. Hopefully, Gray Space will be able to pop up with us on Monday and show us kind of around the area with a first-person point of view. So that would be amazing. So I hope that you're able
to. Make sure to get a new battery pack because I lost my last one or battery. And so I should be ready to jump on stream from boots on the ground perspective.
Perfect. All right, you guys. Again, Gray Space, thank you so much. Sleuthie, I know you're out there doing your thing with your fam. Love you to pieces for being here every day with me. I hope you're having fun. and that it's not too hot. Other than that, I will see you guys on Monday. If anything pops off over the weekend, maybe I'll pop on and try to do something if I have time. Other than that, love you guys, and as Sleuthie would say, love you, bye.
Do you dare to follow me down? Head into the unknown. Down the rabbit hole. Where it stops, no one